Please take your seats. The meeting is about to begin. Remember to speak into the microphone, as this meeting is being recorded for public record. Please stand by. We are going on air in 5, 4, 3, 2, 1.
Okay, good morning, everyone. Welcome to the November 26th Planning Board meeting, and wishing everyone a happy Thanksgiving week. Just a couple of items. Just some minor changes in the agenda. We're going to move the discussion item on loading truck sizes and safety to next month, and we're just going to reverse items 9 and 10 because of a request from some attorneys that need to get out of here. So number 10 will be 9, number 9 will be 10. With that, can I just get a motion to approve the minutes from last meeting?
Motion to approve.
You get a second?
I'll second.
Okay, all in favor?
Aye.
Anyone opposed? Okay, great. City Attorney?
Thank you, Mr. Chairman. Good morning, members of the board. Today's meeting of the Planning Board will be conducted in a hybrid format with the board physically present in the commission chambers at Miami Beach City Hall, and applicant, staff, and members of the public appearing either in person or virtually via Zoom. To participate virtually, the public may dial 1-877-853-5257 and enter the webinar ID, which is 861-4342-6327#, or log into the Zoom app and enter the webinar ID, which again is 861-4342-6327. Anyone wishing to speak on an item must click the raise hand icon in the Zoom app or dial *9 if you are participating by phone. If you're appearing on behalf of a business, a corporation, or another person, you need to register as a lobbyist with the City Clerk's office. If you haven't registered yet, you should register before you speak to the board. You don't have to register as a lobbyist if you're speaking only on behalf of yourself and not any other party, or if you're testifying as an expert witness, providing only scientific, technical, or other specialized information or testimony in this public meeting, or if you're appearing as a representative of a neighborhood association without any compensation or reimbursement for your appearance, to express support of or opposition to any item. Expert witnesses and representatives of neighborhood associations shall, prior to appearing, disclose in writing to the city clerk their name, address, and the principal on whose behalf they are communicating. If you're an architect, attorney, or employee representing an applicant or an objector, you must register as a lobbyist. These rules apply whether you're appearing in favor of or against an item, or encouraging or arguing against its passage, defeat, modification, or continuance. And lastly, Mr. Chairman, I'd like to swear in any members of the public or staff who will be testifying today. Please raise your right hands. Do you swear or affirm that the testimony you'll give in this proceeding is the truth, the whole truth, and nothing but the truth? Thank you.
Thank you. The other thing I wanted to point out is that items 15 and 16, which deal with the North Beach Oceanfront Overlay and Development Regulations, are going to be heard at 11 o'clock time certain. Okay, real quick, let's just get to the motions for continuance. First item is Planning Board File 230625, 1509, 1515 Washington Avenue, and 1500 Collins Avenue, New Hotel.
So I believe the applicant is here and they're requesting a continuance of this till the January 7th meeting. Is the applicant here for the 1509 to 1515 Washington Avenue?
Good morning, Mr. Chairman, board and staff. Michael Larkin, 200 South Biscayne Boulevard, here representing the applicant. We simply request a continuance of the January hearing. We had issues getting through the Transportation Department review process, but that has concluded yesterday. So now we'd like to appear for you all in January.
Okay, anyone here to speak on this other than the attorney? Anyone on Zoom?
And there's nobody on Zoom with their hand raised?
Okay, go ahead, Matt.
Yeah, Michael, just one question for you. Did you have an opportunity to reach out to any of the neighbors or anyone else that expressed any concerns at the hearing last spring?
No, have not done that yet. I'll have to look at that video and see. But our immediate neighbors, would be Club Madonna to the north, a nightclub to the south. We almost go all the way to Collins. Now we do go to Collins now, in fact, with Joinder of Haddon Hall. But I will review the video with Emily, and I'll see what neighbors we can reach out to.
Okay, appreciate it. Thank you.
Mm-hmm.
Okay, can we just by acclamation?
We do need a motion and a second on that
Okay,
continuance.
so we'll move to January.
I'll move it.
Second. Matt, and Yehiel, second. All in
All in
favor? Anyone opposed? Okay, move to January. Thanks, Michael.
you.
Next is Planning Board File BB 240662, conditional use regulations for grocery and convenience stores in CD3 zoning on Lincoln.
I don't see the applicant here, but I know that they're requesting a continuance till the January 7th meeting. So unless there's any public comment on this item, I would suggest the board,
Anyone here on this item? Anyone on Zoom?
nobody on Zoom,
Okay, someone want to move it, to what month?
to next month, January 7th.
Okay,
Motion to move.
okay, we got a first, can I get a second? Okay, all in favor?
Aye.
Anyone opposed? Okay, January is there no meeting in December?
That's correct. There is no meeting in December. The December
Right.
19th meeting was canceled because we have the January meeting just 2 weeks later, so.
Okay, makes sense. All right, next, Planning Board File 230609, 1750 Alton Road, the Palomar Hotel. Oh,
Good
sorry.
morning, Mr. Chair, members of the board. Here on behalf of Palomar Hotel, we've asked for continuances before. This time, we're just going to ask to February. Our client, as you all know, Morini was their tenant. They were going to be the rooftop restaurant operator. That operation went away. They've been very close to finalizing a deal with what's going to be a fantastic restaurant. They're days away, but they're not there yet. So we're asking not just January, but February, so that we can get that tenant signed up, submit the city the operational plan menu and all those items, so that you could have a full application before you. So we're asking for continuance to February meeting.
To when? February.
And that would
Okay.
be the February 4th meeting.
Okay, anyone here to speak on this item?
We do have somebody with their hand raised online, Sarah De Los Reyes.
Sarah? Were you sworn
Hi,
in?
I just have a question. How many times can somebody postpone continuance indefinitely?
No, so the continuance request can happen no more than 120 days since it was publicly advertised. So if it's going to be longer than 120 days, they would have to renotice the application.
Okay, I just wanted to find out that. Okay, thank you.
So,
Anyone
Michael, how many days has it been?
Actually, so if they continue it till February, you would have to renotice it.
Okay.
You okay with that?
Yeah.
Because the last time it was actually advertised for the September meeting, so moving it to February would be more than 120 days. So we'll re-advertise for the February 4th meeting.
All right, it's obviously you can work out with the new tenant, okay, that's
Yeah.
reasonable,
Yeah.
okay. Can I get a motion to move it to, February?
Motion to continue to February.
Okay,
I'll second.
okay, Elizabeth, all in favor? Anyone opposed? Okay, thank you, Mick. All right, the next is Planning Board File 220539, 660 Washington Avenue, the Anglers Hotel.
Me again. Good morning again, Mr. Chair, members of the board, here on behalf of the anglers. Different reason, we've been working with the association to our immediate west, spoken to the client. They did some testing with them on sound. They've asked for some additional testing. We've agreed to do that additional testing. It's going to take a little more time. So also requesting for a February continuance here.
We'll have to re-advertise that as well. You
Anyone?
have a public comment online.
do or
Johan
don't?
Moore? We do. Johan Moore?
Yes, good morning. I don't know if I need to be sworn in as last time, otherwise I can consider myself sworn in. I want to emphasize the nearest neighbor's opposition to granting a rooftop entertainment CUP, but also to encourage the anglers in pursuing the possibility of residential conversion. Thank you.
Anybody else?
There's nobody else.
Anyone in
online?
chambers on this item? Okay, and you want to move it to, you said February again?
That's correct.
Okay,
Motion to continue to February.
Second.
okay, all in favor?
Aye.
Anyone opposed? Okay, it's so moved. The next, I guess if the application is withdrawn, do we have to do anything?
Yeah, we'll just, the board doesn't have to take any action. We just want to notify for the record
Okay,
that the next two items are PB 24-0650 and PB 24-0651. These relate to development regulations, creating the Normandy Isles Overlay District for CD1 zone properties, and the Workforce Housing Comprehensive Plan Amendment, PB 24-0651. Both of these applications have been withdrawn, so no action is required by the board.
Why did they withdraw it?
The owner is going to explore a live local application.
Got it.
Okay, next up, revocation modification hearings. Item new number 9, Planning Board File 210442, 743 Washington Avenue, the Von Dome.
So I believe we have a court reporter here who wanted to place some, no, okay, we don't need the mic, so I'll just give an overview of our staff report on this item. So this was
Did you
last.
say there's a court reporter here?
There is a court reporter here,
Where?
but he initially wanted to place some mics up here, but he no longer needs to place the mics up front. So I just wanted to.
Where is the court report? Oh, there he is. Okay, great, thanks.
So this application for revocation modification hearing was before the board on September 24th. At that time, the board did discuss the operation and approved some modification to the CUP and continued the modification hearing to a date certain of today. Now, since the September 24th meeting, there was a queuing violation that occurred in the properties noted in page 5 of the staff report. This related to patrons obstructing or obscuring the sidewalk on, just a correction on the date, it was Halloween evening, the night of Halloween. So in terms of our recommendation, considering the latest violations for queuing on the property and the prior history of these violations, staff is recommending that the CUP be suspended for 180 days. We do believe that the queuing plan presented by the applicant is clearly not working, and the limited queuing area previously identified is not sufficient on the property. So we are recommending that the applicant provide detailed plans of the entire establishment and identify a much larger area for queuing to occur within the building itself. The applicant's going to be providing a presentation, and you can see from that presentation, there's very little area within the building for queuing. Most of the establishment is a large, expansive area for the nightclub, and there's limited queuing area on the public right-of-way. So we believe that it is warranted to suspend the CUP so that the applicant can modify their interior plans and provide a larger area for queuing within the building. We are recommending that the board modify the CUP to require this updated security plan and queuing plan, which is to be approved by the board prior to future opening. We are recommending that the board include a prohibition of special event permits or promoted events of any kind. With that, I'll turn it over to the applicant for their presentation.
Good morning again. If I could have the presentation that we submitted put up on the screen, thank you. So Mickey Moreira again, law firm Burke, Howardell, Fernandez, Larkin, Tappan is at 200 South Biscayne Boulevard. With me today, in addition to the Vendome team, which is sitting behind me, we have my co-counsel Michael Larkin and our co-counsel Robert Zarco and Jackie Beta from Zarco Einhorn. Here today, and I will tell you to start preparing for this hearing has been one of the more bizarre preparations I've had to do for one of these things, but you'll see why in a minute. So again, this is Vendome. I'm going to tell you a little bit of the history very quickly because I think you've heard it all before. Property is at 743 Washington Avenue. It was previously, it is zoned CD2. It was previously a club called Rockwell that had been open since 2012. It obtained CUP 12 years ago. About in 2021, they closed their operation down. The space essentially remained the same. The improvements were mostly the same, some aesthetic changes to the interior, but our clients came in, and it was closed during the pandemic. Our clients came in to take over the space. We worked with them at the time to modify their Board of Adjustment order, their planning board order, to bring in new ownership, and they've been operating successfully since that time. This is the queuing plan that we submitted prior to the September hearing. We believe it provides a significant improvement to what the operations before, and frankly, we believe it's been working very well. We'll explain that in more detail in a second. Here's the plan, and I will tell you towards the end of my presentation that we would always be willing, even if something works, things can always be modified, things can always be improved. So our client's open to modifying the queuing plan in a way that works better. I believe it's working well right now, but I think everything can always be improved, even the best things. So we're open to working with the city. We've already got drawings that change things a little bit, but we certainly don't want to be doing that under the conditions of the club being suspended, because suspension of this CUP is effectively closing this business down. So here is Vendome, and the reason I believe this queuing plan has been working, there's been other violations which I've explained in the past, the statue, the tinting, which were there prior to our operation, that were cited after the city had already inspected and approved our license back in 2021. But what I believe is basically unprecedented, and I apologize, there's May 2024, not 25, but there have been 88 proactive investigations on this property since Memorial Day. 88. They're only open 3 times a week, generally. There are 88 times, sometimes it's once, sometimes it's twice, sometimes it's 3 times a night, where the city sends code out to just make sure there's no issue. Of those 88 times, up until Halloween, there were exactly 0 queuing violations. After the first one in May, which I can tell you, I looked at other venues, a lot of venues got queuing violations that night. It was a crackdown, they sent the code to multiple locations. It wasn't just us. Get to that in a minute. But again, 88 instances where code went proactively, without a complaint, without any reason other than to see if things were operating well. All 88, no queuing violations. On Halloween, as Michael said, there was a queuing violation. When I found out about it the following morning, I contacted my client and I said, what happened? And they said, we hired extra security that day. We did everything we could to make it work. There was a bizarre rush of people. Most of them weren't our customers. We tried to get it under control as best we could. Ultimately, I guess, there was a violation issued. Code must have been there at that time. We were upset that it happened. I knew I'd have to be here dealing with it, but that's all we knew at that point. Last week, I found out that a disillusioned resident, who I was not able to find evidence of this person online, but a disillusioned resident wrote to the city, copied the commissioners, copied you all, copied staff, that they were so disillusioned by the operation of this nightclub that they were compelled to hire a private investigator to make sure to see what was going on. And it says here, you can read it, I have grown so tired and disillusioned with this process that favors nightclubs over residents that I hired a private investigator to document Vendôme's takeover of the public sidewalk. So I tried to find this person, couldn't find them. No one with that name owned property in Miami Beach, couldn't find anything on Google. They submitted also an investigative report with the name of the client redacted, and if the person sent the email and they hired the investigator, I don't know why they would redact their name. So I did what I've done in other instances, because sometimes people don't redact very well. I cut and pasted the redaction, and then I found that the actual client was not a disillusioned resident, was someone by the name of Gerald Buana, who happens to be the owner of my client's direct competitor, Mr. Jones. We've already suspected there's been something going on here, because these violations don't seem to make sense. But now we know that this disillusion...
Mickey, let me ask you a question.
Sure.
Though. Regardless of the source, if there's a violation, there's a violation, right?
Maybe, but maybe not, because here's what's happened. Here's what I think happened at this point. So again, you can see the person who did pay for this was not a resident, but a competitor, and the resident was sort of put as a proxy, or maybe that resident exists, maybe they don't, but this was clearly paid by a competitor. This competitor happens to have a queuing violation the same day we got one in May. This competitor has a violation for allowing people below the age allowed in their CUP. They haven't been called to the planning board. This competitor has violation for vacant storefront without window covering, similar to the statue and tinting one that we got. We got a violation for failing to notify the city about a promoted event one time. They had the same violation for a Rick Ross event. Ours was 50 cents. Fine was removed by the special master because they realized it was just a clerical error. I don't know the specifics of these violations, but these violations at this venue are virtually identical to the violations that we have, yet they haven't even been called here. I don't know why, but that concerns me. But most importantly, when I spoke to my client again, this starts to come together. 88 times, not one queuing violation. The night that a competitor hires an investigator to take a video of the venue, the night that's probably arguably the busiest, if not one of the handful of busiest nights of the year, is the only night there's a queuing violation. My client didn't understand why so many people came at once, why there was commotion, why they weren't even their customers. I can't tell you this for sure, but it certainly feels like this was a staged situation. They created a violation, they created a video, they sent something to the city right afterward, and now we're here defending the life of this venue that has been operating successfully, that hasn't had resident complaints, that hasn't had noise complaints, never had a violence issue, because someone doesn't like that we're doing good business. And I find that offensive. I find it bizarre, to say the least. I didn't go to law school to be doing this type of stuff, but here I am. And I have these gentlemen that I speak to on a daily basis for the last 2 weeks trying to salvage their business that some of them invested their entire life savings in. And here we are, clearly a competitor has staged a situation that has put us before you with the club's lifeline at stake.
Mickey,
And that's my presentation.
This isn't about them, though. This is about you guys. So,
Right.
I'm not,
Like,
Yeah, no, they're not here. I mean, they may, now that we brought this to light, they may be here in the future, I don't know. But my point is, there was one violation that triggered the staff recommendation, which by the way, a staff recommendation to essentially close a business, that's the most extreme action I believe this board can take. And to propose doing that to a business that 88 times has no queuing violation, yet the one time they have it happens to be not only a very busy night, but the night that a competitor has set up a camera and has paid for a private investigator to document queuing issues. Happens to be the night that the violation is issued. Happens to be the night that my client doesn't understand why all these people showed up that weren't even their customers. I mean,
What does that mean, by the way, not the customers?
well,
I just,
so they
I
tend to
don't
have
frequent the
reservations.
club, so I'm not sure, but
So part of the reason that they have this under control, most of their business is through reservations. People call in advance, they reserve a table, it's not that huge of a place, those are the people that come in. Do some people try and get in that didn't make a reservation? Sure, that happens, but they, again, 88 times,
Mickey,
no
is that the
violations.
case, is that the case with promoted events? Because I keep hearing the problem is promoted events, you get this mob scene show up because of what they're seeing on Instagram or whatever it is,
So when,
and they're not reservations.
So the promoted events trigger the reservations. Again, there are some people that will come, but again, 88 times. There have been, promoted events is something that I've always struggled with here because that's their business. They're not having huge they're not having promoted events where they're passing out flyers. They're just announcing this artist, whether it's a local DJ, whether it's a model, whether it's a hip hop artist, whether it's a celebrity, that will be at the club. It's not a full concert. They might do 2 or 3 songs, but they're just sort of there to greet people and be part of the event. It's very different than a concert type of vibe. But that happens almost every night they're open. And all those 88 times, there was not one violation, again, except for the night that there's a competitor paying an investigator to find a problem. And the amount of people that were there that night, at that moment, was not normal for their business. So they were like, we don't know what happened. We hired more people, we prepared for this, yet somehow something happened. I would have been like, well, you guys made a mistake. You guys didn't do a good enough job, except for the fact that I now know that someone staged something, which I didn't even intend to find. I found it by accident, but it was documents provided to us.
Mr. Chair, Matt, so one of the things that you had addressed, Mr. Chair, is the promoted events. So promoter, known as Drama, is potentially a serial rapist. And one of the things that the police have told us is that we are not, the problem is that they're not notifying police within the 96 hours. And the way that that's being done is it's being promoted as an appearance, not a promotion, not an actual performance. So there are ways that are being gotten around with that.
So-
You guys have also had a 20-year-old who's been indicted in a $230 million cryptocurrency scam.
Yep.
And
Well, thank you for bringing that up because what
because
actually
you guys
happened.
are not, you're not saying, you're not properly vetting your IDs.
No, I think we are, and thank you for bringing that up, because what actually happened, that was a surprise. I'd never heard about this cryptocurrency criminal, whatever it was. So we looked into what happened. That cryptocurrency criminal, by the way, terrible person, was like 20 years and 8 months, just under 21. He did go to Vendome that weekend. Probably could afford a very good ID. These guys do a great job of security. They have boxes of IDs they've confiscated over the years. That same individual went to Mr. Jones, went to Live, went to Kiki on the River. They actually researched this guy because it was a
This
surprise
isn't
to them.
about them.
So
This
he's
is
been
about you.
everywhere. And this person's ID was able to be good enough to get into every establishment in Miami. They obviously had lots of money to blow, and they got their ID was good enough that Live, probably the most successful nightclub in the world, let them in. So I don't think that our one venue should be held responsible for a really, really good ID by someone who has a lot of money. It happens. They catch all the IDs, but this is something that wasn't just us, and we shouldn't be the only person responsible because some criminal has a very good ID.
Michael, just a question, clarify for me. What qualifies a establishment who violates their CUP to be in front of the planning board versus one that doesn't show up here?
So if it's brought to our attention that there's been complaints or violations issued, and there's a CUP, then it's up to the planning director's determination to send a cure letter and schedule them for a hearing. So it wasn't until this morning that I was aware of these violations for 320 Lincoln Road. So knowing that they do have a CUP, we can now, we'll most likely send them, I'll have to research the violations,
When you say it's brought to your attention, who's bringing it to your attention?
either code compliance or resident or just somebody identifying us. We don't do a search of code every day to see, what's been issued for active CUPs. Typically takes an active email from code or a resident to us.
And what does make code decide they're gonna, flag one over the other to you guys for the same
I have
violation?
to see what happened with this case. I don't know why we were not notified that there were violations that relate to the CUP.
And I want to be clear, I have no business in.
That's the important part, is
Yeah.
that the violation has to relate to a condition of the CUP.
So, and again, I'll just point this out. One of them is specifically a CUP violation, the one issued in May regarding no teen night or underage events. They had a violation for that. But again, I have no interest in closing down another club. I want them to succeed. My client wants them to succeed. But we're here because they created a situation.
All right, so you're suggesting that this competitor sent people over to the club just to create a violation?
Here's what I know. 88 times over the course of 5 months.
No, I understand all
violations.
that, but
The
that's
one
your
night
bottom
that-
line suggestion.
It appears that way to me. It appears that way to my client. I didn't know this till a couple days ago when I found all this out. I was defending it another way, but we couldn't understand what happened this night, what was different. I thought it was just Halloween, and maybe that's part of it. Halloween is obviously a chaotic night. It's a chaotic night in my small little neighborhood in South Miami. I can imagine how it's chaotic in Washington Avenue. That being said, even with that, they hired extra security. They did all the right things that a business should do. They knew this hearing was coming, yet somehow it got chaotic anyway. Now that I know that a competitor staged the situation, it makes sense that they wanted to make it look as bad as it could. And that's why, do I have proof? I didn't interview people that night. I was asleep. But I think that's what happened. That's the only thing that makes sense.
You guys were still in violation. That's the whole point, correct? You guys were still.
We received the violation. I've appealed it because I'm fairly certain it wasn't our fault. I think it was a staged thing, and I think circumstantially the evidence points to that.
But there was still a violation.
The violation was issued, yes.
Okay.
Yeah, very good.
Yeah, so you should know, Mickey, that this violation was appealed to the special magistrate. I think the hearing is January 13th.
Correct. Yeah, I mean, it's on my calendar, but yes, it was appealed immediately. I appealed it because you have a certain limited amount of time. When I appealed it, frankly, I didn't even know what I now know. I think my appeal is very strong now based on what I found. But for them,
Let
again,
me ask you, I'm just curious, when you go to the special, how do you prove that they sent people there? I'm just curious
I
how
don't
you
know
do
how,
that at a
look,
hearing.
again, this is not a criminal case. I'm gonna prove that a competitor,
All right,
again,
so
I'm gonna
it's an
show 88
insinuation.
nights of
All right,
compliance.
I
I'm gonna show this,
understand.
I'm gonna tell them, unless something else comes out, I'm gonna show them the same thing I'm telling you. But I frankly believe that look, had code not been there 88 times, and there were, 0 for 88 in violations for queuing, I wouldn't have as good of an argument. But it's the one night that there's a violation, happens to be the night that a competitor, who we now know paid for, an investigator to have a camera and stage the situation. It's just too coincidental to me. I don't know if you guys see it differently, but we're talking about shutting a business down, where people have invested their life savings, where people have invested money to make it run perfectly. And they, for the most part, have been doing that. And then here we are, and there's been other things that have occurred. I'm not gonna get into them now, but these guys have been on the defensive with this competitor for years. And this is just, tip of the iceberg. But to close them down with this being the reason, I find it just insane.
But Mickey, regardless of that, you were here, it was September, and I specifically remember you saying, we have this queuing plan, because there were queuing issues in the past. Now we have this plan, and it's gonna resolve all the issues. And you say you're a good operator, and possibly so, maybe during normal times, there's no issue. But it does seem like anytime there's a special event, promoted event, or something maybe a little different, it does become a problem.
I would disagree with you, and I respectfully, because they have the same type of thing that they had on Halloween. Again, Halloween's Halloween, so let's put that aside for a second. All those 88 times where code went, they had an appearance of somebody, yet there was no violation. So again, what I find here, aside from it being Halloween, there was a violation in May for queuing. Everybody got one. Mr. Jones got one too. Since that time, and since they made some improvements, there were 0. And end of May, June, July, August, September, all the way through October till the last day in October, despite code going every single night they're open, once, 2, or 3 times. And I respect code, they're doing their job, they do a great job. But they found no violations. Yet, the one night, so we say they haven't been doing a good job. 0 for 88, till the one night where we have a camera set up by a competitor. And if you look at the report and you read the details, there was a lot of commotion from like a 10-minute period That's when the violation was issued, that's when the camera was working, and now we're here for that reason. And I think if not for that instance, I can't tell you for sure, but this board would be considering removing progress reports. But because of that violation, we're now going the extreme other way to suspend their CUP and close them down. That's a big leap. And we now know that the circumstances are questionable at best. So I'm here pleading with you to save this business under circumstances that are bizarre at the very least and do not warrant closing a business down. You know, we had to bring in litigation counsel who's with me today, Robert Zarco, because they're concerned about losing their business. That's their livelihood. That's investments that they would lose. Most of these guys have young children. They're starting their lives. They have a business that's been successful. The rug's going to be pulled under them because if someone doesn't like that they're successful. And that's not the way the city should operate, in my opinion.
Mickey, question for you. Are you aware of any other circumstances in Miami Beach in recent history that someone has hired an investigator to stake out of a nightclub establishment?
I am not aware. I'm not saying it hasn't happened. I personally can't think of one.
Do me a favor, let's go to the public comment first and we'll ask more. Is anyone here in chambers speak on this item?
And Mr. Chairman, before we open to the public, I'd like to ask any board members if you have any disclosures to make. As a reminder, it's not just a communication you had about the application. It's also whether you did a site visit, whether you took into account any outside information.
Yeah, I didn't know that these revocation hearings needed disclosure, so, okay. Any disclosures by anybody? We'll start with you, Scott.
No, I did speak with Mickey a few days ago.
Likewise, I had a conversation with their attorney.
I spoke with Mickey Murr.
Okay, I just spoke to Mr. Zarco about moving the hearing up.
With Mickey.
No one.
Okay, all right. Did anybody in chambers speak on this item?
Hi, Troy Wright, Washington Avenue Business Improvement District. This is difficult because I think that, and I've mentioned before, that Vendome is a very well-run operation, and it's been mentioned on several occasions. They've really have managed over the last X amount of years to really have no violations outside of the queuing issue now, which again could be a completely different situation. So it appears to me that they're really more a victim of their own success, but yet I think they've done all the things that needed to be done to really keep the crowds in hand. They attract the kind of crowds that we're looking for. They've done pretty much everything that they need to do. So I'm hoping that there is a way that we can see through and a way to really fix this minor issue to keep them around, because like you mentioned, closing them down could be a big problem, not only just for them, which I would really feel for them because I know they've spent their life savings here, but also for Washington Avenue. We sort of depend on that crowd to come in and to spend and to really support the other businesses in the area, all the pizza shops, the restaurants. And so it would really be a major blow to the businesses on Washington Avenue. So if there's a way of what we can think of, however we can do it to really support them and fix this problem, let's try to do that. But this is not a good situation. Thank you.
May I? Good morning, Robert Zark on behalf of Vendome. It is very evident that circumstantial evidence here would support the fact that this Vendome has been targeted by its competitor, Mr. Jones, and perhaps targeted by individuals who may be in association with Mr. Jones. When you have a record of 88 violations, of which none of them prove to have any active violation in effect, and then all of a sudden you have a perfect choreography set up on an evening which you anticipate there's going to be a lot of people, and then there are cameras set up on that particular day. While, yes, it is true, Ms. Lantone, that there was a violation if you count the number of people, but that was not created by us. It was not our negligence. It was not our failure to abide by the requirements of the previous CUP that deals with the issue of queuing, because during 88 visits, there was no violation. So how can this board undertake a draconian measure of shutting down a business when the evidence clearly leads that this was a setup? And I think what we need to do is, if you want to go ahead and address a queuing issue and say, look, you know what, can you modify it this way? Can you make sure that if we're going to have a promoter come in, you give us some notice? But yes, Mr. Needleman, there have been many other promotional events that took place during the time that those 88 violations or inspections were undertaken. And at no time was there ever a problem. Yet, and there were no cameras at any other time. But yet this time there's a camera. This time the report has the name of the owner of that competitor. I mean, it's a perfect storm created by the person who is looking to hopefully get this board to have the wool pulled over their eyes and shut down a business that should not be shut down. These are small businesses. I'm a resident of Miami Beach. I'm very familiar with how this city works. And the last thing you want to do is take patrons away from the South Beach community. I mean, if you go down Washington Avenue, it's dead. It's not what it used to be. So now we're going to go ahead and cut off one of the legs. I mean, I really think that you have to really reconsider. I'm not saying reconsider, you haven't made a decision yet, but you need to take into account if this is a setup. And if it is a setup, are we going to endorse people doing this because it worked? Because it worked, and now we're going to set somebody up, and then this time it's Mr. Jones, next time it's the other store. And by the way, what happens if Chick-fil-A opens up a business on South Beach? And all of a sudden, you're going to have 150 people lined up. I know this because I represent these people. Are you going to shut them down? Are you going to shut down Chick-fil-A because they have people in the sidewalks? You should be blessed if we have that kind of business here in South Beach.
This isn't about Chick-fil-A, though.
No.
This is about the fact that you guys have promoters who are accused of being serial rapists. Are you guys, let me ask you a question. I wanna know- wait, please. I would like to ask you, are you guys getting around the 96-hour notification by saying that there is a appearance as opposed to a performance?
No, they actually send that to, I'm copied on all those emails once or twice a week. That notice goes to the police.
But
I'm
the
copied on
police
them. I
have
have a
said
record of them.
differently. The police have said that the way that, as a matter of fact, I've seen it myself. When 50 Cent appeared, when all these other, Kodak Black, when all these other people have appeared, it's as an appearance. It's not as a promoted event.
I'm happy to speak to the police. I have all the emails. I'm copied weekly on all their emails to the city of Miami Police. The only violation, just to be clear, the only violation they have for that was one time there was a clerical mix-up. The special magistrate removed the fine because they believed that it was a clerical mix-up. You could tell by the timing of the emails. Our competitor has the same violation for one time, but I have multiple emails, multiple times a week, with all the notices to police. I have them all in my email. I can read them to you if you'd like, but I have them. So I don't believe that's happening.
If you guys had a queuing plan, which you presented, how come that wasn't working?
Because
again, it was working.
It was working. It worked 88 times. The reality is it wasn't working because it was a setup to make it not work. It's no different than if
Since
you
the
have
last time that you,
it's no different than
since
if
the
you
last
have.
time you appeared, it's been 88 times?
No, the first one was in May, Memorial Day weekend. They would issue a violation that day, so were several other venues, including our competitor. Since that day, and again, they're only open 3 times a week. There have been 88 instances. The reason it's so many is because they go sometimes multiple times a night. There have been 0 queuing violations on all 88. The only one is on Halloween, where I don't know what else I need to show you here, but all this evidence, I have not interviewed, can't go back in time and interview the people that were at the sidewalk to ask them who told them to be there or how that happened. But based on what we do know, it certainly appears that way because something was different, something was smelly, and now we know what it is.
All right.
And
Point of
one more
information.
Last one, I got to open, is there anyone on Zoom, by the way?
There's nobody on Zoom with their hand
Okay,
raised.
go ahead, Robert.
Just
Mr. Chair.
very quickly.
Mr.
With
Point
regard,
of
with
information,
regard,
please.
Hold on, Robert.
Are we here talking about the queuing plan? Is that the violation at issue, or is there another topic that I'm not aware of that we're?
No, that's the violation that's been issued since this was last before the board. There was an issue regarding the promoted events where the police department was not notified in the required time frame. That's the one that was referenced. That was appealed to special magistrate several months ago, and that was upheld by the special magistrate.
But is that the reason why you're recommending the suspension of the CUP?
No, the reason we're recommending is because of the latest violation for the queuing.
Okay. Now, if there's any information about promoters, can that be shared with the rest of the board as well? I think if we're discussing that.
Well, just to be clarified, as Ms. Latone mentioned, in terms of the notification required for the police department, there's a definition for a promoted event. As you mentioned, I'll read the definition. It basically says a promoted event shall mean any live musical performance or live entertainment in which an entertainer is advertised or marketed to perform at an alcoholic beverage establishment. So it's the performance that has to be advertised. If someone makes an appearance, that does not require the notification.
Okay, I would like to address real quickly the issue of the.
Robert, before you go, does the city ever investigate allegations that a setup was happening? Like, I mean, it's a really weird situation. Like, I don't know how you prove people were paid to go there, you know, but yet there's a lot of weird things going on.
This is the first time in my 23 years in the beach of having a PI report submitted to the planning board for a revocation hearing. So this is the first that I've heard about this possibility as well.
Well, and can I also say that it was submitted to us, a sort of a quasi-judicial entity under false pretenses. You know, there's this email address from Aaron Friedman, who we heard from counsel that he found no evidence of who it was. He said he was a Miami Beach resident, but didn't give his address, and clearly his email misleads us into believing that this, uninterested gentleman hired an investigator, when the reality of it is that he didn't. It was a direct competitor.
And just to be clear, in terms of our recommendation report was finalized before any of this came to light. So it's not, just to be clear,
Understood.
Our report and recommendation was not based upon some private investigator. But I understand you
No,
guys.
I guess when we're talking about the investigation of the investigation, we're talking. I'd like to know what, if there's anything the city, can do, before before things get submitted to the planning board for our consideration. I mean, how is it that people have to be sworn in here, but we get these videos that are sent to us, under false pretenses?
I'd like to see that video, actually. Can we see that?
It's a long one.
I just think that there's something, I don't know whether there's, submitting something to the government to influence our decision under false
Clearly,
pretenses.
the board can take all evidence in weight and determine what, if anything, they want to do with the application. So,
Well, and at the end of the day, the board is the trier of fact, right? You all are the triers of fact here, so
I know what you're saying.
And if I may.
So it's up to the board what weight you want to assign to a particular piece of evidence. Our code does allow extrinsic evidence to be submitted. It allows board members to have ex parte communications. It's just all of that needs to be disclosed.
And Mr. Chair, I just want to, because, the
Well,
question
see,
was
'cause
asked.
I'll tell you what I'm grappling with is that you have had queuing problems that were legit, right? And that's why we're here. But now, now you're suggesting, and there's a lot of weird evidence that my biggest problem, I don't care who complains.
Yeah.
But if they were paid actors to go stand in line, that's a
The
real,
fact
how do you
is,
prove
nobody
Right.
complained.
Right.
Except this fake person. And I want to point out.
I want to address one quick point. The issue of the accused serial rapist being in there. First of all, somebody's accused. They haven't been found guilty. And if they were found guilty, they'd be in jail, so they wouldn't be there. Number one.
I don't know
Number
if they're in
two,
jail or not, but your
it
name
doesn't
is
matter.
mentioned.
It doesn't matter. The city is not in the position to be the government to decide who it can censure to come in or out of a building, number one. Number two, if you go in and interview
This
everybody who
doesn't
goes
have
to these.
anything to do with somebody coming in or out. They're promoting your business.
But you don't know if this person has committed the crime or not. They're simply accused. The same way if somebody
That's what I
is
said.
in a cryptocurrency scheme, who cares? They can go dance, they can
They're
go sing.
underage. That's what's the point.
And again,
It
no
just- it's
violation was
irrelevant.
issued. No violation has been
Actually,
issued
it's
to.
not
Can I ask-
irrelevant
One at a
if they're
time, one at a
underage.
time.
It's
Can I
not
just say-
relevant to the issue of queuing. and
Okay,
it's
so
not
you
relevant
said
to
that you had prepared this report prior to this planning board meeting and the violation?
no,
Okay.
we based our report on the violation that was issued by code compliance on Halloween night.
Okay.
Is code is here?
Yeah.
Yeah,
Can we maybe ask, unless you want to do it, Mr. Chair,
I
after we.
believe, is Manny Villar here from code?
On this
Ken
item.
Varella's there. And Jonathan, just to one of your questions, I've also been practicing in this realm, not quite where Michael is, but from this side since 2001, and I've never had a situation like this. I was frankly surprised to see it. My defense prior to seeing this report and figuring out what happened was, hey, it was Halloween. We're going to find a better way to deal with holidays. I've talked to him about that. And by the way, they prepared some modifications to queuing. We didn't have time to submit it. What I think is reasonable here, again, you mentioned, Mr. Chair, that there was an issue. Yes, on Memorial Day, another really busy weekend, there was a queuing issue. That's the only legitimate violation that we have. Because I deem this one to not be legitimate based on what we know. And I've appealed it, and I have a strong belief my appeal will be successful. But that's the only one. They submitted a revised plan 88 times that it was tested, it worked.
So
We'll still
Mickey,
work to make it better, and we're happy to work with staff.
So what would you suggest? I think we
I
need
would
to wrap it
suggest-
up and have somebody suggest something or make a motion. What would you
My
suggest?
suggestion would
Let
be,
the board decide.
they've been working, because we didn't find out about this nefarious stuff till recently. They've been working on improving their queuing. We think it's working, we think it can always work better. I'd like to meet with you, not under the pretenses of the club is closed and they're out of business anyway, so who cares? Meet with you over the next couple months in a reasonable way, hopefully get you to agree that whatever modified queuing plan works better, submit that, follow that, continue to improve our operation under reasonable pretenses, not under the situation that we've been asked to be in, which is closing us and asking us to fix it is a death knell.
But
Because
why
if we're
hasn't it been
closed, we're out of
fixed?
business.
Why hasn't it been fixed, though? I don't
It
understand.
has been fixed. There's been 0 out of 88 inspections where there's been a violation. This one stage setup was the only one we have. I don't think it hasn't been
All right,
fixed.
you keep repeating yourself. Can you come up, Code? I guess they have questions for you.
Good morning. My name is Kenneth Varela, Co-Compliance Administrator for Co-Compliance.
So do you know, so what was the violation that was issued on November 1st? Was that a result of a complainant, or was that a result of just a random check?
Give me 1 second. I wasn't working that night, but I believe,
Yes, if you can speak closer to the mic, that'd be great. Thank
Apologies.
you.
I got that information for you now. Give me 1 second.
We did indicate, just in terms of the summary of, on page 5 of the board packages, it says there was an active patrol, and that's when the crowd was observed. So maybe Ken can just verify that, but that's based upon the reason why the citation was issued.
Sorry, just while you're pulling that up, question for staff. So when you came up with your recommendation, I guess you had no knowledge of any of this? You know, someone might have called, there was a competitor or anything like that, you were basing it off of?
This investigative report was submitted after we had completed our recommendation, so we didn't, not based upon, it was only based upon the evidence that we had at the time, which was regarding the citation that was issued for queuing on the sidewalk on Halloween evening, night.
So, Michael, is there some sort of zero tolerance policy now with regards to violations, or?
This is their second offense.
Okay.
It's mentioned also in the violation, so it's not like this is the first time, this is the second time. But at the end, it's up to the planning board. There's a whole range of things you could do in terms of just continuing it, revoking it completely, suspending it for whatever, on a time frame, continuing and modifying. So there's a whole range of things that the board could do as part of this having it as a revocation modification hearing basically opens up all the possibilities for boards to take action on the file.
Understood. The recommendation seems pretty drastic.
Like I say, it's up to, that's just our recommendation. The board can weigh the evidence as well as new evidence that's presented today, and the board can make a collective decision otherwise.
You have information now?
Yes, I'm just looking at getting the case up here. I'm just having a problem with this iPad.
Yeah, I mean, you know, it seems like they came up with a queuing plan. It seemed to have worked since there was nothing until November 1st. I'm sort of, you know, looking at the video, you know, I don't even know, I mean, you see they clearly had plenty of security guards or, you know, bouncers that night, clearly, and there were periods where they're just hanging around because there's nothing to do. I guess my question is sort of when people start crowding around, what are they really supposed to do other than say, hey, you can't stand there, keep walking, at which point then it sort of is a conflict between people, and, you know, I wouldn't be happy if somebody, you know, strongly told me to keep walking when I'm standing on a public sidewalk. And so, you know, that's why I originally in the first meeting said, why don't we, you know, come up with some solution here, because there needs to be somewhere, if they're not allowed to park, you know, patrons outside at all, anywhere, what are they supposed, what are they supposed to do? And so when people start crowding, like, so when a bus pulls up, a party bus pulls up and drops off 30 people outside their doors, I'm not saying, I don't know whether that's, was intentional or nefarious, but say that happens, people just get let out right there and want to come in. How do they do that? There's at least 15 minutes where they're trying to clear the sidewalk. Because of one violation of that, I understand there was a prior one, but this one, I don't see how that's something that we shut down a nightclub because of that, when it's something that potentially could be fixed. And we've worked with a million nightclubs in the past, and hotels and pools, and, in the face of multiple violations. Mila had, multiple garbage violations even after had a garbage violation, and they came before us, we fixed the problem, then they get another garbage violation, and they say they've taken care of it, and we take their word for it. And I don't think it's right that we target, maybe not target, but that we, pick on an establishment like this, especially when, by the way, they had several violations earlier, and they were good actors and they fixed them. The problems we've had in the past with establishments is when they kind of, say poo-poo to us, and they don't fix the issues, and they don't act, toward resolution. And here, they're clearly acting toward resolution. They want to resolve this issue. They've raised very valid concerns, whether they're, those concerns will come to fruition or not. Either way, the concerns are valid enough to certainly make us, look back and think about this. And then I just think, I think what sort of Matthew was indicating is, how are we now looking for a 6-month suspension when, every other restaurant that's had violations or nightclubs that have had violations, we say, okay, fix it and we'll move on. So I just think, I'd like to work toward a resolution here, is my thinking. Not suspend them. I'm in favor certainly of bringing them back in. I guess it's not 30 days. There's no December meeting.
Can you
No, there's no
make
December. I would
reservations?
suggest,
Can you make reservations, like say whatever the other club's name was that you were mentioning, that they have reservations? How can you do something like that where you're?
We have reservations. They have the same violations we have. They just didn't get one on Halloween because we didn't stage a whole situation over there at their club.
so we do think that this does warrant, if they're going to have a queuing plan, it should be like an emergency queuing plan, or have a larger area for queuing. And I did research some building permits here, and the area of the lobby was larger in the past. At some point, there was a spiral stair that was installed.
That might have been the prior
I'm sure it was
operator,
before. I'm
yeah.
not sure but what point it was. Wasn't recently. So the lobby area was larger in the past. We do think that there should be a larger area within the property for queuing. So I do think if the board is going to continue this, that the board direct the applicant to work with staff to come up with some sort of plan to come back to the board, to present to the board.
We're happy to do that. We'd love to work with you on
Hold
this.
on, guys, stop a minute. I want to let him say what he has to say and get out of here, so he doesn't sit here all night.
So on that night, it was a patrol. It was a proactive inspection. The officer did observe a large crowd outside of the establishment. They made contact with the security guards, and the security guards directed the crowd inside at that point. And then the violation was issued afterwards.
Okay. Any questions of him before, because we got to move on. Any questions of the code officer?
Just one. So proactive patrol means,
Patrols are proactive. There was no complaint given.
I mean, you don't call, it's just letting you guys randomly go out, you're patrolling the streets and you just observe.
And am I correct, because we heard that there were 88 visits, proactive patrols, and then there was no issues with crowding, or queuing at those visits?
Correct. After the May violation, we, obviously this location was on our monitoring list, and we did go out multiple times to inspect. This being, and then on Halloween, it was the first time since then that we've issued.
Is there, and for code compliance, is there like a window of tolerance for the gathering, like for the queuing, as Jonathan mentioned? I mean, there is at some point when people arrive, there is a little window of time where people have to be ushered in, or ID has to be verified, or I know we're pushing for doing this in the lobby as much as possible, but I mean, there has to be a small window of tolerance, I'm guessing that.
Well, it all depends on the sidewalk is being obstructed. how much of the sidewalk is being obstructed, and how, if there's a conditional use permit in place and what that conditional permit.
Can you check
stipulates.
IDs that while they're queuing and say, sorry, get out of here? I mean, how can you, I'm
That's
trying to
part
work
of, that's
with you
part
guys.
of their, I don't know if, Mickey, if you want to go over the queuing plan, the queuing plan that you submitted, if you can just go over that for the board's information, so everybody can understand. I think it's a two-phase approach where it's.
I mean, I don't know,
it's-
so.
Someone
So
does
if you can-
patron age checking before they get to the,
So if you want to put it back up, I have it on that page right now. I can share it with you guys. Yeah, so here's the queuing plan that was submitted prior to the September meeting. They have the line within their property on the outside. If you see that triangle, that's the ID check. They don't want to let people in without an ID check. Before they get into the main area, while they're in the lobby, they're patted down, checked for weapons, something that every responsible club should do in the world we live in, so that nobody gets in there. They've never had a violence issue there. They've never had a shooting there, none of those things, because they do a good job of protecting their
Sorry,
guests.
just to stop you there. Is this what generally all clubs do? They're all lining up outside. That's where you get the ID check.
Yeah, but that's within, there's an area within our property, and.
No, it might be
that-
within the property line. I'm saying it happens all exterior.
Yeah.
You're checking them. It's not like there's an indoor queuing area.
There is an indoor queuing area. It's a two-step process. I received from them, this has been a difficult week for them dealing with this. They've modified this plan to propose it. I didn't want to share it today because I haven't shared it with the city. I want to meet with Michael and go over it, but possibly using another entrance to manage it better. Again, he's told you what I told you 88 times, and I just did the search, proactive investigation since Memorial Day. I got 88 hits. I went through all of them, no violation observed. You can do the search yourself.
There is
So-
another entrance, though?
Well,
that you
there's a
could-
back entrance. It's not part of our plan now. We're proposing maybe that's a way
That's
to
what I think,
manage it.
we need to have
But
plans of
it's-
the
I wanna
entire
meet with you to
building
go
to
over this
see
stuff.
where there are opportunities
Right.
to improve.
I think it's working. I think what I've shared with you, hopefully you can see that it is working, but we can always make things better, and we're happy to do that. And whether we come back January's very short, but it can come back in February, whatever you guys are comfortable with, we'll have time, so we have time to meet with Michael, and maybe if there are improvements that need to be made, and I'm just saying maybe, as Michael's suggesting, we could do those when it's not peak time, close for a brief period and I don't know.
What about having like an off-duty police officer helping with the sidewalk? Just making sure that.
They're giving me a thumbs up, happy to
Love
do
a
that.
thumbs up to a
Yeah,
comment that I
that's a
made.
good thing.
I love that. All right, I would
All right,
make
hold
a-
on. Any other, he's gonna make a motion. Any other questions? Okay.
Just before the motion, and this is really for moving forward, and I think Jonathan brought up, is a good point. Let's say there's a club operating and they have a queue in front and everything's good, but let's say there's a promoted event at that club and maybe it's somebody famous and all of a sudden people start congregating on the street or sidewalk that aren't planning on going in the club. And code compliance goes by and it looks like maybe there's a violation of the CUP. It may be a question for code, but how would they deal with that? I mean, how do they make that determination? Who's there for the club and who's there just to see what's going on?
Well, when we observe large crowds outside of venues, most of the time in Vendome's case, there's not many businesses open at night in that area. So when they're queuing and they are on the sidewalk, they're en route to go inside. So it's obvious that they're queuing for that location, not going anywhere else.
One of the things, and I know most of us saw the video, I didn't look at the whole video, but a lot of clubs have, the ropes on the sidewalk and whatever, maybe keeping people against the building. And in that video, I didn't see that. Maybe it was
No,
there, maybe
that's
people
because
blocked
the-
it, but that's something to,
Because the condition of the COP prohibit that.
okay. Well,
Yeah,
maybe it's something to
that's
do.
part of the problem, right?
Yeah, because maybe if there's rope, then people behind the rope are there for the club and anyone else is not. So it's something to maybe look into.
Yeah, well, Mickey, when you meet with the city, I mean, again, what I'm hearing from multiple people, it's promoted events that create the problem.
It's also,
Hold
it's
on, let me
also,
finish.
oh, sorry. I'm sorry.
That's all right. And so, if you ban them, I know that it hurts the business. So that's something you really got to figure out is the promoted events, because that's what I'm hearing is you get the mob, and that's the
So
problem.
we'll work with staff on all those issues. I think we can certainly improve the operation. I think what's being recommended today is far extreme for even if we didn't have what I found, but based, in addition to what I found, it's a really
Well, I'm
unique
hearing from the
situation.
board, they want to give you time, so.
I appreciate that.
Anyway, go ahead and make a motion, John. I'm
Can-
sorry,
can
wait,
I just
Elizabeth,
ask-
I'm sorry.
I just have a quick question. How can you guys comply with promotion versus appearance. That's, I think, where you start running into issues, is that you've got appearances that are being announced as at the day of, oh, special appearance by, as opposed to an actual maybe promoted event. So
Right.
how can we go back to and skip the appearance and say this, because like it's what was his name? DaBaby, I think his name was. He appeared at Live the night before he appeared at Vendome, and he's going to be there. So how do we get to that point?
So what we do is, and again, I can read to you the emails, I'm copied on all of them. They notify the police. The code says if it's a performance, it's 96 hours in
But
advance.
it's not a performance.
Right, so they notify 96 hours in advance, and if for some reason, what happens sometimes is they find out someone's in town, they say, I want to be there, they come to an agreement. The code allows, if it happens within this 96 hours, as long as you can show that the contract was not signed prior to your notice, it also complies with the code.
I think that's
And
a
I've just
loophole.
checked with them, they do this for performances, they follow the code, that's what the code says. If it's just an appearance, someone's just showing up, we're happy to discuss that with Michael, maybe making
think
that
that's
a requirement too.
important. I think it's important.
But they're following the code, and the only violation they did get, and again, our competitor got the same violation. The one that we got was a clerical mistake on the contract. We showed that to the special magistrate, they saw the dates. So they said, look, it happened, clearly it was an error. You guys have been doing it good every other time. So they removed the fine. And that's the only one that we've ever had.
So the continuance, I didn't hear you earlier, it would be till when?
I would suggest January so that applicant can come back to the board and show whatever progress they've made in terms of the queuing plan or suggested modifications to include, for example, language to talk about any advertised person, whether it's a performance, just the advertising or having a contract with somebody, that also has to be notification of the police
So
department.
that's 6 weeks. Is that enough for us to get to?
I would do.
February?
So February, because the magistrate hearing is in January, right?
It's, I think, January 13th. Also, look, I want to move this, I want to get this resolved quickly. It's the holidays. I need time for an architect to finish drawing something. I got to meet with Michael. I think February just makes more sense, so we're really buttoned up by then.
I'm fine with February with the understanding that you'll be back sooner if there's a different violation.
Absolutely.
issued.
I think
So
I'd
that would be
encourage
my
you guys to
All
have
right,
an
so there's a motion. to
appearance
mo-
notice.
There's
Yeah,
a
we'll
motion to
discuss that
move it.
with Michael.
There's a motion to move it to February. Is there a second?
Yes, I'll second it.
Okay. All in favor? Aye. Anyone opposed? Okay,
Thank you all.
in February.
Happy Thanksgiving.
Revocation modification hearing is item 10, Planning Board File 240678, 1100 West Avenue, Mondrian Hotel.
So this next application has been before the board this year since the planning department issued a cure letter on March 28th. This was last before the board on September 24th. Now, as noted in our prior reports, the most flagrant violations here were for, one, on April 6th, the violation was issued for having a live band, including percussion without a special event permit. And on April 27th, the violation was issued for having a DJ on the property without having a special event permit. As we noted at the September revocation hearing, those two cases were appealed to the special magistrate, and on September 5th, those were dismissed due to technicalities with the code cases. Now, since the last meeting, there was a noise complaint that was issued, and that's outlined on page 11 to 12 of the staff report. We are recommending that the board continue monitoring the property, even though there has been no violation issued since the last time. We are recommending that the board continue the revocation hearing, the revocation modification hearing to the February meeting in order to continue monitoring the property. That I'll turn it over to the applicant's representative for their comments.
Honorable Chair, board members, staff, James Rao with Great Swim Water, Office of 600 Brickell Avenue, here with my colleague Adrian Noto, and the ownership and management team of the hotel, including Michael Leibowitz, one of the owners. So as Michael mentioned, this process started 8 months ago. We're here on a continued hearing. For the last 6 months, there have been no complaints or violations. Michael mentioned there was noise complaint issued in November 8th. There wasn't actually anything issued. To the contrary, the code inspector, as noted in the staff report, indicates at no point in my inspection was any music detected. So there was no music. There were some people talking, is what the report indicates. So essentially what we have here is a completely clear and clean record of operation for the hotel for the last 6 months. And for that reason, and obviously we had a number of different progress reports and hearings in this matter. So we've talked through all of the past items in there. And for that reason, we're asking that you conclude this matter today, which I think you would be concluded as a success. I think this, if there was any problem there regarding CUP enforcement, it certainly is clear that it's been resolved, as indicated in the staff report as well, that there's been no violations of record. At the last hearing, you made some non-substantive modifications to the CUP, so that's already been done. And look, the staff has actually continued this hearing to February, but I think you've taken all the enforcement action that you need to. You did take action, you modified the CUP, you had hearings, and the enforcement process is not designed as a tracking system or to be a penalty. So if something happens in the future, of course, the board has continuing jurisdiction over the hotel under the CUP. The staff, the board, code compliance, all have the ability to monitor the hotel, and you have the ability to call the hotel back here in the event there are any violations, complaints, etc. I would like to give Mr. Leibowitz just a
Yeah,
few
and
minutes. of my
Michael, I
time.
was reading something when you were going, why does the staff want to continue it?
Just because of the history, we just think that monitoring is important in case there is a violation that's issued that enables the board to take action. Otherwise, if this is concluded at this point and a violation is issued, we have to send a cure letter again, and the board will have to set a progress report.
Well,
and
okay,
then
let
set
me
a
ask you, I
resolution.
probably asked you 1,000 times, but and again, this is subject to public comment, which we haven't had yet, but can you continue it, but if there's no violations, then cancel that hearing?
We've done that in the past. We could have the board continue it, provided that there's no complaints or violations issued, not have them come before the
Okay.
board. We've done that
Seems
before.
like reasonable. Okay.
The problem with the other way is that essentially it keeps you under perpetual indictment,
I mean, considering.
seeing what's going to happen.
Yeah, all right, let's have the public hearing. Are you finished for
I
now?
would just like to give some time to Mr. Leibowitz to say a
You
few
want to
words.
speak now, or do you want to wait for public comment? Once you wait, and then you can address it. Is there anyone
sure.
in the chambers to speak on this item? Anyone on Zoom?
We have a couple of people on Zoom with their hand raised. The first is Susanna.
Hey, make sure she was sworn in, please.
Hi, Susanna. Can you state your full name for the record?
My name's Susanna Purker.
Thank
I
you. Do
live on
do you
1200 West
do you
Avenue.
swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Absolutely, I swear.
Okay, go ahead.
Let's please not move back to square one and take that snake oil that they're trying to sell you there, because it's been laying low, the business, for the last few months after we've been at the planning board and after you guys have thankfully started to understand and believe us. And there have been no major events, and it's been quieter, but it's been suspiciously quiet and has been acting up in the last few weeks. So it's not true that there were no complaints, because we have all called several times. And you can see from the previous complaint, the Vendôme, when there's 88 noise complaints, this doesn't come from nowhere. People are hearing it, people are complaining, and then when there's no violation applied, then we need to look into the code compliance system, because something is not working. There was a DJ there last weekend, 2 weekends ago, who packed up as soon as we complained and called, packed up right away, left. Then there was loud music, and the code compliance officer heard it And I don't know whether there was no fine applied, no violation, but it's been going on, especially on the weekends. The one complaint was actually about an unpermitted event, not about noise. So that must have been a misunderstanding on the code compliance officer's side. There was a big wedding and reception, whatever was with loud music, a DJ, etc., which counts as an event, and it was not permitted. So that was the matter of the complaint, not music. And please don't seize this here, and let's keep this open, or let's finally have them have consequences. We all, a lot of us have been here since before this place was a hotel. This used to be our sister building, residential. It was a normal building, quiet, people lived there, families, and now it's turned into a total event space that anybody can rent, a music event place, and it's just not designed for that. We're living in a Greek arena. It's just sounding off in all the other buildings on the sides. And thank you for being sympathetic to us.
Thank you. Next.
Our next caller is Gail.
Hi, Gail. Do you swear that the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Yes, I agree. Yes, I will tell the
Thank
truth.
you. You have 3 minutes.
My name is Gail Durham. I live at 1504 Bay Road. I've been a resident of West Avenue for approximately 25 years. Throughout the years, the Mondrian Cup regarding alcohol hours, speakers, music, all those uses have been expanded. The cup was expanded in 2008, 2009, 2013, 2014, 2019. I think all of these expansive uses and hours have caused the chaos. And I think we have to go back to a more restrictive cup, the pre-2014 cup. You know, we have in recent years a different city, a different members on the planning board, a new mayor who based his election on law and order, and it makes sense to rein in these outdoor entertainment events and outdoor speakers that blast music day and night. I think what the planning board should do is reverse the hours of operation for alcohol. And sometimes there are 2 o'clock and 5 o'clock outdoors. I think specifically you should prohibit the special events permits, prohibit especially outdoor special events. The reason why there's a lot of complaints and less valid complaints by the code compliance is, as you know, planning board members, we hear this all the time, code goes in wearing a uniform. They, by law, have to present themselves at the reception desk. And then by the time they get the manager to escort them to the outdoor patio, all of a sudden the music's lowered, the band has, you know, run into the back room or into the bathroom and has disappeared. So, you know, if code compliance really wanted to catch them, they would have a drone, they would have a boat outside. I don't know what else they could do. They would be undercover, but they're not doing that. So that's why there's not enough valid noise violations versus the complaints. Thank you.
Thank you. Anyone else?
There's nobody else online with their hand raised.
Okay, nobody else in chambers, you want to speak?
I'm Michael Leibowitz. I'm one of the owners of the Mondrian Hotel. I've owned it for 5 years. I met with Susanna and Gail probably 8 or 9 months ago before the first hearing to hear out everything that they had to say. I live in the neighborhood. I care about the neighborhood. I encourage everyone to visit the property and on this board and see what goes on. But the truth matters, okay? And I think the truth in life is important. And what I just heard there was the exact same things I heard when I met with them in a very hostile way. And I went there to help. I didn't go there to fight with them. I wanted to hear their concerns. I thought it was important. They talked about these events at the first planning board hearing. They talked about 3 or 4 events that had nothing to do with the hotel. I think that was shown. They talked about the chairs being moved in the morning. The chairs don't move, okay? We don't put the chairs away at night. But I said, if there's any movement or a hose, whatever you guys need, we'll push it to 9 o'clock. The head of WAVNA, of the association, I ran into in the gym, and he said to me, you know, sometimes people park across the street and there could be garbage. I said, fine. Every day we will have somebody from security go out and clean up any garbage that you think comes, okay? We do everything we can for this neighborhood, okay? The property does not make any money. It needs a renovation badly, okay? We want to improve the property, but if we're under attack by, number one, Gail does not live in the neighborhood, okay? Susanna lives next door. If you go visit I don't even know what I'm defending, okay? And I would encourage everyone to see what's going on at the property in the morning and at night. If we do a renovation and it makes sense because we feel like the neighborhood is with us and wants it to improve, we'll build sound walls. We'll do whatever it takes not to have noise. I actually met with a sound consultant. Back then, I walked them through the building. Okay, I'm at the property all the time. I think it's truly unfair, the attack that we're under there's 800 people that live in those buildings, okay? And a lot of people use the property. A lot of people are very happy with the property. I've owned it for 5 years. That's 1,800 and something days. We're talking about one scenario where there was a percussionist that was basically hired, and 20 minutes later, it was shut down. The employee that booked the event was let go, okay, and we took action, okay? And we've taken action in every single scenario that we've had. And again, in the 1,800 days that I've owned this property, we're talking about one scenario, okay? The other noise that we hear, there was not noise. So we want to be a partner to this neighborhood, okay? We live in the neighborhood. I have another partner that's here with me, Perry Whites. He lives in the neighborhood. Obviously, you guys know Russell. He lives in the neighborhood. We want to be a partner, and we're a good citizen. And I think we've been dragged here over and over again. We've spent a lot of money on lawyers, and we will do whatever it takes. But we just want to have a partner in the city. We employ 250 people, okay, that all have jobs related to this property that matter also. So I just wanted to finally meet all of you, say my piece. I'm happy to answer any questions. I'm happy to meet again with Susanna and with Gail, but I think they have their minds made up. They're 2 people out of 800. We'll meet with all 800, and I'll meet with the 2 of them. So we will do whatever it takes, but I think as a business operating in this neighborhood, that people that all live here, we'd much rather own this property and be a solution than go sell the property to some national company that's not going to care about it. That's it. Just wanted to say my piece and meet all of you.
Thanks a lot.
Thank you.
Anybody else?
We do have another public comment. Alex, online?
Alex, please state your full name for the record.
Alex Diarmas.
Alex, do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you. You have 3 minutes.
Morning, Chair, members of the board. I have been a lifelong resident of Miami and have been living in Miami Beach for going on a decade almost. I have been to the Mondrian many, many times with prior ownership, with current ownership. And for the life of me, I just do not understand what the issue with the sound is. The Mondrian is a staple to that community. Every time that I go, everything seems to be fine. The service is great. It's a great place to unwind. I don't know why they're having so many issues, and it would be a shame if this problem continues to go. That's it. Thank you.
Thank you.
And we have Susanna back again, if you want to let her speak.
All right, 1 minute, Susanna, then we're done.
Thank you so much for letting me say my piece. First of all, of course, I don't appreciate to be called a liar. I live next door. If you have people, customers that like to go to the place, to your establishment, call in and say how much they like it. You can have that for Vendôme, etc. That's going to be happening always. But we live next door. There's a lot more people. We have Thanksgiving weekend. Everybody's traveling. Last time there were more people in the chambers. There is another neighbor on online with her hand raised, and it's really a constant nuisance. I live right next door, and every neighbor, even the ones on the rooftop, can hear it. That lady is just with her baby at the daycare, so she can't call in. But if you in the future have another meeting, we will of course rail on more people. I've been here much longer than 5 years than Michael, and When we met with him, he compared us to Ocean Drive, and he said, "Oh, I live in Miami Beach. It's a party place." And when I said it's a residential zone, he said, "Oh, there's also people residing on Ocean Drive. So much for hostile. It's something you just can't negotiate with."
Okay, thanks, Susanna. Is that it?
I suggest we close the public hearing.
Yeah, we're closing it.
Mr. Chair, if you will, I'd just like to lodge a time.
And I'm sorry, 1 second. Do any board members have any disclosures to make since this was last heard? Okay.
I'm sorry, Mr. Chair, I just want to lodge a timely objection to the hearsay evidence from the folks that are talking and lack of cross-examination in person. But we're here to, obviously, as Michael said, we're here to answer any questions that the board may have. And as the one gentleman that called in support was talking, I looked at the hotel's general manager to find out if she knew who it was. She said she didn't. She's here to tell you that if you'd like, but that's one of the many things that were said that did not sound true by some of the people that called in.
And Mr. Rao, I didn't hear exactly what you said, but you do have a right to cross-examine. Did you say you were being, just so I just want the record to be clear.
In person.
You could do it over Zoom if you wanted to.
I wouldn't want to do it over Zoom.
Okay.
I want to do it in person. Oh, I'm sorry, I think there's one more public comment that didn't raise their hand.
Good morning. My name is Perry White. I've been a owner of the Mondrian with Michael and Russell for the last 4 years. And as Michael said, I would invite everybody on this board to come there anytime, day or night, and see the level of any music there. It's absolutely quiet. And proof of that is there's over 100 condo owners that live in the Mondrian. Not one of them have ever complained about the noise to this board. And so they're living there under that roof and have never, ever complained. So how could you justify listening and verifying what is being said by these two people? It's not justified. It's really not. And I would really urge you to come there because we really do want to improve the neighborhood. You have the Bay Walk going in there. Right now, at the ADP of this hotel, you see people coming there and enjoying the services of this place. If we do the renovation that we want, this place is going to enhance the neighborhood enormously. It's going to bring up the value of the condos in the neighborhood. With the Bay Walk coming by, this is the only place where people could come and have a drink and sit by a pool and enjoy lunch or dinner. And we want to make that even nicer for the neighborhood. But we can't do that if we're going to be restricted in ways that are unreasonable.
Can I ask
So
you, what are the restrictions that are unreasonable to you that you're not able to operate like you want to be?
Just
I think he's saying if
people
we
saying that
impose
there's
restrictions.
unreasonable noise when there's not, and having to, be monitored by the board. It is a hotel. It is a hotel, and there are certain services there, and you have to offer certain things to the hotel, to hotel residents, and to the condo owners who want certain services. And so,
Yeah, I mean, I understand. No, I don't mean to interrupt you.
Yeah,
No,
no.
I'm just saying, what's in the CUP to all of us seems reasonable, especially since we just modified it to kind of bring it up to date and keep it consistent with what we think should be going on. And I think that was the agreement, the understanding is that was what was going on. And I don't think, my thing, I understand having to hire the lawyers to come back to this hearing. I get that element of it. It seems that there are still residents who are lodging complaints because of the excess noise. So far, we haven't seen anything like that. We've seen a complaint when code went out there. There was, people talking, and that was what the noise was, which wasn't a violation. And I think just as long as there's no violation, I think we're poised to close this out. But me personally, I understand what the residents are saying. They've lodged their complaints. I think, to me, it makes sense to leave this open one last time, and if there's nothing else, that have, and no other violations, then I say, I would think close it out. But I just don't want you thinking that there's these like new restrictions that anybody's placing. I don't think that's.
I don't know, just urge.
But James, I thought you were okay with.
No, I think the issue is that, just to respond to that question, on being in the midst of an 11-month enforcement proceeding that presents a risk of, deprivation of property rights, and that's hard to explain to partners, investors, lenders, when you want to make improvements. I think that's more of the issue.
Wait, what do you mean 11-month investigation?
Well, this started in March.
Oh, you're talking about the hearings?
So if we went to February, that would have been 11 months of enforcement proceedings, when in the last 6 months, there's been literally nothing of record. There hasn't been complaints. There was one complaint.
I didn't know what you meant.
So
by
that's
investigation.
what it was.
Can I ask one question though?
My only point is, I just would urge the board to put everything in perspective. Mic is off. I think your mic is off.
You need to turn, there you go.
Sorry. Michael and I just would urge the board to put some
We
of these
do.
complaints
I
in
promise
perspective.
you we
That's
do.
all. Okay,
Can
we
I-
want to just make the neighborhood better.
We have
want to make everything
just
better.
so you know, our job is to balance your success with the quality of life of the residents. We try to do that in every case, just so you know.
That's all we can ask.
Can I just
know.
Thank you,
so
thank you all very much.
The residents had one of the speakers had mentioned that they've called multiple times, and that, obviously there's only one code, code complaint that was opened. Do we know anything? I mean, maybe, I know code's still here, but, I guess my question is how is it determined that a code case is open versus just a complaint by a resident? Yeah.
So, since the CUP's violations were issued back in April, there's been 3 code complaints called in. None of them have been valid. So that's the only complaints we have recorded in our system. Other than that, it goes to our dispatcher, and our dispatcher sends it to us, and we respond out there.
Yeah, no, I guess so, just if the residents are still listening.
I would suggest that if somebody does have a complaint, that they follow up and contact code afterwards, if that complaint has been registered, and if there's a citation number, a violation number, or just a number that can be referenced.
That's what I was gonna say, because whatever they're doing, however they're calling, only one of them or 4 since the last time we were.
Well, nothing has been issued at the location other than an individual unit that has nothing to do with the property itself.
Right, I'm saying in terms of the noise complaint, there's only been one that's recorded in their system. So for the residents that are listening, you need to follow up with code to make sure that they're receiving your complaints properly, that's all.
There was actually 3, 2 in May and 1 in.
Right, the most
Yeah, but I'm
recent one.
talking about
this month.
recently, yeah, okay.
But when they do call in, they do get a case number for them to follow up on.
Okay.
Thank you.
Can I guess make a motion?
Sure.
Considering that there haven't been any violations, I think we've been doing this for 6 months and we've continued it, I guess to give chance for there to be more violations, I would make a motion to dismiss this. Obviously, we'll be paying attention. If something were to happen, they could always come back, but I would make a motion to dismiss.
Okay, is there a second on that? No second?
So then.
Okay, if there's
I'd
no
make a
second, is
motion-
that because, I want to make sure, I assume it's because you all want to continue it, but how about if we continue it, but agree not to have the hearing if there's no violations? Would
So
someone,
I'll
that be
try that.
palatable? Okay.
Make a motion to continue it.
Well, no violations or no complaint?
But the complaints.
Here's the issue. No, listen, I don't want to delay this on forever. One of the issues is that the residents are testifying to under oath is that code compliance shows up, they're greeted by the front desk, and by the time they get to the back, everything, the music's turned down. There's not going to be a code violation. That, it's just.
Yeah, but then Jonathan, then you're living in a world where there's got to be some definitive
It's a loop
enforcement.
of, or more videos or more.
You
of a
can say that
resident
about every
outpouring.
venue in the world.
All right.
I understand what you're saying. It's a tough,
No, I'm good with, listen, I think I agree with you that this has got to come to a head at some point, so I'm okay with.
So I just want to make staff is okay with that. We can continue it till February, and if there's no violations,
If you want to say violation versus complaints,
No
no
violations.
citations issued.
Right.
You could do that, but just remember that any time a violation is issued, we have to follow all the steps in the code. The notice and cure letter to the applicant, the progress report before the board. At the time of the progress report, the board can vote to set a modification or revocation hearing. So all
yeah,
those
but
steps.
hold on, if we dismissed it today and they got a violation next month, what would happen?
That's the process. I think what they're suggesting is that they,
Right.
that they continue the
Leave it open.
revocation modification hearing.
Correct. And if
that
there's
there is
none-
no citation issued by the February meeting, then the applicant does not have, then the case will be, then
That's, I
the
think.
board will
correct.
suspend.
That's the
February
motion.
over January.
Automatically suspend the hearing, and the applicant does not have to
Okay,
appear before
wanna
the
make it
board.
Jan, whatever
Yeah,
you-
okay, I'll make a motion to continue this item until the January meeting. And in the event that there are no confirmed violations or citations issued between now and then, this item will be dismissed
Okay.
prior to such.
I'm gonna get a second, then Scott will get to you. Can
Which
I get a
date?
second on that?
Second.
Sorry?
Second.
Jonathan, okay, Scott, you had a question?
It's not, I mean, I'm okay with the motion, but this, we can wait. After this, I can ask staff
Okay.
a question.
I was going to suggest February. There's a
The
second,
motion is
but there's a
January,
second,
and we have a
so-
second, so let's vote. Do a one by one. Michael?
Okay, this would be to continue the application to January, and the revocation modification hearing will be dismissed in January if there are no citations issued by code. Ms. Beatty? Ms. Beatty?
Sorry, yes.
Mr. Frieden?
Yes.
Mr. Cement?
Yes.
Ms. Latone?
Yes, but I'd prefer February.
Mr. Goltenoff?
Yes.
Lynn? Yes. And Mr. Elias?
Yes.
Motion passes 7-0.
A question.
Thank you.
And this is for staff. You know, I know this application had some violations in the past, nothing recently, but we've seen a lot of other issues where there were noise violations, numerous noise violations, which I think are much more detrimental to quality of life. The previous application, Vendome, they had the queuing issue twice, and you were recommending a suspension of 180 days. I would hope and expect in the future, moving forward, when we have other violators in front of us, CUP violators, and especially if they're noise complaints, that you look at them just as harshly as you looked at Vendome. Because we've, you know, I can name them, we know the ones that have been up in front of us. They're always in front of us with violations, and they're good for a while, then they come back. So I would hope you,
Well, we have
you
one,
address.
and just for the record, for everybody knows, we did have the Good Time Hotel. The Good Time Hotel was continued till December. Since the December meeting was canceled, the Good Time Hotel will be back before you as a continuation of their revocation modification hearing on January 7th.
Well, I would just hope if there are violations, you scrutinize that application or hearing.
Is that who you're talking about, the good time?
There's some other, I mean, seems like every meeting, there's people that are violating their CUP and they're in front of us, but noise violations, I think, are probably have the most detrimental effect on quality
Right,
of
but I
life in the
thought
city.
you thought they were too harsh on the Vendome.
Yeah, I mean.
You're just
it
saying
was
be
probably
consistent.
going-
We get
I'm
it.
saying
Be
be consistent.
consistent.
Yeah, I
Got it.
mean, you looked at that, that's a queuing issue, that's at 2 in the morning. It's not, nobody knows that's going on except code compliance.
Right.
And you were recommending 180-day suspension, whereas other violators have noise complaints that really affect quality of life. And, it seems like they get a slap on the wrist, and then we just move on. What happens again? So
Well,
I
it's
would
up to
hope.
us.
Well,
Ultimately.
the staff recommendation goes a long way.
True. Okay. Well taken. Just consistency, that's always well taken. All right, we'll do one more item, their companion, and then we'll get to the time certain. So we'll do 11 and 12 together, Planning Board File 240695 and 0696, Washington Avenue Residential Plan, Comprehensive Plan, and Land Development Regulations.
So I'll go through some brief history on these items as well as on recent action. So because this is for the Washington Avenue Residential Plan incentives, this is to incentivize the change of use to residential uses or or include new residential construction along Washington Avenue. Since this does include an FAR increase, there's a 6-step process that these applications have to go through. This is similar to what's going to happen later on today. We have the Dovell site application that requires 2 public hearings before the planning board with a community workshop in between, and then 2 city commission meetings with a workshop in between. Now, there's an extra step for these Washington Avenue application requirements, because initially the planning board reviewed the first proposal, and that was to increase the FAR up to 3.0 for Washington Avenue, and that was reviewed by the board on July 30th, and the board continued it till September 24th. On September 10th of 2024, a public workshop was held. After that time, the commission sponsor increased the FAR further in the proposal to a 4.0. So because of that, the process had to start over again on October 29th. So the board reviewed this proposal on October 29th. That included the FAR increase to 4.0. And because of that, we had to have another public workshop. That public workshop was held on November 7th. After the planning board met on October 29th, the Land Use and Sustainability Committee met on November 5th, and they provided additional recommendations as part of this, an ordinance. And that's really, I'm going to go over today the changes from the last time the planning board reviewed this, as well as what the Land Use Committee recommended or asked the board to weigh in on in terms of what they requested. So on November 5th, on November 5th, the LUSC met and they provided some additional recommendations to the board. This includes a couple new items. First is the incorporation of a transfer of a development rights program, or TDR program, to require a portion of the maximum FAR from the sale or transfer of FAR from a sending district. So the FAR would be increased from the contributing buildings in another historic district, for example, within Flamingo Park. So the FAR would be increased for contributing buildings in that district, and those properties could then sell their excess FAR to Washington Avenue. As part of that, what that does, those funds from the sale have to be utilized to renovate or restore the contributing buildings in historic districts. So you're providing benefits for Washington Avenue, as well as benefiting the contributing buildings in Flamingo Park by allowing them to have funds for renovating or restoring their building. An example of this would be setting a maximum FAR of 3.5 with up to a 0.5 additional FAR available through that transfer program. So in order to avail themselves of that maximum 4.0, they'd have to buy 0.5 from a sending district, from a sending building in, for example, Flamingo Park to get to that 4.0. The second requested modification is the potential inclusion of an attainable housing requirement for a certain percentage of the increased floor area. For example, a portion of the units would be reserved for households below a certain income level. Now, for reference, workforce or affordable housing has a AMI percentage of no more than 40%. So this would entail perhaps requiring that up to a certain percentage of the units be reserved for people at an income level below, say, 160%, or another number that's looked at. It's not to the level of workforce or affordable housing. It's slightly above that level, but not to market rate housing. So that addresses some of the affordability that's been addressed with Washington Avenue. Also, because of these additional requirements, we've removed the maximum unit size that was previously in the proposal of 1,200 square feet. So the primary ask today from the Land Use Committee and the Commission is to weigh in on the affordability requirements for in terms of what percentage of the unit should be at a more affordable level that's below market rate but above workforce housing, as well as what portion of the FAR should come from a TDR program from, say, Flamingo Park. Now, this TDR program will be developed as a separate ordinance, but sort of the idea is that this would be incorporated into the Washington Avenue ordinance at this time. So we'd have like a cap of a certain FAR in order to get the additional. You would have the TDR involvement, as well as having a portion that's reserved for unattainable housing. With that, the area remains the same, the increase height remains the same, and the FAR of 4.0 remains the same. The provision that now a portion would have to come from TDR and from attainable housing component.
Is the first floor still dedicated
50% to,
That's still in there now, 50%.
gonna vote.
That's something that the board can weigh in and suggest a different number. Like I say, this will also be further developed as it has been to this whole process when it goes to city commission, the first reading, and then I'm sure it will be developed even further after the first reading, and then the community workshop, and then the final reading before the city commission. So again, this is an application generated by the city as opposed to the application we have later on today by the Dovell site, which is a private application. So I just ask for the board members primarily to weigh in on any questions that they have, as well as the specific asks regarding the TDR program and attainable housing requirement. We should at this point open up to public comment. And then the
Yeah,
board-
is there anyone in chambers to speak on this item? And just identify yourself and your address, please. Thanks.
Okay, Roberto Da Torre. I own some buildings on 16 and Washington Avenue, 1568 Washington Avenue. Just a suggestion on the height, there was a consideration to go to 150 feet, which I think is way too long, too high, but maybe 120, which will allow the units to be higher ceilings. If, you know, the units by itself are small, and you have a higher ceiling, it gives a better, could be for us larger unit. Also on the first floor, you considering to have some commercial, and you want that commercial to also have high ceilings. No, 20 feet is not that much, but it could make a difference on the design of the units. Thank you.
Thank you. Anyone else in chambers? Anyone on Zoom?
We have Johan Moore online.
Yes, good morning again. I want to echo the board member's skepticism as to some urgent need for 50% of the ground floor, in fact, to be dedicated to micromobility. I think there is so much more value to this than just promoting walkability. And I don't think we necessarily want to get into a situation where we're going to require a contributing storefront to lose 50% of its ground floor to micromobility when there's a different way to access upper floor apartments. On the question of attainability, I very much am looking forward to hearing those numbers, but an article that I read recently referred to a study which stuck in my craw, but nonetheless seems worth mentioning. I will review the study over the holiday, and it argues that even building market rate housing, anathema to some of us as a solution, does tend to lower rental prices and or increase affordability, and that in this instance, in any case, trickle down might actually work. That being said, I remain fully supportive of any efforts to regain lost population. I'm wondering if the board has in fact had forwarded to you by Michael my 9 questions about the TDR proposal. And if so, if you have any questions about those, I'm also happy to read them. I understand that that is 9 questions and that may in fact exceed your patience or my time, and they may not in fact all be worthy of your consideration. My bottom line is that I think a TDR proposal, wisely crafted, can do more than anything on the horizon at this point in time, especially given U.S. Army Corps of Engineers timeline for 28 funding requests, which have to come from the White House. This is a good way to get money to shore up our historic buildings, contributing buildings in our historic neighborhood. To the extent that this residential model extends across the rest of the city, that benefit to historic neighborhoods and contributing buildings can expand citywide as we confront environmental impacts, rising sea levels, stormwater, and all of that. So if there are any questions, I'm happy to go into them. I won't, without being prompted, subject you to my 9 questions, though. Thank you.
Thank you. Anybody else?
We did have a caller, Darren. I think he lowered his hand. So with that, that concludes our public comment online.
Okay, nobody else in chambers? Okay, we'll close the public hearing. Any questions from the board? You're healed?
Just before I forgot, one last thing I forgot to mention. Also included now is the ability of the Historic Preservation Board to waive the setback requirements. That was not included previously.
Okay. So obviously, I've always been very much in favor of this. Just listening to some of the public outreach, I was a big proponent of the micromobility. I think that's a big deal for getting this accomplished. But I don't think that the micromobility should come at the expense of, ground floor retail activating, the street and the residential up top. So one of the things that we've seen in different cities is, micromobility happens usually in either back of house space, loading areas, or they're allocated some type of, space on the sidewalks, right? So you can kind of build out your built-in scooters, bike rentals, whatever that is, in order to accomplish the micromobility use. So I'd love to see how staff can incorporate that going forward. And I'm also, I don't know kind of best path forward for suggesting what the percentage should be. But I think that we should kind of stick to workforce housing and above, bans and limits. And I don't know, I guess I would defer to, staff and whatever developers think would make a project like this feasible. But I don't know the answer to that. I don't know if anyone here would know the answer to that.
Yeah, I think definitely, in terms of the requirement that the percentage of the ground floor have that micromobility component, you're not gonna have, you're right, this would be reserved more towards the rear of the site, or maybe if it has a storefront presence, that it not be just, scooters in the front. And that's something I think would be part of probably the Historic Preservation Board review process, for any sort of application along here on Washington Avenue.
Sure. Yeah, I just want to make sure that anything that we do, we kind of keep the, main goals front and center. It's how do we activate the street, and how do we, get people back living on the beach?
I agree with you, and I think that I don't want to see our ground, we see all over the city that we have ground floor retail space that's underutilized, and in fact has been empty for going on 15, even 20 years in some cases. Those spaces need to be built out properly and useful, with a minimum depth of at least 70 feet with a 20-foot frontage. I would like to see also that we set a number of units for each size. I don't think we want to have one bedrooms throughout the whole project. I don't think that we need to have, I also think we need to set slab to slab height limit for each. Someone in here brought that up. And also we need to set a floor minimum.
Are you saying you do want to set a maximum floor to ceiling height, or no?
I think so. I think maybe, 12 to 15 feet. But as long as
10
it's-
feet.
Is there a minimum for the sizes? I know
No.
we just-
That's
Well,
what
we have, there's in the code already of a minimum of 550 and a minimum average of 800.
I think we need to have a little bit higher to make it usable for families. If we're really serious about having families live in this area, then we need to make the units actually livable.
So the minimum, sorry, I just missed that, Michael, but the minimum was,
The minimum is 550 square feet for new construction.
And that's just not, I don't think that's enough.
Well, Michael, as usual, we need to vote to pass it favorably, then we can do a second motion with recommendations.
Well, I would suggest if if there's a consensus, we can include that in the recommendation, so.
Right.
I think if we can come to a
And this
consensus.
is definitely I guess, contrarian point of view, but if you look to the cities where people are moving, like if you look to, the city of Miami, I believe they have a lower minimum unit size, don't they? Isn't it in the, fours?
Well, in terms of, if someone's going to include the renovation of a historic building here, then that unit size goes down to 400 square feet, so that's sort
Okay,
of the
so then we
benefit.
don't do a minimum ceiling height, and then we have,
Yeah, so the minimum ceiling height, I agree with, but in terms of the minimum unit size, the city of Miami has, units that are in the fours and they're efficiently designed. And it's a great entry point for, these young working professionals to come into a city and kind of,
so how many do
start
we
off.
have that how many do we have? Then we don't want, what percentage of the projects do we want to have? I think those are,
Well, I
do you-
think
do you
that's
wanna-
gonna, I mean, that's gonna depend on, I guess, each specific, project is gonna have a certain floor plate and they're gonna try and
but
fit
if
in.
we're setting those standards now,
So if we were setting standards, I would, if possible, I'd say instead of having a 550 minimum unit size, can we bring that down to 450? So that we can maybe start to get some additional density and where people can really start to move in, reactivate the businesses, and start to have units that are actually attainable for young
I think
professionals.
that you're doing that by already utilizing the income level, 160% of the AMI, are we not?
So that would, I think, definitely help, but if we could get, let's call it 450, square foot units, developers could probably fit a few more units on there, which, again, just by having some additional supply will also hopefully help bring pricing down.
I think if you set a lower minimum, you need to make sure you also have an average, otherwise you're gonna be left with all,
That's
you don't wanna have all
hotel-
studios, right?
That's hotel size. I'm not
Yeah, I
in
would be,
favor of that.
I would also have concerns. I have concerns with the removing the average, or excuse me, the maximum unit size, right, Michael? That's been removed, 1,200 square feet.
Correct.
And 1,200 square feet today is a large two-bedroom or a small three-bedroom.
It's a small
that's being-
two-bedroom, because I
that's-
live in one.
Okay, that's being built. And there's a lot of things that I think are going on here, and micromanaging the entire formula here, I think, is going to set us up for a failure.
Agree.
Even going to the AMI level, I think is really going to have an issue. So I think, I've spoken to a lot of different stakeholders on this, and many are supportive of this, but when you start doing things like taking out the maximum unit size,
I'm not gonna vote for that.
increasing the FAR, increasing the height, you're starting to look at like a live local type thing here.
So go ahead and move it.
Well, I don't think we're ready yet to do that.
okay.
But I would recommend that we keep well, actually, I can, one thing, concern is the maximum unit size. I'd recommend keeping a maximum unit size. Maybe it's not 1,200 square feet, there were some concerns, but if you remove that and you combine it with the extra height, you're gonna get luxury units, which is not the intent. So whether it's 1,300 or 1,400, those are, in today's market, those are three-bedroom apartments, which are what are needed in this city and which are a luxury for many families.
Do we wanna vote on each, what we could do, I've seen this in the past, we could vote on each recommendation, especially the unit size. I mean, I would suggest coming up with.
Scott?
I echo a lot of what Matthew's saying. When this started out, the idea was to bring residential Washington Avenue, which is a good idea. But it started out at 3.0. We could debate that. I do like the idea of a TDR because you're not really increasing density in the city, you're just moving it. That's a good idea. It started out at 3.0, now it's 4.0. It started out at 75 feet, now we're talking 150 feet.
100 feet. It's 100 feet.
Well, in certain zoning districts.
I feel like you guys are
The-
trying to manage
the-
what's being developed
but-
and losing sight of the goal.
But that's my point. The goal was workforce or affordable or attainable housing now. And
You've
it
already
seems
said
like
that
it
with
seems
the
like
160% of the AMI.
it seems basically what that's saying is you can make even more money and then live in the.
So do you want to, so this 160% is
Well,
still.
I'll get to that. I mean,
All right.
I just want to go through the different things. We had the maximum unit size, which was basically eliminated now, or at least that's the recommendation. We had where was it? The AMI we talked about. Now, basically, you're saying that, well, actually, going back a little bit, it was supposed to be that all the units were going to be affordable, workforce, or
No, there was
attainable.
never
There
an
was never-
indication. No,
Was
because
there ever any?
unless you put it in the code, no one's gonna build under market rate units unless you put it in the code. They're always gonna get to the highest and best market that it will provide. So unless there's something in the code that restricts it, they're all gonna be market rate units. It's gonna matter what what level of market rate.
And that was from the beginning, because
Yeah,
I know
it was
the
never-
MI normally for workforce or affordable is 120.
The city has
For
a,
the
the state's different. So in terms of the state and live local, it's 120. The state's workforce and affordable housing is 140 in terms of that percentage.
And now we're at 160, so
Right.
it's bumping that up. And then I do think that, we're talking about not having any parking at all. You have families, even if it's 20% of the families living in these buildings, at least 20%, I think, are going to have a car. And that's going to wreak havoc on the surrounding neighborhoods because they will want to park somewhere.
But the idea here is that the people, if a family wants to move here and they have a car, they're not going to be moving to
I
the building.
understand that, but I just think that's going to be a problem because you say they may not move it. They may move there and then say, well, we'll just do what we can, we'll find parking. That's what people do in the Flamingo Park
Well,
neighborhood
it's also
anyway.
been
They
clarified
find
too
street parking.
that anybody, just so we're clear, anybody taking advantage of these incentives and building a project, those residents could not get a residential parking pass in the neighborhood.
True, but it doesn't stop them from looking for other parking or parking illegally. And it also, have that many more cars on the road. I know you've talked about the sort of the infrastructure impacts, and you didn't seem to be it seemed like you were concerned about that. So that's part of it. Also, in terms of the overall massing of these buildings, it's in the report. They all look like basically just big rectangular boxes, and that's what I'm afraid they're going to be because we're eliminating we're adding, I guess, a waiver for setbacks. So when these projects do go in front of the HPB, when the developer says, I need to build out to the street, or I need only a 10-foot setback from Washington Avenue to make it work, a lot of times that happens. So I'm concerned with what Washington Avenue will look like if this goes through as proposed. Heights, we can talk about it, FAR, height increase, but I just think this, what's being proposed here is very large. I don't think it's a one-size-fits-all for Washington Avenue. Maybe we could talk about a certain section of Washington Avenue and try
Well,
something.
I think definitely, these studies are just based upon the developable area. That, of course, any specific application is going to have their own application to be submitted. One of the things that I think is important to talk about in terms of, and I think Michael touched upon this, or Matthew touched upon this last time, is taking over the square footage of parking and replacing that with like residential. The problem with that is that a floor plate for parking, you can have, these dark spaces and expansive parking garages. Once you go into building residential units, you have to think about light and air, so the footprint's going to be much narrower. So you can't take the square footage of a parking garage that say would be at the second or third level and replace that with square footage for residential, because then you're not going to have light and air. So necessarily, if you do have a setback reduced along Washington Avenue, it's going to be form of either a bar building along Washington or something that has a limited, a floor plate. That's why in the massing studies you see, the tower portion is always narrower than the ground floor pedestal, because otherwise it's not going to be conducive for attractive residential units.
No, look, I understand that. I just, there was a presentation a few months ago, and I think I forget who the architect was, and that question came up. These buildings look like they're just going to be a flat facade, and even the architect at that point said, well, maybe we can push a little percentage of it back a little bit. Even the architect seemed like, to get everything to get the square footage that's needed would be very difficult without being able to.
I think that's why we
basically
included
just put a box up and maximize the space.
But so that's why we included that flexibility, so it's not a variance. And it's something that the Historic Preservation Board, who's, very knowledgeable in approving new construction and historic renovations and adaptive reuse, do think that the Historic Preservation Board is knowledgeable enough to weigh all those issues and without having to.
I don't know, I just think that because this is all new and it's a rather huge upzoning, that certain things should be sort of etched in stone and said, yeah, you can do, if we go ahead and move this forward, you can do this, but there are certain things you need to abide by without having a variance or waiver. I think that being one of them, but I mean.
The
I'm
collective, I
open
think if
to-
someone wants to make a motion on an individual suggestion, and we can, hopefully we can have some consensus, or we can just provide, some of the comments. But I think it'd be good to try to pin down issues like the TDR program. I think I haven't heard anything negative about that. And maybe comment on, what is appropriate percentage of the FAR to come from a TDR program?
So I'd like to make a motion on the maximum unit size. I think it's important that we keep it in this proposal, and I would make the motion that the maximum unit size be 1,300 square feet.
So in other words, you're making a motion to pass it on favorably with that amendment.
Or I think we're gonna,
Can we include other, meaning I agree
Well,
with you, but can we
I
include
think
other?
it's,
Yes,
what
but I
Matthew's suggesting is we vote on each item.
One by one.
Yeah.
All right, but, okay.
Well, what do you think, Mr. Chair?
Yeah,
That was-
yeah, that's fine.
Okay.
I'll second that.
I mean, ultimately, we're gonna pass it favorably, and then we're gonna vote on specific
We'll-
recommendations.
We'll include which ones, and then the vote and the consensus for
Right,
which
so
ones.
do we need to vote generally on passing it?
Well, let's vote on each item first.
Perfect,
right.
okay.
So this was to increase the units, to establish a maximum unit size of 1,300 square feet. Ms. Beatty,
Yes. Oh, no, sorry, repeat the question?
this would be to establish a maximum unit size of 1,300 square feet.
No.
No. Mr. Frieden,
Yes.
Mr. Cement,
Yes.
Ms. Latone. Mr. Goltenoff,
Yes.
Mr. Needleman,
Yes.
Mr. Elias.
Yes, reluctantly, yes.
So that would be, so that including consensus, we have a consensus to,
But it's a recommendation.
right, yeah.
Right.
It's
Okay.
a recommendation to include a
Okay.
maximum unit size.
Yeah. Okay.
Can I go for another item?
Sure.
Well, was it Scott? Were you finished?
Yeah.
Okay, go ahead.
First
Yashil,
motion,
go
so then
ahead.
I'd like to make a motion that instead of the 50% for micromobility, we utilize something along the lines of, let's call it 15 to 20%, which would hopefully incentivize ground floor activation with retail.
I'll second that. But could I make a friendly some suggestion?
Depends how friendly.
Okay. Well, so the micromobility is an extremely important component to this. And,
Absolutely.
And it really should have front of house visibility. This is how people are going to be coming and going to the building predominantly. So I've said this before, and I continue to say it, this micromobility component needs to be further developed. It's very high level right now. We don't really know
Yeah, I agree. And I mean,
what is proposed.
And I think depending on, what the retail needs are, in other words, you could have enough micromobility to satisfy an entire building, and I just don't know what that percentage is.
And I agree.
It could be
It
5%.
doesn't need
But
to be in
50
the
is too
front.
high. I don't
Correct.
think anyone
It
would
doesn't need to
say-
be in the front of the
So I think
house.
the
Yes.
consensus is that 50% is too high, and the number needs to be looked at and revised
Number needs to be
downward.
looked at, needs to be lowering to figure out kind of what works sense to satisfy, the residential use and the retail use.
And it needs to be in the back of the house, not the front
No,
where
no,
retail
the
and
front of the
people-
house.
I'm
It-
sorry.
It needs to be on the front of the house.
It actually doesn't, and I'll tell you why.
Okay, well,
because
my
that's where
friendly
people- I know, but-
amendment was front of the house.
Okay, well, I appreciate that.
Okay, let's vote on
Hold
that.
on, we can have debate about it.
yeah,
Elizabeth,
let's-
tell them why you
I'm
disagree.
telling you why, because
Go ahead.
retail has been my business for the past 30 years, and this is where people walk. And people walk along and you want to drop into stores and you want to do all these things. There are also parking places all over the place. One of the biggest problems is what Scott was saying earlier, is you are going to have families that have cars. And so, I think parking is going to be a real issue. This is not, you can't just, this is an LDR, right? This is a comprehensive plan. You can't just say, no cars. I mean, that's unrealistic. People have to drive to the doctor, they have to take their cars, their pets and their family to places. And, look, this is a discussion that we need to have, and we can't just, blanket have a motion. We have to have a real discussion about it.
This is the proposal that's been presented to us by the commission sponsor.
And we're discussing it.
So I invite you, I'll spend some time with you around South Beach. You'll see many families
We're
getting
not
around.
in South Beach, though. We're all.
Well, hang
this
on,
is-
Washington
this is-
Avenue is South Beach.
Washington is Washington. It is not all of South Beach.
I think, let's just vote on the motion.
No.
So, and this would be to look at the micromobility component,
Yeah, I mean,
revise the
again,
number downward, but have a front of house component. This doesn't mean that the entire frontage is going to be for a micromobility
No, but
station.
I think we're all in line, we're all in agreement that it should be less than 50%. And then the commission can deliberate as to where it is, whether it's front of house, back of house. At the end of the day, we're all trying to accomplish the same thing. It should be enough kind of micromobility to service.
Right,
the
so just
residential
articulate
needs.
your motion, though.
The motion is that the micromobility needs should be significantly less than the 50%.
And let them decide
And
how
let them
much.
decide what that percentage is, but it should be enough to service the residential needs in the hopes of reducing, the vehicular traffic in the surrounding area.
I'll second that.
Does anybody oppose
Seconded
that?
Previously.
Anybody opposed to that? Okay.
Okay, so there's
passes.
consensus on that.
Okay. Any other suggestions?
I think that,
Nothing
never mind.
I'll also, and I think, we also have to make a motion for items 1, 2, and 3, or are we kind of good with what we've done?
Yeah, I think the commission wants specific recommendation on the TDR and the percentage involved, as well as the attainability requirement.
So I think, I'll make a motion that we, let's see, we pass number 3 with a favorable recommendation in terms of the percentage of attainable housing. How are they defining attainable housing? I assume it's not going to be affordable. Is it workforce? Is it above workforce?
That's what the commission is asking for your recommendation.
But I mean, aren't we kind of now pigeonholing, and I've been the biggest proponent of workforce housing, so it's not that I want to limit it, I'm just saying, aren't we now going to pigeonhole the development community in terms of what's a feasible project?
160% is what I'm looking
Well,
at.
maybe if you want to suggest that there be something for below market rate and let the,
Okay, so
That's what's
I'd
right
like to
here.
make it with, I'd like to pass with a favorable recommendation with the inclusion of, some type of percentage of attainable / workforce housing. And if possible, let's call it, I don't know, 10%.
No,
Hey,
shouldn't it be a
Jonathan,
lot more than that? 'Cause
What do you
that's
think
the whole
about the
idea.
160%?
I just don't know. Again, I don't know what makes these projects feasible. So if you come out to the development community, you say that you need
Michelle.
50% workforce housing, they say, okay, we can't build it because land is too
But
expensive.
true, but then all we're doing is basically upzoning Washington Avenue to allow big luxury buildings.
Well, I think to Matthew's point of what he was trying
you
to
still can make
accomplish was
money
to
off
have-
of workforce housing, just not making as much money.
Might not make any money. I mean, land is expensive nowadays and
Work-
construction costs are through the roof. So I just don't know the answer to that.
Basic economics is that the quality of the building is directly correlated with the pricing that can be obtained. So workforce or affordable housing is going to be basic construction. And I think that it's been given for 160%, and we maybe have 10% to 15%.
And maybe I misunderstood. You're talking workforce affordable, not attainable.
No, I'm talking about the technical workforce
Workforce
housing.
is
Okay,
what
then, yeah, I can,
Michelle's
if it's smaller,
saying.
I'm okay with that. I guess what I don't want to see is high-end units or,
It's-
and I know it's
Let's
not,
put
they're
it
not
this
going to
way.
be million
As a
dollar
current
units,
member of the
but-
planning board, I mean, the last thing that I'd want to see as part of what the city is trying to put forward is another high-end condo
Mm-hmm.
project trying to kind of revitalize Washington Avenue with some attainable
I don't think
housing.
it can be.
So I don't
high-end.
know how we could accomplish that, but if, hopefully the maximum unit size would help, the introduction of micromobility, some type of mandatory inclusion of workforce housing. I mean, that's my goal. I put it to staff as to how to accomplish that. I don't think we're able to, I know what you're gonna say.
No, that's not what I'm gonna
Is
say.
that not, is this right?
I just have one comment on your last recommendation is, the city commission is separately, looking at creating development incentives for housing that is above what we currently define as workforce in our code, which is up to 140% of AMI. It's an initiative that Commissioner Fernandez is sponsoring and is pending before the Land Use Committee. So, I mean, those discussions are ongoing, so you don't necessarily need to nail yourselves to a specific number
Keeping
at
it to
this time.
below market value would keep that open enough for the commission to be deciding the direction of that,
So,
right?
so I guess for number three.
too.
so
One
for
at a
nu-
time, one at a
so-
time,
So for
guys.
number 3, so my motion would be to pass this with a favorable recommendation, and I guess the city commission will advise and opine on what additional, workforce housing would be included based on, the items up for discussion.
I think, do you agree that it should be above workforce, but below market?
Yes.
I'm not necessarily agreeing to that. I don't
Okay.
know. Let's
But
see
below
what the data
market, I
shows.
think, everybody,
Below
should there be a
market-
below market?
market, yes. But-
What is market? I mean, I think throwing these terms around here, what is market rate on Washington anyway? Or in?
I don't think there is much of a market rate because there really isn't any stock there.
I know, I think we are kind of pigeonholing ourselves a little bit here by prescribing certain percentages of.
No, but
income.
we're not ascribing any percentages. We're just saying there should be some workforce housing. I think the commission has additional items up for discussion. And based on the additional FAR that's being offered for this, which I think is meaningful to really get the development community incentivized, let's see what makes these
Right,
projects
without a
feasible.
specific, okay.
Without a specific
All right.
percentage.
Okay, you got that?
There should be some sort of workforce or attainable housing requirement.
Yes. Any second?
I will.
Who said yes?
All right, anyone opposed to that?
I'm a no.
You're a
I think
no?
it should be all market rate.
Okay, anyone else opposed? All right, so that
Include that as
recommendation
a
passes.
consensus.
Is that it? Anything else, Michael?
I think everybody agrees in terms of the TDR program is valid, is a good thing, but do you want to weigh into what percentage or what part of the FAR should be part of a TDR program?
Would this take the FAR above the 4 that they're?
No, so 4.0 is the max. So the issue is, should a portion of that be from a TDR program, for example, 1 or 0.5? So basically, you'd be giving, for example, Flamingo Park an increase in FAR, but that increase in FAR could only be used not to construct in Flamingo Park, would be to sell it for construction along Washington Avenue.
I guess why do we care? If they can build up to 4, right now they can do it.
Well, because then you're benefiting, you're not just giving the benefit for Washington Avenue, you're giving a benefit to contributing buildings in a nearby historic district. So it allows somebody, nearby residents or property owners to get funds to renovate or restore their property, this TDR program.
So is there any downside?
I don't see any downside, it's just a matter of, what percentage you think should come from a TDR program.
How much FAR is available? I know this was asked before, and I don't think we have the answer, right? Is there a lot of FAR available in the Flamingo Park?
Well, no, the idea is here is that you'd be giving, the commission would be increasing the FAR beyond what's allowed now, say 1.25 for Flamingo Park, increasing it by a certain number, so then that could be sold to Washington Avenue. And of course, if the property is already above that amount, then they couldn't sell anything.
So they would lose their FAR.
No, they're not losing the FAR.
No,
'cause
no, in Flamingo Park. they
Okay,
would-
so
they're not losing anything that they have right now. They'd be getting additional FAR that could then be sold.
No. Okay, that's what I want to know.
So I guess I'd make a favorable recommendation then that the TDR program be allowed. And the portion, again, I have no idea. I don't think we have enough data to mandate any of these percentages.
with
or-
you.
Okay.
Yeah.
So the
Anybody object to
recommendation
that
is that
TDR
they-
program?
that they do an analysis as to what percentage should be devoted to TDR.
And ultimately, we'll be able to vote on the specific percentages that the commission would, I guess, decide on, right?
Well, the city commission will decide. This is not, after this recommendation,
This goes to them.
it's not going
Maybe
to come
it's
back
not
to the
going to
plan.
come back.
All right.
Okay, so.
All right, anyone opposed to that? Okay,
I'd like to also discuss the minimum floor area size for units. I don't think that we should have hotel room size apartments. If you've already limited the maximum unit size to 1,300 square feet, or which was the recommendation by this board, I think that we should set a floor for the unit size as well. And I don't think that, a hotel room is.
So right now, the code would allow, within an existing building that's reconfigured, 400 square feet. But for new construction, it'd be an average of 800 and minimum 550.
Minimum
Oh, so it's already in the code.
I think that's okay.
Okay.
Or
So
I'd
there's
even,
no-
I'd even go 600.
So that's the case, I would say there's no need to then
But
modify.
fine, okay, I'm good with that.
Okay.
all right.
If there was an applicant based on their project that wanted smaller, minimum unit
They
size.
could apply for a
bring-
variance.
Okay.
Well, as long as they still have to fit within the maximum density that's allowed. Those
And that
density-
variance goes to the planning board, or which?
That would go to the Historic Preservation Board.
Got it. Okay.
Could I mentioned before that I don't think, like for Washington Avenue, one size fits all. I think when you look at maybe the southern end, you have Good Time Hotel, the Anglers, taller buildings there. You don't have much 8th, 9th, 10th. Well, the Moxie's there, but in certain blocks, you have sort of smaller scale. And then when you get up to City Center, you have some larger buildings. So I don't think one, when you do this up and down Washington, it makes sense. I think it should be broken down. Maybe certain blocks should, maybe we can go a little higher and other parts of Washington not. I would make a motion that the commission looks at, sort of I don't know how to phrase it, but.
Varying heights?
Well, just heights and FAR.
Just general.
Overall massing.
Right.
Look at different sections of Washington Avenue, whether 2, 3 block stretches, and say maybe this particular stretch warrants a larger building or larger FAR, whereas somewhere else, maybe doesn't.
And just, if I could just give you some context in terms of what would be allowed under a live local application. So since this is all commercial, most of it's primarily a commercial district. This would not, you couldn't do a live local application in the RM2 district, which is a small portion. So a live local application could come in and do, as of right, a 6.3 FAR and 150 feet in height. So whatever we do here today is not going to prevent a
Correct.
live local application.
Yeah, because they bypass all those local ordinances,
Right.
so.
So that's why we think that 100 feet, appropriately reviewed by the Historic Preservation Board, you're not going to find 100 feet at the setback along Washington Avenue. You're typically going to have, maybe you'll have a 2 or 3 floors along Washington Avenue if there's a waiver by the HPB, and then you have like a 35-foot setback for the tower. So we have that built-in step. If you want to, look at those setbacks in more detail, or
That was going to be another motion I make about the not allowing a waiver. It's everything I mentioned before. I'd like to see it. I'd like, let's take a vote on it as a board.
until something, these are all just, out there in terms of incentives. Until somebody comes in with an actual project, I'm sure not everybody's going to want to, follow these restrictions and do a project. So it's going to be up to property owners to want to take advantage of this or not.
Sure, but it's also up to the neighborhood and the surrounding residents to, kind of, I want to say put a check on development, but, be involved in what the neighborhood looks like. I think that's what we're supposed to do up here as a board. So again, I don't think it's a one-size-fits-all for all of Washington Avenue.
So you want to recommend that the commission look at varying heights?
Varying heights and FAR.
I would like to see that no more micro units, though. I would definitely say
There are
no
no-
more
That's
micro
the
units.
whole point of, I
Right,
think, doing
exactly.
this.
Just-
So, yeah, but I mean, as far as that, just look at, and
All right, so go ahead
again,
and make the motion. Go
I
ahead.
would make the motion that the city commission look at different sections of Washington Avenue and I'm trying to think of a way to phrase it.
Considering
And-
varying
And
heights.
consider varying FARs and heights in different sections because the one size doesn't fit all.
Okay, second on that? Anyone want to second that?
Well,
Okay.
sure.
All right, is anyone opposed to that?
I have a question for Michael.
I would be.
Is there a sunset provision
would be.
on this proposal?
There is a sunset provision, yes,
It's
I
5
think
years.
2032,
For
2032.
For building permit or for land use approval?
for a building permit, or I think, let's see. A full building permit by September, is it September?
So the reason I'm asking is, there's only going to be probably in this time period a handful of buildings anyway. And to prescribe certain heights and FARs throughout this 10, 12 block stretch, I think is perhaps stretching a little too far here. I think maybe we need to wait and see even what's proposed by the market, if anything.
Yeah, and then the commission can always, amend the regulations downward, or,
Yeah, I mean, I understand your concern, Scott, but I think realistically, we're not gonna, there's not gonna be 10 proposals coming out, or 15 proposals. So I think it might just be, how do we determine even what is the height for a particular block? Right? If we can barely agree.
We can
here-
recommend, I can go, and
Yeah.
say, you can look at, I think 10th, 11th, 12th, you have more smaller scale buildings. If I'm, 2 and 3 story buildings, maybe those blocks, you shouldn't be able to build 125 feet or whatever the height is now. Whereas city center, you have further up north and further down south, you have taller buildings. They'd fit in.
So I think, Ms. Latone, did you second Scott's?
Yeah.
Does anybody oppose Mr. Needleman's proposal?
I'm a no.
I would. I'm not opposed to Mr. Needleman.
Oh, yes.
He's phenomenal, okay?
Jonathan, you're in favor? Yeah. You're in favor. All right, so 4 are favor, 3 are opposed.
So we'll include that in the recommendation.
Yeah.
And I'll go back to the waiver. I don't think I think with what I'm looking at in these massing studies here, I mean, to me, they're all looking like just large cubes, Washington Avenue, and my fear is that, developer may come in afterward, I need to be a little, or go to the HPD, to make this work, I need to be closer to Washington, or whatever the case may be. So, I think those setbacks, the tower setbacks, or however it's phrased, should be set in stone. I think once they're determined, that's how they have to build. I mean, we're already giving a lot. So, I think that will help to protect the walkability of Washington Avenue.
So you're recommending no waiver for the
No.
setback from HPV?
Correct.
Is there a second on that? I don't see
Okay,
a second.
listen to Michael, repeat it.
This would be, Mr. Needleman's recommending that the HPV not be granted the ability to waive the setbacks. They could still ask for variance, but it wouldn't be a waiver.
I'll support that.
It's a second, then that's a second.
Does anybody else support that?
No, sir.
So that does not pass.
Michael, I think there's, we saw this with another application previously on Washington, especially when you take into account raising of the street, future levels. New projects can cramp the sidewalks. And, there might be an opportunity to increase ground level setbacks and reduce tower level setbacks. And to your point, that increases the walkability, especially with new construction. So, I think if it's done carefully, looking at setbacks, it's a give and take, or it could be a give and take. And we could even make a recommendation. If you are seeking a reduction in the tower setback, then you must increase the ground level setback.
Yeah, I think we don't have enough data on a specific project in front of us. So I think the overarching goal is, how do we accomplish more attainable housing, more, kind of retail activation? That's the goal. If we start to, to your earlier point, if we start to put in these specifics, we're killing it before it even starts.
I'm from that view too. I just think that we have a general guidelines and let sort of the projects, it's not like we won't have a say in any of these projects in the future. So I think we don't want to discourage some of this, the benefits of in attracting some of this investment in that neighborhood. So I understand some of the hesitations, and we all want to make sure the setbacks are sensible. But I think by now, all these boards that are going to be reviewing are going to, are smart enough at this point to make sure we don't do some of the mistakes we did with some of the past
And
developments.
the planning board will, like we've seen for the application that was continued this morning, the planning board will still review projects that are over 50,000 square feet that are large like that. So that would still come to the
Okay.
planning board as well as the historic
All
preservation.
right, that last recommendation failed, so.
Okay.
Any other recommendations?
Just find groups that are ready and willing to help us solve this issue.
So I think at
All in
this point-
favor? Aye.
So was that a motion to recommend with a favorable recommendation, transmission of both ordinances with the consensus items that we identified?
Correct.
Yes.
Anyone opposed to that?
We did a second on the motion?
I'll second it.
Okay.
Goldenov?
All in favor?
Aye.
Anyone opposed? Great, okay.
Great, thank you.
All right, So we're past 11 o'clock, so we're going to go to items 15 and 16. Planning Board File 240708, 6701 Collins Avenue, North Beach Oceanfront Overlay, and 240693, Development Regulations for the North Beach Oceanfront Overlay District.
So before I turn it over to the applicant, I'm just going to do a brief overview of the site and the proposal and just our basic recommendation or concerns for the application. So just in terms of some history of the site, I'm sure that everybody's aware that the former Dovell Hotel was demolished recently. It was constructed originally in 1956 and designed by noted Miami Beach architect Melvin Grossman in the post-war modern style, and was designated as contributing within the North Beach Resort Local Historic District. Now back on, it seems so long ago now, on July 25th of 2017, there was a fire in the Dovell's electrical room, and the city took extensive action to attempt to ensure that the building was not demolished by neglect, through enforcement action by the building department and by filing suit to attempt to force the Dovell to meet its obligations with respect to the 40-year building certification process and pursuant to a 2018 Unsafe Structures Board order. One of those obligations was for the owners to submit a structural condition assessment report from a licensed engineer. After years of enforcement action and litigation, this structural report was submitted by the city, and unfortunately, the report, which was verified by the building official, made clear that the building was unsafe and could not be saved due to structural defects, and the building was subsequently demolished on November of 2022, almost exactly 2 years ago. In terms of this proposal, like I mentioned, for the Washington Avenue incentive ordinance, this proposal requires the 6-step process. Today is just the first step in that process. After today's meeting, there is a public workshop scheduled for, I think it's December 17th. After that, there will be a second review by the planning board at either the January or the February meeting. Now, again, this involves a proposed overlay for the Dovell site at 6701 Collins Avenue. This proposal includes up to 400,000 square feet of additional bonus floor area, which would equate to an FAR of 5.5 for the property compared to the current maximum allowed of 3.0. Additionally, the applicant's proposing up to 200 feet of bonus building height, which would result in new towers at a height of up to 400 feet. We've included the proposed modifications to the setback requirements on page 6 of the staff report. Other proposed amendments, which I'm sure the applicant will go through in detail, include modifications to the allowable encroachments, reduction in the off-street parking requirements, the allowance for subterranean parking, and for mechanical parking without review by the planning board. Lastly, they're also requesting exemption from the requirements of the long frontage standards. Now, in our staff report, we mentioned that we don't object to the concept of what's being proposed, but we did have some concerns in terms of the level of detail that's been provided so far. We did note that there's some discrepancy in terms of what actual square footage of the Dovell site was previously. We have an application to the Historic Preservation Board from 2013, which indicated that Dovell had approximately 309,000 square feet. The applicant's now indicating that there's approximately 500,000 square feet of that was existing on the site prior to its demolition. So I do believe that we need to have more accurate FAR drawings to establish what is the baseline of FAR for reconstruction in terms of the maximum bonus. We also believe that the massing study provided is inadequate with one simple axonometric drawing. We do believe that much more detailed information should be required, similar to what we saw last month for 1250 West Avenue, where we had more contextual renderings and elevations of the building and site. We also believe that in terms of the long frontage standards, those are put in place to have the long-term resiliency of a site, and especially when you have a frontage here of, I think, around 500 feet, we do believe that those frontage standards should be maintained, or at least we should have details to show which frontage items and which resiliency standards cannot be complied with. We do believe that additional information is required to support the tower setback on the south side. 50 feet is required now. They're proposing 30 feet. We do believe that the board should be reviewing the footprint of those towers in conjunction with any sort of setbacks. And we do believe that since the site is vacant, there's some opportunity to push and pull in terms of the setbacks for the reconstructed portions. We are recommending that they provide at least one grade level pedestrian access point to the beach. So we are recommending that the board review the proposal, take public comment, provide any recommendations, and we do think that the board should continue this application probably to the February meeting to provide the applicant more time to respond to the comments today, as well as any comments that are provided at the public hearing, the public workshop on December 17th. At a minimum, we would require any sort of updated plans be provided no later than December 20th if the applicant was going to continue this application for the board's review in January. Well, I'll turn it over to the applicant for their presentation.
Hi, David Martin, 3310 Mary Street. Thank you so much for being here today and doing everything of what you do for our city. I'm really excited about what you guys are going to see today. I think North Beach has so much opportunity, and I think this property is truly a vital piece of the revitalization of North Beach, and I'm excited to be working with Alan Schulman, local architect that's really probably an expert for us on the reconstruction and replication of the Deauville Hotel. I think our firm really feels that's something that could be really positive for the city and the community, and also to celebrate our heritage. And also we have Foster and Partners that are going to be also working with Alan on the project. So today, without further ado, just wanted to say hello, and I'll be here to answer any questions. And obviously we have Michael and Nick here from Burke Albert that can answer a lot of questions as well. But with that, I just wanted to get Alan to do a quick presentation. Thank you so much. If you could pull up the presentation, please. Sorry.
Good morning. Alan Schulman with offices at 7300 Biscayne Boulevard. I'm very pleased to be here today on behalf of Terra and our team. And I'm going to start by telling you a little bit about the baseline of the project, which is the reconstruction of the hotel. And just to give you a sense of our team, David described my office. We've been in Miami for 3 decades, and our office is about 28 years old, working primarily in Miami Beach, but also in Miami and in a few other municipalities as well. Foster and Partners is a well-known, you probably already know them, so no need to describe, but starting with Norman Foster, they've really made a mark on the history of modern architecture globally, and it's great to be working with them. And our architect of record is ODP, a very professional firm that we've all worked with as a team before, so we're really excited about working together on this project. So I'm just going to start by with the site and with the history. You all know this site, I know, but at the end of 67th Avenue, the Deauville really played an important part in the development of North Beach as a resort district, and Collins Avenue as a resort corridor. And it fit in at one point with, the Sherry Frontenac and with the Carillon and a number of other resort hotels. But it's also kind of an important placemaker in this particular part of Collins Avenue with its retail across the street and areas behind. It's a little different than the areas to the north and to the south. One of the interesting things about this site is the layered history. It's not like a single history, it's many histories. And that history begins with the McFadden Deauville, which was built in 1926 as the first resort hotel in North Beach on this exact same site. And then, like before the hotel celebrated its 30th birthday, it was demolished to make room for a whole new idea of resort hotels, which was the Deauville Resort and Hotel. The architect was Melvin Grossman, an architect who has done hundreds, maybe thousands of buildings in the Miami area, and a very important architect of resort hotels. I won't go into the details, but like the components of it were really standard components for the post-war big resort hotel like the Fontainebleau, the Eden Rock, et cetera, the Seville. You had the big pedestal, you had the tower, you had the big porte cochere, you had the great lobby entrance, and all that is present here. And the hotel was kind of, it really presented a kind of a glamorous mid-century idea when it opened, and we are right now in the process of bringing that back and also reinterpreting it for the 21st century. So here in this view, this kind of aerial view, you see one important, or two other important aspects that you couldn't see from that frontal elevation. One is the size of the pedestal. These pedestals were huge because they had all these big ballrooms and, theaters, and it's a landscape up there, and it was just an asphalt roof before. Our intention is to re-inhabit that pedestal for new uses, but also this pedestal is kind of the starting point for new development that will happen on top of the pedestal, leaving the other element that you see here, the pool deck garden, to be free and open and to continue its role as a garden. All the images that you see here, the kind of iconic images of the Deauville will be reconstructed. The main entrance court with its parabolic porte cochere, the very dramatic tower with its curtain walls and eyebrows, the pool and pool deck area, not the pool itself, but the pool deck area as an area of the building, which more than most hotels of its type was kind of enclosed on the east end by this kind of screen wall of an oceanic deck, which provided some really iconic imagery. And the history of the Deauville, which is also really, let's face it, it's global history, John F. Kennedy, the Beatles, et cetera. This will all be reinscribed into the history of the new building. We're basically weaving that history into the arts and the story lines of the new building. So as David mentioned and as Michael mentioned, the building had been demolished in 2022. It exists now, basically in our collective memory. And the starting point of this project is the reconstruction of the Deauville. And here you see all the same components of the Deauville will be reconstructed, the pedestal, the tower, the garden area, the porte cochere, et cetera. And so here is a view of that entry court and the porte cochere, and you can see that we paid a lot of attention, a lot of detail to making it right, to making it authentic, and to bringing back that spirit of the post-war resort hotel. Now on the inside, we're also taking the same approach to being very serious about the authentic recreation and redevelopment of these spaces. So here you see the original plan with all those really huge rooms, and basically our approach is to basically adaptively reuse all of them. The lobby is basically being fully reconstructed. All the other rooms are being reconstructed, but with some new inventive touches that bring it into the spirit and usability of the 21st century requirements. Also at the northeast corner, what you see in orange is a former back of house area. It was 3 stories of back of house with a stucco wall facing the beach. We propose to open that up with a new terrace. So when we're done, the ground floor, or the main floor of the Deauville will be a suite of great public spaces, really capital public spaces that will all connect with each other and will be sort of the baseline for bringing in a first-class operator into this. And just to give you a sense of some very preliminary perspectives of some of these spaces, this is the grand stair leading from Collins Avenue pedestrian entrance up into the lobby. This is the lobby itself, which spans from Collins Avenue to the beachfront or to the garden, which you see on both sides, so it's kind of sandwiched in glass. This is the Casanova room, which was a kind of a dinner theater. We're reinterpreting it as an atrium. It's being recreated, but reinterpreted as an atrium, a green space that brings light down into what is otherwise a very dark pedestal space. And then one of the really cool features of the building was this space called the Peacock Alley, which had this zigzag glass wall which looked down on the pool. And it is also being recreated, but with a new element, an atrium that comes in and again brings more light into the space. And with that, I'm going to pass to my colleagues at Foster, if they're on.
Oh, yes. Yes, Erda Fierro.
Thank you.
Mr. Chairman, would you like me to give them another, 10 or so?
Hello, can you hear me?
How would you like me to set the timer? Yeah, okay.
Go ahead, you can go.
Thanks very much. The site is bridges the gap between the beach and Collins Avenue, and of course the beach was the reason for the creation of these resort hotels like the Deauville, but we've paid special attention to the public realm, to Collins Avenue, and we tried to tap into the transformed city from what was there in the 50s to today, and actually enhance it and provide spaces, quality public spaces for the pedestrian. Next, please. So you can see on this slide in orange the historic public space towards Collins and the black line that defined the historic facade. And in the next slide, you can see how we are widening the sidewalk and effectively creating a new space, a plaza that goes beyond being a buffer from Collins, but a real public space of quality. Next, please. On this slide, we can see a photo from 1964 with a narrow sidewalk with the ballroom hovering over the sidewalk with a strip of retail facing Collins Avenue. And in the next slide, this is our idea of how we could transform this space, pushing the retail front back and allowing for a boulevard with shade and green to emerge with a very, very light presence of vehicular drop-off and activated. And in the next slide, as we move into the space within the volume of the historic building, now doubled in height, we use this not only as a spill out for food and beverage and retail, but also as a way to solve the problem of raising the ground for resiliency. The next slide. In addition to this response to Collins, as a response to Commissioner Bart's suggestion and developed together with staff, we designed this concept for a south beach walk on the south side of or along the south boundary of the site. Next slide. From looking out from Collins, we thought, well, on top of this idea of connecting the two, the beach and Collins Avenue, could we turn this into a space that actually has its own value and adds to the sequence of the public realm? We could include art and history in the walk. The next slide. And as the path widens, we could create spaces for people to use, for there to be a cafe or a space for the community. And in the next slide, as we look now with our backs to the beach, looking west, we can see that this path widens enough that it becomes an inviting access and connection to Collins with a life of its own. And we've tried to respond in a similar way. Alan, if you want to describe the north path.
Sure. So, again, Collins Avenue in this area is kind of known for its pretty narrow sidewalks. That intention of widening the sidewalks, widening the public realm, it continues all the way from the south to the north. So on the north side, just in the same way as we're doing the south side, we're kind of pulling the public realm into the building, into the ground floor. And this is also improving the resiliency of the building. And then another element of what's happening at this point is that staff also asked us for a second public access way on the north side because the site is 500 feet long. So this is a complex maneuver because the north end is where we also have our service entry, our truck docks, our vehicular entry, et cetera. So we've come up with a plan to basically bring the public realm over the top of that. So we have We have a stair from that public plaza on the north side, which you see in orange there, that would go up. There'd also be an elevator, bring you up to this kind of High Line type structure that would travel across the north side of the building and down a grand stair on the east side to the ocean. So this basically creating a mirror to the south on the north side of the building and basically allowing circulation to run around. And the character of that would be trellised and green and public, and you know, there could be a connection to the hotel. And then as you arrive on the ocean front back, as you come back to the beach walk, you would have a, this is the area where we reconnect with the beach walk, which is very close to the building here. And we've created a terrace in what used to be the back of house, the 3-story back of house, which you see in the bottom left photograph, you know, kind of a big solid wall, basically opened back up to create more public and private amenity, both. And then at the south end of the beach walk, you see the continuation of that oceanic deck, that terrace, that was a historic element of the building, but is now more perforated. And on the left-hand side, just to bring it back, you see the connection to the South Beach accessway. Do you want to take it from here, Eduardo?
Thanks, Alan. So effectively, on all 4 sides, we have a connected public realm. It connects with the existing public footpath, and it really creates a porosity at an urban level. Next, please. So we also looked at the center of the site, at the main public open space of the site, what used to be the pool deck. And in the next slide, we think that there's an opportunity to bring in the ecology of the dune into that space and create a real heart of the site, which is open to a wider audience. Next slide. So in this view of the historic pool deck, we can see a presence of hardscape, an absence of shade, and the architecture very much in the fore. We think that attitudes have changed. So in the next slide, you can see how this space could be transformed to bring in shade and bring it passive cooling, and even you know, extending the area of permeable floor, bring water down to the aquifer. So the next slide. The main addition to the site is the residential component. And in the next slide, you can see what it would mean to condense all that in a single volume. It became apparent very quickly that if we split the volume, as we show in the next slide, we have a much more sympathetic result. In the next slide, as these 2 elements split, gaps appear between them and the hotel, which are really very similar as the rhythm that you can see along this elevation from Collins Avenue. And the slimness of these towers really is much more in tune and sympathy with the rest of the buildings along the skyline. On the next slide, this section from Collins Avenue to the water shows what the opportunity, or what this separation of the 2 towers actually brings to the pedestal. It brings the opportunity to bring daylight and the breeze through the building. In the next slide, you can see the arrival from Collins Avenue going into a courtyard, a green courtyard in the middle of the pedestal, what used to be the dark space of the ballroom, providing a quiet access for residents. The next slide, the space shows this connection to the room above, which becomes the Napoleon Club, one of the suite of rooms of the hotel, and below grade there would be a drop-off for residents that is also daylit, as you can see in this slide, providing not only a really discreet arrival for residents, but also relieving the pressure from the ground floor arrival on Collins. The next slide. In order to achieve this, some structural gymnastics are required. Bringing all the columns to the main core of the building means we can respect the historic lobby, create this new club space, and really reduce the footprint of the towers on the historic pedestal, respecting the contours of the original building and the relationship between the 2. In the next slide. And providing this providing this possibility for spaces in that old, what used to be the ballroom. The next slide. So now looking from the water, we can see, this sequence of buildings along the skyline and the gaps between them, think that the two additional elements really work in sympathy with the rest. I think that's all. Over to you, Mike. Cool.
Hello? Great. So Michael Larkin, 200 South Biscayne Boulevard, representing the applicant. So when you combine the obligation to reconstruct a historic hotel, and then you merge that with building 2 residential towers, and you try to travel under current zoning regulations, it's like trying to fit a square peg into a round hole. It just doesn't work. So what we do is we create our own zoning district. It's an overlay zoning district. So the RM3 zoning remains in place, and the RM3 land use designation remains in place. But what you do is you create a brand new zoning district. Here it's called the North Beach Oceanfront Overlay District. And this first slide is the comp plan ordinance. The comp plan is meant to be more broad in its nature of regulation. You have to put in there any difference in floor area. So here we're asking for 400,000 square foot bonus to reconstruct the hotel. The comp plan ordinance also is what regulates density, so we're reducing our density to 75 units per acre. We're also voluntarily agreeing to lower the hotel unit count to 280 units and reduce the accessory use square footage down to 35%. And then the HPV would be in charge of the substantial reconstruction. We have to get a COA for demolition design from the HPV. Next slide. So this is the zoning ordinance, and the zoning ordinance is more detailed. If you travel down the left-hand side bullet, so it would authorize new ground floor additions no more than 30 feet in height. The zoning code right now says the minimum driveway width has to be 22 feet. We're asking for 20 feet. We don't need 22 feet. And then in order to achieve our FAR and do the 400,000 square feet, we have a series of requirements that we have to meet. That's a bonus structure. We do that for a variety of reasons, but one reason is that if you use a bonus structure for height and FAR, then any developer wanting to use Live Local Act can't use your property as a precedent by which they can base their development program on, because the way the Live Local Act is structured, if you use a bonus system to achieve your FAR and height, then it's unavailable to a Live Local Act developer. And again, we're asking for a height of 400 feet. We're modifying some of the setback encroachments in order to actually reconstruct the Deauville Hotel. We're asking for a parking exemption for all the uses within the reconstructed building. This is no different right now under the code. There are no parking requirements for any uses within an historic building. We're asking that mechanical parking be approved on an administrative basis. Next slide. And then with regard to the traffic study, as you all know, if we traveled under current regulation, we could build almost 1,000 hotel rooms. So based upon the limitations we're seeking for our density and for our hotel unit count, actually on the weekends, which it can be very busy in this stretch of Collins Avenue, we're having a reduction of vehicle trips to 379 on the weekend rush hour, which is approximately from 4 to 8 when people are trying to get to dinner or go to Bal Harbour shops or whatnot. Next slide. So with regard to the community benefits, we're prohibiting short-term rentals within the residential towers. There's going to be a tremendous economic benefit to the surrounding businesses that have been suffering since the Deauville Hotel was demolished, and we're providing our public access beach to the beach walk that Eduardo and Alan ably described. Next slide. And of course, when you reduce your density and reduce your hotel unit count, then every impact upon city infrastructure is reduced, starting with water, sanitary sewer, solid waste, our student population, potential, of course, goes down, and the demand on city recreational areas, of course, is reduced. Next slide. I don't know, David, if you want to, you're the numbers guy?
Yeah, real quick, David Martin again. One of the big things about this project is there's different types of development. We have some that are higher impact, more density, and they maybe provide maybe less taxable value. In this case, this development would be a really low impact, high value. So when we look at that, the incremental tax revenue from this project is going to be significant. If we go to the next slide, maybe, you could just see here two things. One, through the life of the CRA, if obviously, hopefully, we're able to build this and move forward, we'll be able to contribute around give or take, the number's around over $300 million net to the CRA over the life of the North Beach CRA. And so a lot of our vision has been not only about our site, but we're also thinking about the rest of the district and how we could greenify the neighborhood, how we can make it more walkable, and really, really thinking about Harding as well. So we really think that the incremental tax revenue, we probably will not be doing the 280. I think in our hopeful, this is a long process, but, we're targeting around 150 keys in our target program with the hospitality partners that we've been interviewing and working with. So it's actually going to be less density. And then our residential count will probably end up around 120 residential units. So just believe that this is a low impact, low traffic, low infrastructure, and also we're going to be investing in a lot of stormwater management, not only for our property, but we're going to be over-designing for the neighborhood. But anyways, just wanted to share that with you. Thank you so much.
And that's it, Mr. Chairman. We're happy to answer any questions.
Good timing. Okay. I just want to say preliminarily, the project looks beautiful. You've got a great team. David's a tremendous developer. You guys are all a great team. So I'm happy the team's been assembled if we can work out the details. So with that, we'll open it for public comment. Are the people in chambers to speak on this? Well, sir, I'll give you next. This lady had already started coming up. And everyone that comes up, please identify yourself, introduce yourself with your address.
Yes, good morning, everyone. My name is Sandra Cosola, and I live at 7451 Harding Avenue. My family and I, we've lived in North Beach for 32 years, and we also coincidentally lived in the DeVille for a period of time as well. And so when the DeVille disappeared, that neighborhood and area was greatly affected, including the local businesses that are still unfortunately affected by the DeVille not being there anymore. I myself, when I pass by there and I see that vacant lot, I get a little sad and a little nostalgic. And I'm hopeful with this project that is being proposed because it would bring the daily foot traffic that I used to witness when I lived in that area. And also it would greatly help the local businesses and local cafes and restaurants. And it would bring back families that would go to the beach and go to these local businesses and cafes and restaurants. And it would revitalize the area again. Because when the DeVille left, that area is just missing something.
Were you happy with that presentation?
I was. It was great to hear that they're going to do certain things that are going to resemble the DeVille, the former DeVille, but also with new improvements to it. That'll match as obviously as the years gone by, changes occur. So I'm very hopeful with this project. I really hope that it will bring back the energy that was lost when the DeVille was demolished. Even when it was demolished that day, I couldn't bring myself to witness that. Because my family and I, when we lived there, we have some very nice memories of when we lived there and when we lived in that area. And so I hope with the board's help, this project will be approved and North Beach can move forward.
Thank you. Appreciate your time.
Okay,
Sir?
thank you so much.
Good afternoon. My name is Ira Sussman, 6565 Collins Avenue. I'm here today with my brother and my father. My dad was in the Miami Beach Veterans Parade last week, and thank you very much. We're the owners of the Sherry Frontenac Hotel, which is the property just to the south of the Deauville property. and we've been faithful stewards of that property for over 50 years. We support the redevelopment of the Deauville property. We thought it was a beautiful presentation. I just saw it today, just like you did. And as you can appreciate, it is a large property, and as a vacant site, it is not a positive impact on our neighborhood. So we support David Martin and the development effort, and hopefully it'll be a success. We also want to encourage this board to take a more global view of the neighborhood, of the North Beach Oceanfront Historic Resort District when considering this legislative proposal. The legislative proposal should inure to the benefit of the historic hotels as well that are in that district, as well as to those that replicate significant elements of those historic hotels. One other thing I'd like to raise, we're planning to develop on our Sherry property, and looking at the legislative proposal, as it was mentioned, the Deauville is a very wide property. It's 500 foot wide. And there are issues about side yard setbacks. And we would appreciate that they could move as far away from us with their new towers as is feasible. So that we saw in the presentation, they proposed one large tower, and then they divided that and moved the southerly tower closer to us. I was looking at the legislation, the proposed legislation, and it says on page 10, I have the November 8 version. It says an enclosed loading and/or raised public beach accessway may be set back 0 feet from side property lines. Now, I don't know if this is the ultimate resolution of side yard setbacks, but it continues and says a raised public beach accessway or screened enclosure may be constructed up to 40 feet in height as measured from base flood elevation plus minimum freeboard to the top of the railing. And it goes on to talk about other elements that could be in that district, in that area. So we would encourage that there be side yard setback and that they can't build a 40-foot structure right up to the property line. Having said all that and realizing that my time has expired, I just want to say that overall we are supportive of David Martin's effort. Thank you.
Thank you. And thanks to your dad for your service. Okay, who's next?
Good morning. My name is Dominique Vassos. I live next to the Deauville site on 6067 Collins Avenue, and I'm a local real estate agent as well. And so I'm confident that this project we've been discussed today is one we need really to continue to move forward. I think it makes this project so exciting, and it complements really the character of North Beach. And it's a kind of project we bring a long-term value, attracting new buyers, renters, and businesses. And so it will improve tremendously the neighborhood, and I think this is very important, it's what we need right now. And so the floor plan they propose and the height would fit beautifully into the neighborhood in that site. And by preserving the Deauville iconic charm, our neighborhood will benefit from the aesthetic and functions. And so Terra is leading this project, and they understand the history and purpose of the space of this project. So from increasing property value and we renew the energy of our neighborhood. So this project is exactly what North Beach will need. And so we hope the planning board will approve this project, and we look forward really for this exciting project and for the future. Okay, thank you.
Thank you. Anybody else?
Hi, my name is Sherry Rubin, and I live at 1615 Pennsylvania Avenue, and just celebrated my 6th year of Miami Beach being my chosen home. But my love affair with Miami Beach began a long time ago when I was a little kid, and every single spring break we came down from Milwaukee to Miami Beach, and my family spent lots of time at the Deauville. And I have a lot of warm memories, as do some other residents. So I'm extremely excited by this project and the wealth of opportunities that it brings to the North Beach community, because I was a firsthand witness to the decline of that property, and it was so sad. And to see it become just a gaping, ugly hole was really kind of heartbreaking, especially given the history of that iconic property. So in any case, having heard the presentation, I'm even more excited by the potential for amazing opportunities to build community and provide beautiful green spaces for families and residents of the beach, because that's what I want to see. And having said that, I would also add and feel even more optimistic about this. I hope we can all work together to continue to increase accessible housing for many different types of families here on the beach, because I believe with all my heart that adds to the vibrancy and attractiveness of this community. So I too hope that this project receives support going forward, and I'm very excited to see what the finished project is actually going to bring to the community. Thank you.
Thank you. Ma'am?
Hi, Janet Silverman. I live at 6899 Collins Avenue, which is the Carillon, which is directly next door to this property. And I just want to say, first of all, I've been to a lot of these meetings where proposed development is on the table, and I've never seen one where there hasn't been somebody that came up and said, we hate it, don't do it. So, well done so far. Tara came and presented at the Carillon, and there were probably 150 people that attended, including many of my neighbors. And I just want to say that I've had discussions with a lot of my neighbors after that meeting that attended it, and basically to a person, everybody is very supportive of this, at least who I've spoken to. Obviously, I haven't spoken to everybody, but the neighborhood really needs this project or a project to be done there. And I think this project, with its rebuilding of the Deauville and the way it's imagined, is quite a tribute to the neighborhood. Thank you.
Thanks. And if I understand, Michael, after this meeting, there's going to be a second public outreach meeting, right?
There's going to be, yes, a community meeting on December 17th at 5 p.m. via Zoom.
Okay. Anyone else, sir? Sure.
Good morning. My name is Guillermo Garcia Tuñón. I'm 6767 Collins Avenue, which is Sterling, which is the second property north of the Deauville. And we're very glad, I am very glad that the property is being developed. But there's only two things that I would request to be taken into consideration. Because I hear a lot of conversation saying we're replicating the Deauville. There's a couple of things about
I think preserving more,
well,
yeah, part of it.
But I've heard replication of the Deauville.
Yeah, yeah, okay.
And as far as I'm concerned, that the Deauville, the way that it was located in the site, it was, I don't know what setbacks it had, if any. The tower was almost at the boardwalk. That I hope that they respect the new setbacks required by the city. It affects our building, and actually the building that's going to be, the hotel is going to be built next door. The fact that if they put the big tower all the way down to the boardwalk or minimal setback, it affects the view for all the residents over there. So again, setback in the, at least on the east side, the rear of the property,
I think it's very important. Secondly, if they're going to replicate the Deauville, the north facade of the Deauville was not a particularly pretty facade. It was just a wall with windows. It would be nice if they would consider maybe doing some applications of the north facade so it's a little more attractive than the Deauville used to be. That's all I have.
He's nodding his head yes.
I know
And I also encourage all of you to participate in these public meetings, so you'll get more information, but thank you.
All right.
Appreciate your thoughts. They're constructive criticism. Anyone else in chambers? Okay. Michael, is there a lot of people on Zoom?
We have 6 people on Zoom.
Okay.
5.
Hi, Tom Richardson, 6450 Collins Avenue. I just want to say I'm president of our condo board. I'm a founding member of the Allison Park Neighborhood Association, which is the association from 63rd Street to 71st Street encompassing this project, and I'm also a member of the North Beach CRA. I'm here speaking on my own behalf, but I have a long history of being involved in North Beach and trying to improve it. Since I moved up there 10 years ago, I've been a reluctant activist trying to promote the revitalization of North Beach. There's an old saying that justice delayed is justice denied, and I am applying that to North Beach because it's been revitalization delayed is revitalization denied. It's been years and years and years of struggle to try to pull North Beach up. And I want to put this project into the context of all of that, going back to Ocean Terrace, which were over a decade waiting for that to be developed. The 72nd Street Community Center, which was approved a long time ago and looks like it will be denied and killed. We had the town center, which is still not have its first project, although it's very close to be CO'd. We had a previous project here that was voted down and delayed. This empty lot has left a psychic and a literal hole in all of North Beach. It's the center of the development. It not only is a spectacular project, and I applaud you guys because it's somehow you managed to make it way better for the community than what existed there before. The public-facing amenities from the beach walks and the cafes, and it'll have the best views of any hotel because it will see the ocean from the lobby. So it's really spectacular and will be amenity for anyone who lives in the area. Just to be able to see it is great. It also is no longer a dead hole of retail on Collins Avenue that used to be where the Napoleon Ballroom was, and it was just a concrete block for the most part. So that's really fantastic. But the ripples do not just go, the effects of this are not just on the 67th Street Deauville site. You saw the money that goes into the CRA. It will have wide and far-ranging benefits for every aspect of the community in North Beach. $350 million in benefits that go into the CRA, and the CRA needs funding for, it's part of the mandate that it has to, part of the money has to go to affordable housing. So people might say, well, it won't help me at all because I'll never go in there and have a cocktail at the Deauville, but it will. It'll make the sidewalks better, it'll make the green space better, it'll make the affordable housing more efficient all throughout North Beach. Besides being a spectacular project, it will lift up all of North Beach, which has been delayed for years and years and years, back to the original plan that was almost 25 years ago that Roger Aberson showed me one time. They've been trying for decades to fix this area up. This project will go a long way to doing that, and I support it. I hope you will support it and move it along so we're not delayed even further. Thank you.
Thanks. Anyone else in chambers? All right, let's go to Zoom.
Okay, the first person on Zoom is David Sexton.
Hi, this is David Sexton. Can you hear me?
Yes.
I'm on the CRA board as well. I'm on the GeoBond, and I'm the president of the Normandy Fountain Business Association. And that's really what I want to speak to today. We've talked about the Deauville being demolished 2 years ago, but it closed 7 years ago in 2017. And as a brick and mortar business owner and someone who leads brick and mortar business owners that are all mom and pop shops here, it was devastating to the North Beach economy. The Deauville brought in hundreds of people who were fresh to North Beach every day as hotel tenants, and they were discovering things. They were shopping in our stores. They were frequenting our restaurants. And when it shut down, the ripple effects on the economy were devastating, and we're still struggling with it. So, as many people have pointed out, there's been a hole in our community for 7 years now. And I think that this recreation of the Deauville is the best scenario that I have seen thus far. And I love the idea of it coming back. I love the Deauville. And I hope that this project moves forward.
Thank you. Next.
Our next caller is Gloria.
And Gloria,
Yes,
please
good
state your
afternoon.
full
Can
name
you
for the
hear me?
record, Gloria.
Yeah, my name is Gloria Masuera from 5750 Collins Avenue. And like the rest of my fellow residents, I'm very happy to express my excitement about this new project in North Beach. The renders are fantastic, and the benefit to the community of being able to access the beach from the property is something that we always wanted to have. The design is much softer impact than other potential development proposals, and I look forward to for this development to happen. So thank you very much. Great job in keeping a lot of the history alive and bringing something back to North Beach.
Thank you, Gloria.
Our next caller is initials DB.
And please state your
Hi, my
name
name
for
is David Borg. Do you hear me? Hi, my name is David Borg, residing at 6301 Collins Avenue. I lived in North Beach for about 3 years now and am in favor of this project. It will definitely help the retail, help the walkability, reduce crime. I think two things is we have to make sure that not only does this developer benefit, but all developers and future developers in North Beach should benefit. Additionally, looking at the massing study that was provided, I think we just need a little bit more work to make sure that there's clear and obvious setbacks. So future development's not hindered, light and views, so we don't turn into another Sunny Isles. Make sure that it's open and airy to all developers and other sites as well. Again, super supportive of this project, very excited to see it happen. Thank you.
Okay, again, I'm just encouraging everyone to participate in the community outreach. Thanks. Who's next?
Next caller is Nicole Ochoa.
Hi, my name is Nicole Choa. My address is 1426 Bay Road. This Delvaux redevelopment is an exciting update, to this location. The beach access that they're proposing is exactly what this community needs, and I'm looking forward and grateful that they're trying to engage with the community and give us what we want. I hope you guys can support this project and vote to approve. Thank you so much.
Thank you.
And our last caller on Zoom is Jimmy's iPhone.
Jimmy's iPhone. I knew iPhones listened. I didn't know they could speak. Jimmy? Maybe you're on mute, Jim. Still there?
Yeah, Jimmy has his hand raised, but he's on mute.
Jim, we're going to give you 5 seconds to turn off mute. All right, we got to move on. Anybody else? Okay, Daniel.
Actually, we
we're-
have, well, after Daniel, there's somebody else now.
All right.
All right, thank you. Daniel Serraldo with Miami Design Preservation League. I won't bore you all with the 10 plus years that we've been involved with the Deauville, or the fact that 15 years ago, the owners got approval to reconstruct and build a new tower at 200 feet. We're not there, we're here today. Unfortunately, there's been a lack of leadership in that neighborhood with some of the property owners. And I wanted to thank the Sussmans for the Sherry Frontenac, who have actually maintained their property, unlike the owners of this current property. I also know the owners of Urbanica are here as well. And so I do think that some thought needs to be given to, if we do this, what will be the impact on the rest of the community. The other thing is that we reviewed the project with Alan and the team. before we got the staff report. So I'm going to first talk about the concept of the reconstruction. We, our advocacy committee met with the Foster team, and they even flew a model in from London, and it was really fun being with our experts and theirs, looking at all the different possibilities. And so we had a threshold that we wanted to first decide, which is, do we believe that there's a public benefit in reconstructing the Deauville? Because oftentimes historic buildings are reconstructed poorly and they don't really have the benefit that they should. But we felt that in reviewing all the details, that urbanistically, this new project was maybe even better than the original. Things like having the restaurant on the upper floor. You know, when the Deauville was built originally, the back wall on the east was right on the ocean. So that was before the boardwalk. So there are many things. The beach access on the north and the south is amazing. There's so many good things about the project that we like. And so the committee did decide that they endorse the concept of the reconstruction of the Deauville. As far as a new tower, the proposal we saw was actually higher. And so they did take our feedback into consideration. And now the new towers are proposed at 400 feet. We haven't yet reviewed, though, this latest version, and we're glad there's going to be public meetings about it. But we did recently find out at the staff report that there's a question of, I don't know if it's 300,000 square feet of how large a Deauville actually is. And so we think that we really need to know that information in the future meetings, because if the Deauville is 200,000 square feet less, then that would mean the new buildings also go down. So I think, you know, we definitely want to get that correct information. That's obviously going to seriously impact the size of the towers and the setbacks. So overall, though, if you compare this to the prior owner, the prior developer who came and denied that it was historic, now we're sitting at the table meeting with a local developer, I think we're in the right direction. So thank you.
Thanks, Daniel.
Okay, we have two callers. We have Jason Mamane.
Jason?
Yes, hello? Yes, hi. My name is Jason Mamani. I'm currently an owner of Norman's Tavern, located at 6770 Collins Avenue. And we're really looking forward for this project. I think it's going to bring some life to the area. For the past 5 years, it's been it's been a little dark in the area. Another solution they're bringing, I think, is parking. There's not much parking in the area. The project looks beautiful. There's beach access. I really, really hope you guys can go ahead and approve this. It's going to be a very, very big plus for our little North Beach area. I'm also a resident of North Beach, so I would really want to see this moving forward.
Thanks,
Thank you
Jason.
for listening to me.
Thank you.
And that concludes our callers online. So I would suggest, if nobody else is here, that the board close the
All
public
right,
hearing.
no one else in chambers, right? Okay, we're gonna close the public hearing. Questions, comments?
I've got,
Sure.
first of all, I mean, when you take kind of first proposal, second proposal, it seems like, you know, the first go around was just you all listening to all the public feedback, so you can come in and really kind of incorporate everything for hopefully a much more seamless process. I mean, really doing the outreach you hear about, meeting with the associations, nearby community organizations. So hats off to you all. I think hopefully, you know, you've kind of done a lot of the groundwork on the front end, so you don't deal with, again, hopefully the outcry on the back end. Incredible project. Loved your term greenify. Hope I can use that going forward. But I mean, it seems like really we've only heard two comments, right? How can we kind of include it going forward to create a real district, not just for one project, and to work on the setbacks? So I guess I would ask, whether it's you or you know, David, what can we do to either A, work on the setbacks, both from beach kind of access and also the side setbacks? And also what can we do, I guess it's a question for city staff, to include this kind of, you know, whether it's the neighboring projects or, you know, call it a few blocks, whatever it might be, to really create a real district to incentivize further development. So first question for you all.
Also second that.
amen to that, I'll make a motion. We could be quick.
I mean, you know, look.
There you go.
What I don't want
You
to
know what,
see.
sit down.
What I don't want to see is, you know, come back and come back and come back and just, you know, let's just cut to the chase, tell us what we can do, and let's.
Yeah, I mean, honestly, this is
This is great.
This is a city redefining project, and it's monumental. I mean, how often do you have a project with increased FAR, meaningful development, and there's so few people coming out? I mean, Danny was somewhat positive. Look at the smile on his face. I mean, this is crazy.
That was amazing, really.
I almost fall out of my chair.
It's just, it's a shot in
Honestly,
the
so
arm.
it seems like there's two things.
So let them answer. Go
Yeah.
ahead.
So, Mr. Chairman, we could go and answer all your questions one by one, or we could write them down, absorb them. When we come back in February, we could have everything, you know, in sequence. And I don't, because we've been here now almost hour and a half, 2 hours. I don't want to soak up your whole day, so I want some direction from
Listen,
you.
I agree. You're going to be coming back, and you're going to have. There's a whole process outlined in here. So, yeah, I mean, I think what the goal here would be is for the board to give you their thoughts and comments, and then you know, marinate on them, meet with the public, and then happily come back with all the answers.
That's fair. Like, in other words, I'm sure there'll be other questions. If I were to make a motion now, I'd say passes with a favorable recommendation with the goals of A, seeing how we can work on the setbacks, and also to include an entire district.
So this is,
Yeah, we're not voting today, right?
No,
I didn't think so. Oh,
That's why I
okay.
said, if
Got it,
I
got
were
it,
to
got it.
make a motion,
Yeah.
that's what it would be. Don't get nervous, Michael.
That's why this is more like informational today. So, I mean, I want to absorb all your questions, and we'll come back with very precise answers for everything.
And I'd like to say something. I don't know if it's of any concern to you, but I asked for the following information. The Akoya is 460 feet tall. It is super dense. It had a 4.5 FAR, and the Carillon is 400 feet tall. It had a 4.5 FAR, and at the time, the code allowed for a 6.0. A lot of the, you know, people in North Beach have waited and waited and waited, and we've gotten pushed back and voted down and voted, you know, all of these things. And, you know, at some point, you can't look at a hole in the ground anymore. You've got to have thousands of jobs back, and that's what this will do for the area, for the businesses, for for all of North Beach. And I support this. So.
Anyone else?
And I would support the setback modifications.
Get ready for the motion.
All right.
I'll just say, you know, this is a unique property. I mean, this is not like any other property in the city. So, I mean, there's definitely it warrants, you know, changing the LDRs to do something there rather than just, you know, whatever could be allowed. But, you know, in your presentation, and I mentioned this when we spoke before, I mean, I don't think anyone's against reconstructing the Deauville, and you showed all the bells and whistles that'll come with. But what you're really asking for today is a big, you know, an FAR increase, height increase, and all that. And in your presentation, you know, I think there was about 10 seconds dedicated to showing the towers. So, you know, I concur with staff. We really want to see what's being proposed. You know, sight lines and all that good stuff, setbacks and everything. We you know, it's not only us. I think the neighborhood and the neighbors would like to see that too. So, you know, before I can take any position, I'd like to see all of that.
Yeah, I agree with my colleagues' accolades on the proposal as well. Urbanistically, I think it really does elevate the area. I remember the old Deauville, and it was just a blank concrete wall along a large portion of Collins Avenue. It wasn't fun to walk by, and you know, a lot of people arrive to North Beach, either it's Collins Avenue or it's the Beach Walk. And the two Beach Walk access paths that are proposed, I think will be a huge win as well for the neighborhood and for the businesses and people that are coming and going. It's half a mile right now between 65th and 69th, which is the primary way to access the beach. So I think that's a big win. I've shared with you all, some of my thoughts on the north walkway. Obviously, working with the program and the loading, it's conceptual right now, but I think, it's the idea of having a North Beach Walk is something that should be preserved, even if it has to be elevated, because what you're doing underneath is important. You're taking the trucks off the street, and you're not blocking Collins Avenue. So that is definitely a big positive. I've spoken before about the term like dedensification of areas. This is different, right? This is, today it's nothing, first of all. In previous years, it was, 400 or so hotel rooms. It's going to come back a nice mix of transient and residential. And I think that is important for the economic success. Again, we're just giving you feedback. I think it's definitely a step in the right direction. Appreciate that you've come down in height. It's not going to be just a wall of 400 to 500 foot towers. You're at the lower end of that scale. So it gives you a slight varying, especially with the other properties along that area. So I think you're going in the right direction, and hopefully you listen to the feedback from everyone else.
Again, echo what everybody else is saying about what a wonderful project it is. I have concern. I guess I'm looking forward to hearing more about parking requirements and the exemptions. I mean, not only is this, a big hotel, but you have to also understand, I mean, I'm sure you do, but everybody has to understand that there's a huge convention center, or ballroom element to it. And I'm sure the best events in the city will be hosted there, which comes with a lot of parking needs. And so, given there's 2 residential buildings going up there, a big hotel, I would like to know more about the plans for parking and why the exemption is absolutely needed, especially nowadays with the robotic parking and everything like that. So, and then the other thing that I mentioned to you all when I met with you was, I really would love to see some, affordable housing or, market rate housing, workforce housing element to this. I mean, it seems like there's so much space here. We're giving you so much FAR, even if it is just, some portion of the property as to get things going. But I think that we really need to start looking at these plans and these projects in our city, that where we're giving these, huge FAR increases, we really have to start thinking about, where, at some point we need to start requiring some element of workforce housing, because these huge pieces of property get taken up by these beautiful developments. At some point, there's no area left. I mean, right now, there's no area left, and we have a big blank canvas to not include workforce housing here. I think it's just, short-sighted and not looking toward or forward for the future of the city.
Jonathan, the $244 million that's coming into the CRA is going to build workforce housing because it's required.
No,
It's not going to be on the beachfront, I don't think, ever in this part of the city. But I do think that having workforce housing is important, and it is required by the CRA to contribute a
Right, okay, but my point being, I guess this is, you can have all the money in the world, but if you don't have any properties for workforce housing and nobody's gonna be spending.
They are, that's the Byron Carlisle is gonna be workforce housing.
How many units?
We don't know yet, but
Right.
it's gonna be significant enough that it's gonna, at least 75, I think.
I get that, and I think this is a great step forward. I just think, instead of making major financial contributions to funds for future housing, I think we need to start thinking about in these projects doing, some areas of New York City, what they do, where they require certain parts of buildings.
Live by local, it's the same concept, okay.
Wasn't there a parking, didn't we talk about parking? Can you address that a little bit?
Yeah, real
Thank you.
quick, there is a parking garage on 67th, and so that garage, one of the public benefits are two. One, obviously, is to satisfy the parking requirements of the hotel 100%. And two, also, potentially having a portion of that parking be publicly accessible parking and public parking. So we're studying that now, and that'll be part of our proposal. Thank you.
Yeah, well, I think we're ready to move on, but just one question. So after this public meeting, it's coming back to us. Do you want it to be in January or February?
Good question. So, I don't object to Michael's recommendation for February, but I just wanted to be aware that we have to go to city commission for first reading in February. And the date of this hearing in February is what? Is it February 4th? And then
February 4th.
city commission is February 5th, right? They changed it this recently, the last few days.
No, the date, I don't have the date.
It's
How
okay.
quickly do you get our recommendation?
No, I think it's up to, if the applicant can provide us with the information we requested in terms of FAR drawings and better massing studies and things like that by December 20th, then we're okay with continuing it to the January meeting.
We would prefer the additional time. I just want to make sure it didn't alter our schedule in a way that would
When's the
preclude
commission hearing
us.
in February?
It's February 3rd, actually.
The commission meeting?
Yeah,
So it's before our meeting?
yeah.
So that wouldn't work.
Say that again?
That wouldn't work. The commission meeting's the day before.
But there are
ours.
2 meetings in February, so the second meeting, let's see, is February 26th.
Okay, and they can do first reading then?
Yes.
Oh, okay, that works then.
And
Okay.
also, I'd like to point out to the public, whoever's listening, that the next Zoom meeting, which will be open to the public, will be December 17th.
December 17th.
Okay, and that's going to be a Zoom meeting, and everybody will be given that information. So I would encourage as many people as possible to Zoom in.
Yeah, so Mr. Chairman, back to your question. So provided that your hearing is February 4th, we'll present to you all, that'll be your transmittal hearing to the city commission, and then we can do first reading toward the end of February. We're totally fine with that.
Correct. Okay. Board okay with that?
Yep.
Okay.
Absolutely.
Tom? I didn't know if you wanted to say something.
Thank you for coming.
I saw you get up, sorry.
Now he objects.
No, it's a tight deadline, so to meet the manager's print deadline for February 26th, we likely will have the memo done, and then we'll update the commission on the action of the planning board at the February 26th meeting. But
Right, so
there's
the
also
timing will
March-
work for you for us to hear it on the 4th?
Yeah, and
Okay.
there's also a meeting in March, and then that would allow for the second hearing, and the adoption hearing would have to be in April.
We just want to,
Okay.
get it going.
All right, so
Time
then,
kills deals.
nothing else for us to do. We'll schedule for February 4th?
We just have to have a motion to continue this to February 4th.
All right.
Motion to continue this to the February planning board meeting.
I'll second.
Okay, Elizabeth seconded. All in favor?
Aye.
Anyone opposed?
Nope.
Okay, guys, thanks. Great
Thanks, everyone.
presentation. David, glad you're involved. All right, we're going to take a 10-minute lunch break, and then we will be on to new applications.
seats. The meeting is about to begin. Remember to speak into the microphone, as this meeting is being recorded for public record. Please stand by. We are going on air in 5, 4, 3, 2, 1.
Welcome back, everybody. Thanks for the break so we could eat. We're moving on to new applications. The first file is Planning Board File 240686, 6747 Collins Avenue, New Hotel. Oh.
Okay, again, we're on PB 24.
The New Hotel?
-0686.
Yeah.
This is for 6747
Started
Collins Avenue.
without you.
I'll let Giselle, if you can just read the notice.
Yes, Planning Board 24-0686, 6747 Collins Ave. Conditional use approval for mechanical parking and a neighborhood impact establishment that includes a restaurant located on the rooftop of a building, which is located on the property that is within 200 feet of a property containing a residential unit.
So, on May 9th of last year, the Historic Preservation Board reviewed a certificate of appropriateness for the construction of a new 16-story, 160-unit hotel building with a 104-seat restaurant and 112 parking spaces on the vacant lot. And this lot has been vacant for probably over 20 years now. So this application is before you today for two reasons. First is for mechanical parking, and the second is for the requirement that whenever you have an activation of a rooftop use, and it's located within 200 feet of a property containing an apartment unit, that constitutes now a neighborhood impact establishment, which requires review by the planning board. In terms of staff's recommendation, we did have some concerns with the application. First, regarding the driveway access. The applicant is showing very large one-way drives on both the north and south sides of the site, recommending that they be reduced from the 20 feet that's proposed to no more than 12 feet. We are also recommending that the parking be fully screened along the north and south sides of the property to minimize visual impacts as well as the noise from the large vehicular circulation under the building. Regarding the neighborhood impact establishment that's proposed, there are 3 food and beverage venues, including a 194-seat restaurant located on the rooftop of the pedestal structure. This includes 94 indoor seats, 60 outdoor seats on the southeastern portion of the 4th level, as well as an outdoor pool bar with 40 additional seats. The applicant is proposing, this is indicated on page 9 of the staff report, the applicant is proposing the operation of this outdoor venue from 11 a.m. till midnight. Due to the close proximity of the Sterling Condo Hotel to the north, we noted our concerns and are recommending that the rooftop bar and the associated seating and the pool deck be closed from 8 p.m. to 8 a.m. This is consistent with the hours of operation that are required for any outdoor bar counter when it's located adjacent to a property with residential units. We're also recommending that there be no outdoor speakers located on this pool deck level, except for those required for life safety purposes. We did note that even background music played all day long on the rooftop could be a nuisance for adjacent residential units. We're also recommending that there be no special event permits allowed for the property, and that the pool deck and associated bar not be open to the public and only be open to hotel guests. We're also recommending that the pool deck bar be covered by a solid structure to further minimize sound transmission upwards from patrons in this area and impacts on the residential building to the north. These recommended conditions are included in our draft conditional use permit, which can be found after our staff recommendation. I know the applicant is going to suggest some modifications, and we're generally not supportive with what they may be proposing to modify, except for maybe some modification to the requirements for special event permits on the property. That'll turn it over to the applicant for their presentation.
Good afternoon, Mr. Chair, members of the board. Nicholas Rodriguez, 200 South Biscayne Boulevard, Burkow, Riddell, Fernandez, Larkin, and Tapanez. We did pass out a proposed modified conditions. They are being further modified as we speak with the Sterling, so we'll get to that at the end, but I just want to let you know that there's even further modified from what we've discussed with staff and what's on your handout, but at least that'll give you a kind of a roadmap when we get there. So if we could call up the presentation. Thank you. So I'm joined by Charlie Porchetto and Diego Colmenero. They're the principals of Urbanica Development, and they are responsible hotel operators of 2 other hotels in the city, and this will be their latest brand. It's the Meme Hotel. It's a hotel by a renowned chef, Mauro Colagreco.
What are the other 2 hotels?
The Urbanica Fifth Hotel on 5th Street, where the old Walgreens used to be, and then the Euclid Hotel, 426 Euclid. So smaller projects. This is their biggest project to date, but they are experienced in the city. So the Meme Hotel being a product of a world-renowned Michelin-starred chef. It's really focused on a high-end food and beverage program. It is not a hotel, a large hotel attracting people for events. It's more of a resort, sanctuary, oasis type property intended, consistent with the character of the North Beach Resort District, Resort Historic District. So as I touched on, the Urbanica folks have been developers in Miami Beach for several years, and they own 2 hotels that are currently operating. And if you look them up through the city's code enforcement site, they have 0 violations in the last 5 years. They do have a roof elevated pool element. They do play background music, and they do have food and beverage components. They're a little bit smaller, but they have been responsible operators, and it's something that we think responsible operators should be rewarded for continuing to adhere to the city's laws. So, there was another vacant oceanfront site in this area on today's agenda, but they're not the only vacant oceanfront site in North Beach that could help revitalize the businesses in the area. This site is about an acre, just under an acre of oceanfront land, and as staff mentioned, it's been vacant for even longer than the Deauville site has been vacant. And in May 2023, the Historic Preservation Board approved of the design of the new hotel. It's about 160 rooms, which is a significant reduction from the previously approved project by the same developers. That was about 200, a little over 200 rooms and less parking spaces. They came back, they decided they wanted to do a smaller, less intense hotel, more amenities and more parking. And that's the project that we're moving forward with now. And they're actually in building permitting already for the project, minus the mechanical parking and the neighborhood impact establishment. So this side view rendering just kind of gives you a good perspective of the hotel. You see the 5-level pedestal and then the pool deck on top. The parking is all contained in the pedestal. And you notice on the ground level, bless you, there is a very deep valet circulation zone, and it's kind of the ingenious part of this design is that all of the cars and all of the loading is getting pulled off of the street and circulating within the site. And then on the eastern side of the property, the towers maximizing views for the hotel rooms, and you see there's a ground floor pool deck, a small cafe in that area. On the 3rd level, there's kind of an elevated terrace that's going to be the hotel bar. It's going to be like a small cocktail bar with 60 or so seats. And then on the 4th level pool deck is the signature restaurant that's going to be operated by Chef Colagreco and the pool. So this is, as I was touching on, the internal circulation that Arquitectonica came up with, which is really ingenious in keeping all of the valet circulation within the site, and then an internal ramp that goes up to the parking garage. So it's a really effective and good, clever design for a pretty narrow site. On level 2, there's traditional standard parking, and then on level 3 is where the mechanical parking is going to be located. It's only 30 spaces that are going to be outfitted with mechanical lifts, doubling the capacity to 60 parking spaces. And I think that request is pretty non-controversial, but just to show you what it looks like and how that operated will be 100% valet for the hotel, and this really allows them to bring in, handle more vehicles for the hotel operations. So just to summarize, there's 116 total parking spaces with the stackers. 56 of those are going to be traditional spaces, so it's not like an entire garage full of stackers that sometimes can be a little bit slower to retrieve. There's also a significant micro-mobility element here, 75 bicycle parking spaces, scooter, and they basically have areas in the garage that are dedicated for scooter micro-mobility parking, and also dedicating 5 of the traditional parking spaces, the non-mechanical lifts, for carpool parking for their employees. And the way that will work is the employees will receive a valet pass if they are carpooling with their fellow coworkers. So just to touch on kind of transportation demand management, which is a big thing for new development and new hotels, this property is required to provide a hotel guest shuttle. They're required because they're benefiting from a 0.5 space parking requirement for the first 100 rooms. In addition, we're providing carpooling spaces, as mentioned, micro-mobility spaces, and we also are committing to provide at least 2 free transit passes to start and to participate in the Miami-Dade County Corporate Discount Program, which is actually a really great program that uses pre-tax income to pay for the discounted transit passes to benefit both for the employee and for the employer. And also willing to commit to City Bike memberships if anyone would like one, but most people tend to have their own bikes. This is just a summary of the venues. I think we'll get into this when we get into the conditions and the hours, but just to touch on the fact there's a ground level, small restaurant, only 38 seats, all outdoor in the kind of covered terrace area. Cocktail bar on the 3rd level, again, very small. And then Artis, the signature restaurant, will be on the pool deck, on the 4th level pool deck. That's the only really significant venue. And that's the only reason that we're required a neighborhood impact establishment permit. We are not at an occupancy that exceeds 299 persons. It's just because we're on the top level of the pool deck that we're here today for these venues. And then Satino, which is the pool bar, only open to hotel guests. It's really going to be serving the guests of the pool. So just to go through quickly, it's the ground floor pool, cafe, it's the pool, the cocktail bar on level 3, and then Artis and Satino, which are on the 4th level of the pool deck. You can see that the restaurant is on the southeast corner away from the Sterling, and then the Satino pool bar is on the west side adjacent to Collins Avenue, and that's only 40 seats. It's going to serve mostly the pool and have a small seating area for people that want to sit there. And then this is just touching on Chef Mauro Colagreco. He's a multiple Michelin star chef, and he's has restaurants in many world-renowned hotels, one and only, 4 Seasons around the world. So just to get an idea of the type of operation this is going to be. So just getting into the conditions, originally we were going to ask for another hour for the Satino pool bar. We're not going to ask for that, so we're totally okay with closing the Satino pool bar at 8 p.m. Out of respect for the Sterling residents. However, we would like to make some modifications to the hours that the pool deck can be open for hotel guests. While the bar may close at 8 p.m., we think it's a little bit strict to be closing the entire pool deck for hotel guests only. It's only a 160-room hotel. It's just a place where people can sit and you see the view towards the city. Realistically, the benefit of this pool deck is that it faces west, and it's a sunset pool deck, and it's going to have a nice view during the evenings, potentially of some new towers at the Deauville and of the cityscape to the west. So,
let me ask you, I see there's no entertainment, but is there music?
So that's the next condition. Staff has recommended absolutely no speakers at all on our pool deck on the 4th level, and we think that that's a little bit harsh, especially given the fact that these are good operators with a proven track record. What we're proposing to do is just ambient level background music following a sound study with a noise level limiter and directional speakers. We're going to pull out all the bells and whistles just for ambient level music, particularly for the seating, the outdoor terrace seating on the southeast side for the restaurant.
I'm sorry, who's the neighboring, is it a resident?
The Sterling condominium.
It's the neighboring building?
Yeah. So, and I should touch on that. We have been, we have a good relationship with them. They've been in communication with them. We were just speaking with one of their board members who's here, and I'm sure she'll speak. We've been going back and forth on agreement, on a mutual support agreement. There is no agreement signed. They need some access to our property to do some work on their, one of their retaining walls. We want them to support. There's lots of things. They want us to pay for the waterproofing. So this agreement is still being worked out. But there is a very positive working relationship. Charlie and Diego have been communicating with them for years as this project has come forward. And it's really kind of a pick up the phone and call type of relationship. So we're not anticipating having a kind of we want to have a harmonious relationship with them, and they have not objected to this application, at least as far as we know.
Nick, how many people have you spoken to in that building?
I haven't spoken to them. Charlie and Diego have spoken to them. I've spoken with their attorney.
I think that the whole reason that 200 square foot or 200-foot noise limit was put into place was specifically for rooftops.
Right.
So I think more, I mean, at least from my perspective, you're gonna need to get a lot more support from people in that building, actual neighbors in that building, because I know a lot of people are concerned about their, even though they haven't had a view for 24 years, they're still concerned about, you know, obviously, but there's some more feedback, I think, for me.
Yeah, and we're definitely sympathetic, and that's why we're willing to go the extra mile. But I think as Mr. Chair Elias mentioned earlier, you know, balancing the needs of the businesses and the quality of life of residents is kind of what this board does. And, you know, saying that a pool deck for a hotel can have no music, even if we're proposing to limit it from 12 p.m., and I should mention, we want to add to
There's
this.
also a lower pool deck too, so this is not the only pool deck.
Right, but
It's the one that's on the roof that's the concern.
Right.
Right, and we're willing to do a sound study before, use directional speakers and a noise level limiter to confirm that the noise won't escape, and limit it to 12 p.m. to 8 p.m. So just a very limited amount of time when music, background ambient music can be played
Is this
on that pool deck.
Artiste, is that the same as Centino? Is that,
So
what's the difference?
Santino's just the pool bar, Artiste is the signature restaurant, so it would be,
But you want 12 a.m. on the bar?
no, that's 8 p.m.
Okay, which is,
So
I'm confused.
do you have the conditions that we passed out, the chart?
I'm wondering which one is which. It's not- I have this, but I don't have which one is the bar and which one
Okay,
is the
so
actual
here's-
restaurant.
So the bar is in pink here.
I see that, but which one is Centino is the bar?
Yeah.
And Artiste is the restaurant, and it's enclosed?
Yes, except for these outdoor terrace seats that are on the southeast corner
Okay,
of the
but
property.
so that is really kind of outdoor that moves to when the restaurant closes, is that right?
Right, well, I'm sorry, I don't really understand your question. What are you asking?
What time does the restaurant close and it becomes an outdoor venue?
It does not become an outdoor venue. The restaurant closes at midnight, and the seats will stop being served at midnight. And it's gonna be we don't have any
And it's
entertainment.
enclosed?
The indoor portion, so these are walls.
No, the terrace part of Artiste.
Sorry. No, the terrace part is not enclosed from the sides, or it's overhanging, the building is overhanging above it, but it's not enclosed. It's
Do you have a 3D view that can better show maybe the relationship or
Yeah,
the
this-
volume of the tower and the building? Yeah.
Yeah, thank you.
So here, this is where Artiste will be, and this is where the outdoor seating will be along this edge.
It's not on the residential side.
Right, it's on the other side. It's
And the
perfect.
tower will be blocking this
Right.
noise presumably.
And what is next door to that?
The Deauville.
Oh, okay.
Yeah. Hopefully,
Got it.
Yeah.
Okay. Keep going.
Here it is.
so we're, in terms of the conditions, we're hoping to be able to have ambient background music at our pool deck from 12 p.m. to 8 p.m., provided that we comply, with providing the highest technological solution that's available to us. The condition 3D, staff had requested a concrete canopy. I think we're okay with it saying a solid canopy. I don't know if staff would be okay with just removing the word concrete, and then we can work on providing, it may be another
We
material.
could modify the condition, a solid canopy that is sufficient to reduce sound transmission.
Right, and exactly.
There may be some other materials that could be included that would,
Don't want to bother the hotel guests either. I mean, I'm trying to, again, balance.
Right, if it's ambient, anyway, we'll get into that.
Right.
Go ahead and finish your presentation.
Right, so ambient, and then the last condition is staff had put a prohibition entirely on special event permits. Special event permits, a process that you apply for. This is not the South of Fifth District where special event permits are prohibited. We would request that we'd be allowed to request 4 special events per year at a maximum. Just reminding the board that a special event doesn't necessarily mean a headliner DJ. A special event could be a grand opening for the hotel. It could be a fundraiser for a nonprofit. It could be an Art Basel event. But 4 per year is pretty limited. It's pretty reasonable for a hotel of this size. Prohibiting special events entirely, it's a prohibition on being able to make a request for a permit that is reviewed by the city administration. So we think that that's going a little bit too far. especially it's kind of being punitive before this hotel has even had an opportunity to show you that they're a good operator. So with that, I know the discussion will be mostly focused around these conditions, so happy to try to work something out and come to a compromise.
And Michael, ambient is still defined in the code as you can't hear, you can't
be above
interfere with
normal
conversation, right?
Correct.
Okay, because the problem we have with the good time is the language. The terminology is like not audible across. So obviously you understand ambient, what that means. It means people at the pool deck can hear themselves talking.
One of the sentences, the applicant shall submit a noise impact study demonstrating that the proposed sound system shall not be audible beyond the boundaries of the property. And so I mean, from what are you saying that you agree that beyond the boundaries of the property, you will not be able to hear this ambient music?
That's what we're proffering in this condition. We're not.
Has to be.
We're not proffering.
No, right. I mean, my whole thing is like, if you can't hear it outside of the property, then who cares?
I agree.
What,
That's why I pointed out the
but it gets tricky though when you've got neighboring units above and you're standing at street level measuring, and so I think it should be from the. I mean, and it's difficult for you because right from the balconies of some of those units that are closer to that level, it's going to be really easy for the sound to travel. And so I think, I don't have an objection to it as long as it doesn't escape the property. It's just hard for you guys.
It's had the onus on them to demonstrate that fact.
Right.
And I would suggest that we probably should have access to one or more units of the Sterling to ensure that in that sound test, it actually works and the sound is not
And make sure
audible
that
from
when
those.
it's open,
So we're going to be already be doing a pre-construction survey of the Sterling. So I don't think that that's going to be a problem.
Right. All right, before we go into this, let's finish because I want to open it public and then are you finished?
I'm done.
Okay, is there anyone here other than the applicant to speak? Anyone on Zoom?
We have one person on Zoom with their hand raised.
Okay.
And before we open to the public, are there any disclosures?
Yeah, I was just going to get to that. Anyone have a disclosure to make? No? Okay, all right, let's go to the Zoom call.
James Frank.
Hi, James. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. You have 3 minutes.
Okay, thank you. James Frank, I am a unit owner in the Sterling. I actually own multiple units there, and I'm a former board member. I was a member of the board for 2 years, so I'm pretty familiar with our neighbor. And just a couple of, I mean, you guys have brought up some really good questions because the noise is definitely a concern. One of the beautiful things about living at the Sterling or having some units there is that you do get to hear the ocean. You do have, a really good sort of natural sound going on for a lot of owners. And I would really hate to see that disrupted because, I mean, the fact is we're real close. I mean, 200 feet is very, very close between the residency and the hotel. So, I think that getting the testing done, making sure that it's not just street level testing, that you're actually looking, you're doing your tests from different heights in the building is extremely important. So
maybe you'll volunteer your unit to do a test. No, I'm serious.
Problem. I have one unit that would be facing there. So I would be totally open to that. That would not be a problem as far as I'm concerned. So happy to help out on whatever level. And then go ahead. I'm sorry.
No, you're right. I mean, we live in a neighborhood. We live in, Condo Canyon, and we are neighbors, and we do hear we live up there so that we can hear the ocean, and that's sort of the point. I'm just,
Yeah, I want to give you
concur.
music, and I just want to make sure they're not disrupted.
Correct.
So, like we always talk about.
And I haven't listened to a lot of your calls, but I mean, the fact is, probably 75% of the initial meetings you had today were about noise. So, this is, we don't want to be in that queue, complaining about noise for our neighbors. And I don't think it is unreasonable for these guys to be asking for, for special events. Listen, the place is a beautiful design. It's gorgeous. It's absolutely stunning. I look forward to having them as neighbors, and, they certainly have been good folks as far as working with some of the people on the board. But I do think that, certainly noise after 8 o'clock, making sure that ambient noise is exactly that is a really, really big deal. So I appreciate you guys, taking this very, very seriously.
Thanks, James. Anybody else on Zoom? Okay.
Sorry, nobody else on Zoom.
All right. I thought you said, did you say you had the homeowner rep here? Did I hear that?
We were speaking, she just doesn't want to comment, but we were speaking with someone from the board who is here.
Okay. I thought you said there was someone who wanted to speak. Okay. So we'll close the public hearing. Scott, Jonathan, whoever want to start?
Yeah, I guess maybe for staff, could you explain the special events permits? And I guess, part of it is I don't know this property yet, and so I don't know, maybe you can, in terms of a special event, where do you anticipate doing special events? Is it down in the bottom pool? Is it on the deck? Do you have other than the restaurants, is there an event space sort of thing?
And if you don't mind, can you bring back up the plans so that we can take a peek?
And while they're doing that, Michael, remind me, so in a special event permit, does the CUP sound restrictions stay in play?
The planning board can be specific in terms of what can be exceeded with a special event permit. So the special event permit, unless it's specified, the occupancy can be exceeded, the entertainment could be exceeded. So I think it's important, if the board is going to allow special event permit, that it be specified where on the property the special event can occur, indoors or outdoors, and if it's just the occupancy levels that can be exceeded, just the hours of operation that can be exceeded, or if.
But I don't remember doing, so, but doesn't the special event permit come with certain rules? Because I don't remember addressing specifics with respect to the special event permit.
Typically, the occupancy, the hours can be exceeded, but none of the
No,
other
I know, but is
conditions.
that in the permit, is that in the code about permits, or we have to do that?
No, it's I don't know if it's in the regulations for special event permits.
I thought they were.
So through the chair, so the
But
special.
it doesn't, like, for example, if the board says on the hotel pool deck, it's only for hotel guests only, the special event permit is not going to supersede that. It may allow increased occupancy for that pool deck, but it would still be for hotel guests only, if that's a condition in the CUP.
All right, go ahead.
So the special event process, you apply through the city administration, and then they put limitations on what you can do. Of course, they review your CUP, and if there's limits on your CUP, those are automatically implemented. But it's a pretty rigorous process, and if you have even one code violation, any code violation, an elevator, you can't get it. You can't get a special event permit. So it's a pretty tight process, and we haven't seen many other applications where you basically prohibit someone from requesting a permit from the city. So we would be willing to maybe limit no special events on that fourth level pool deck, because we understand the concerns with impacting the Sterling. But for example, a special event on the rear yard, kind of ocean facing pool, we don't see anything wrong with that. And the limits would be set by the city administration through that.
So if we allow them to apply for 4 special permits, can we address those at the time, or the staff does that?
No, we don't. So planning staff does only the special events department reviews the special event permits. They may ask us a question or ask, is there a CUP on this, or is this allowed according to the CUP, and then we will respond. But
Right, but I'm saying if we allow them in the CUP to make 4 applications a year for special events.
that's restricted. They will be.
Right, then they can do that, and then who's gonna review and determine what they can do with that special event?
The special event permits reviews
Okay,
it.
there's
Right.
a city department that does
Yeah,
that.
yeah.
All right, so what are you suggesting we would do if we allow them to
To
apply?
clarify exactly, for example, the special events may not occur on the pool deck.
Okay.
And you're talking about the fourth level.
voluntarily stated.
Okay, and so, and the bottom pool, you're not proposing a limitation on hotel guests, because I know the fourth.
Yeah,
level-
we're not. We're proposing a limitation on just the rooftop pool deck.
But-
And that's the reason why, if they didn't have this rooftop activation, this would only be before you for the mechanical parking.
Right, okay.
So you're going to have 62. Look, can I just ask a couple questions? Bar level 3, is that a pool deck or no?
No, so it's on the level 3 mechanical parking plan. You see it's kind of at the end of the garage. So this is their spa, and then this is the bar, internal, and then the terrace seating. Very similar to, it's on the southeast side away from the Sterling.
Where would you have any special events?
I think we're voluntarily stating that it wouldn't be on the pool deck. I think
Would
it
it be
really
on level
depends on the
one?
nature of the event, right? That's why we don't want to get too specific. You know, it depends who's at what event are we hosting.
I'm trying not to disturb
Yeah.
the neighbors, but I'm also trying to give you guys
Right.
what y'all want. But I honestly don't want the residents disturbed, but I'm having a tough time with this because I feel like that should be inside. I don't want to, I'm going to use an example. The Deauville is 4 buildings away from me, or was. And also the Sherry has decided that they want to have pool parties, but we're very narrow, we're narrow. And it echoes. I don't want to hear 4 stories away and call code and say, why am I hearing this? And have this problem over and over and over again. And I don't want that for the residents that are even closer to you, because it does echo because of how, that open space is. So even if you're on the water, so is Bar Muse on the water?
It's on the water facing side of the building, correct?
Okay, so that, when the wind blows, it blows the sound back. So do you have 30 people indoors and 30 people? Or is it just those 30 on the terrace?
It's 30 indoors and 30 outdoors in terms of the
And they
seating.
can move back and forth like this, so it could be 60 at any point?
Right. There's a floor plan here for it somewhere. Here it is. Right.
So 60 people at ambient level is still not conversational?
60.
I'm trying to,
No, the music's ambient.
Yeah.
I know, but conversational level at ambient music, you're still with 60 people, you're talking over and over and over each other, is my point.
It is on the southeast corner of the building, and we would, I know when we have these applications, kind of everything becomes subject to the planning board, but this is
I'm
not
just
an
trying to-
NIE. It's
I'm
not.
trying to be
Right.
considerate of the residents,
Right.
and, I'm,
Could we, if we, if in the eventual order, it says, any noise from the property has to be at ambient levels and can't be heard, let's say outside the property lines, and they apply for a special event permit, is there something that we could put in our order that says that special event permit or cannot, must abide by that? In other words, anything they do for their special event they can't have a
Yes.
DJ, they can't play anything louder than.
Yes, you can include that as part of these conditions.
Okay.
Yeah, but what fun is that special event? No, I'm kidding. What he was saying earlier is we can specify that there are restrictions in place in the general special events permit concept, but we can add additional.
Correct, and they mentioned that they mentioned, I forgot what, you may have a special event that's maybe a wedding or something that's maybe not, it's not gonna be a DJ, it's not gonna be a party. It's something that's more of a
Right.
low-key type special event, but still a special event.
but no DJs or any of that
So
kind of stuff.
we had,
and-
so our
because that's-
recommendation, I'll just read our recommendation in terms of, and see if it's acceptable to, this is what we had also emailed the applicant, is we're okay with special events held fully indoors, concluding by 6 PM with entertainment. So we're okay with, if there's 4 special event permits per year, with entertainment indoors, concluding by 6 PM. Or if there's no entertainment, they can have their special event permit indoors till 10 PM. Well, 6 PM with entertainment indoors, and 10 PM if there's no entertainment, also indoors.
So only indoors. So it would only be special
Only be
events indoors.
right.
Okay.
But that's just are you saying limiting that to entertainment indoors, or you're saying you can't even have like people standing outside in the bottom?
No, they can have the special event, the entertainment, if they have a special event permit, the entertainment can only be indoors. And if there's entertainment, that event has to conclude by 6 PM. If there's no entertainment, then they can conclude till 10 PM.
Entertainment inside would be done at 6.
Yes. That's for the special event permit.
Would they still be able to get a special event permit for something outside?
Not for entertainment outdoors, and not in the pool deck. I mean, no, I think, would that have to condition to be only for indoors? Unless the
Right, so
board
this
wants to
condition would
modify it.
prohibit any special event.
So this is from the city, this is like for special events currently?
No, this is our recommendation. If
Oh,
the
your
board-
okay, this
yes.
is not.
If we're talking about
but
narrowing down, I'm just throwing
I-
something out there.
You know, when we're
to
talking
work
about
from.
inside events, I mean, it is a hotel. If they're gonna have a wedding, I don't know of a wedding that's inside that doesn't have entertainment that finishes by 6 PM. Why are we being so restrictive on the inside, event?
Just because if you have a special event, you're probably having more people come to the establishment, and it's just usually a higher occupancy.
They're going
so
in
more
and out.
people-
They're going in and out is the
But I
point.
think it's more important that the outside events. I think that's
Right,
what's
I think-
critical.
I
The
think, yeah, I
inside, if
think-
nobody hears it, I'm
I
okay
think
with
it's a bit
that.
unreasonable for a hotel to have inside events that they have to limit
you-
to 6 PM with
do you-
entertainment. I mean, you're
How
kind of
many of
really
y'all have been
diminishing.
to
I was
North
speaking-
Beach?
Can I finish?
Yep.
Thank you.
How many have been to North Beach? Like, how many of us have been there?
No, to our, like, seeing our, like, our specific, how our buildings face and how you have the canyon where the sound comes.
But is there a canyon right here? What's on the other side of Collins Avenue? It's low-rise, CD2, right?
Our argument here is that this is not like Washington Avenue is a commercial district.
Right.
This is a residential multifamily district, so that's
Correct.
why we're recommending stricter conditions than we would otherwise recommend if this was in a commercial zoning district.
It's very different.
Well, can I ask I know it's a little premature, but we just had a first hearing on a big project to the south. Would similar type restrictions be recommended, would you say, like in a year when they come to you for a conditional use permit?
Well, if they were to come for a CUP, that would come before the planning board.
Right.
But would you make the recommendation to the planning board to conclude entertainment by 6 PM?
I think we probably look at where on that property's so big.
Okay.
If you had something that was focused towards the interior, then probably they could have expanded hours, but something that's on the periphery will probably have to close sooner.
Their hours are 8 o'clock anyway,
Okay.
by 8 o'clock.
Is there a ballroom or similar type space in the plan? There's no event space, it's just. Okay, so it would be these venues that we have in
Right,
front of us.
that's the only assembly space within the property. It's
Okay.
hotel rooms, those decks, and those spaces.
So the only wedding possibility would be on the beach then, or in the pool area outside?
Essentially, yeah, there's not much space for an indoor special event. Maybe the lobby, but it's not very big.
Not to jump around, your presentation says 116 parking spaces. The staff report says, I think, 164.
So 164 would be our requirement, where with the stackers would be 116. But we're
With the
reducing.
stacker, okay, go ahead, sorry.
But we're using the alternative parking incentives, which allow you to basically replace parking with other types of parking, bicycle parking, moped parking. We're balancing providing 116 conventional parking spaces for vehicles and then providing all of that additional like a micromobility parking, and that's how we're achieving our parking requirement of 164 spaces.
Okay.
So since we're on this subject now, can you talk more about the guest shuttle? Where, what are the requirements for this, and what is your proposal right now?
So the requirement is just the code says to provide a guest shuttle for transportation hubs and areas around the hotel. I don't have details on how the shuttle's operating, so give me one moment. Or do you guys have? So we'll have to work that out in
Okay,
permitting.
this is the first I've heard of this particular one. I guess it's a parking reduction, right? There's a
Right, so you get 5 spaces per unit for the first 100 units, and then for every unit in excess of 100, it's 1 space per unit. And the only way you qualify for that 0.5 space per unit is by providing a hotel guest shuttle.
Okay.
So we're gonna have to figure that out.
So the idea is that you may have a shuttle that goes to the airport, for example, so people don't have to rent a car.
For sure, at a minimum, I think it would go to the airport.
The
I think.
airport, and then maybe one to South Beach, or one to 41st Street, or to Design District, for
Or it could
example.
just be, it's not a very big hotel, it could be, upon request of a
On
guest.
demand.
Depends on how things work.
Definitely an interesting idea, and I want to thank you. I asked about the TDM requirements because they weren't specified in the plan. I know that you provided them to me last night. I haven't had a chance to review, but I did see that you included a slide there. On this topic, the bike parking, which looks like it's on the ground level, is that a secured room or facility, or is it open to anyone
There's-
walking by?
It's a secured room. There's multiple. I think there's also another bike room on the second level, and that's where the employee showers are going to be. So we have showers for if an employee wants to bike to work, they can shower and get ready there.
So that's also part of your parking reductions, right? You get for the shuttle, for the carpool spots, the showers, and the bike parking. All of those combined. The intent is to reduce the need for people to drive and provide alternatives. And I think it's a good legislative intent, and we've seen a bunch of hotels and other commercial venues take advantage of this, including I think the ones on Fifth Street. I think your clients have also taken advantage there.
Probably, they're pretty savvy.
Of that as well. I have seen the stackers, by the way, when you walk by Meridian Avenue. The hotel's been open for a couple of years, and they seem to be utilized. So I know there are concerns about mechanical parking. That's why it comes to this board. But, they do work, and they do save space while still providing required parking. So it's...
Yeah, I guess, I don't know. I mean, I know there's 180 rooms or so.
160.
160, and then you're going to have 116 parking spaces. There's something, employees receive free valet passes for carpooling.
Right, there's 5 spaces dedicated for.
Oh, so it's only 5, okay.
Yeah.
So really, already you'd kind of cut it, the 116 down to 111, and then, I don't know. I get concerned with the parking there. We're limiting the parking there, limiting the parking next door at Deauville. The parking garage is going to be at capacity, and so, but I think you're doing a good job in terms of the transit passes, the city bike memberships for employees. I think that's important. And so in terms of the special events, and so number one, I think I personally, in terms of the fourth floor terrace, as long as the speakers, that you don't hear the music or, whatever from the balconies, I don't think it's a problem it won't be a problem for residents. That to me isn't an issue. As far as, is there gonna be ambient level music on the first floor pool deck?
Yes.
Yeah, because I mean, given the proximity of that neighboring, building, I can see that being an issue too. I mean, even just, it's not that far away, that ambient level music there, so I would want the music there equally not to be able to be heard on the balconies. I think we need to have this special event permit thing is difficult, and I honestly think this is like the first time in my 3 years of being on the planning board that we're discussing the number of the special events for a new property. Maybe we have discussed it before, but I think they should have special events. I think we're all silly if we think that the Deauville Hotel is not going to have special events. And so I think we need a comprehensive plan for the area. I get it that right now it's a nice, quiet, residential focused area, and there's a canyon or what, where.
Even when the Deauville was there, though, it was still, there's that wide open area. So I'm not quite sure how I explain this to you, except that it's sort of like a U, okay? So the Deauville is going to be down lower, right? Then you'd have those towers in the back, but then you have the other towers like the Monte Carlo, and then you've got the other ones, and then Sterling, it's like it literally is like a horseshoe.
We're talking about 4 times a year max.
Right.
So I don't see that. I think everybody
I have a
who's.
problem with special events as long as they're monitored properly.
Well, I guess the next question becomes, what is it that we're comfortable with in the special events, right? I think it's, I don't agree with,
In residential areas, what has been done before? Do you know, Nick or Michael?
Typically, the board will not get so into the details on special event permits.
Right.
I think based upon past history and sort of questions we receive from Special Events Department, it's better off to clarify the language so that there's nothing that can be misconstrued in terms of what can be approved with a special event permit.
And just to be clear, we're voluntarily prohibiting on that fourth level, so it would only be special events.
right, I know,
basically
but
inside or the ground floor.
But for, for the residents next door, and I wish we had a better presence from that building today, but you're, in addition to these four, then you're gonna have the additional, special events permits from the Deauville. And, if you're adding it all up, it becomes, more invasive. 4 times a year isn't that bad, but when you've got it, maybe if the Deauville gets 10 per year, I don't know how many, that's 14 times a year. So they're gonna be hearing noise. So I don't know, I don't see a problem with the 4 events. But
I agree. And Michael, just so I understand, so if we were to, in light of their history, and these guys obviously have been good operators and good neighbors, and if we were to agree to 3C, these requirements that they do, is that something that has to be done before what, the CUP becomes official?
No, it'd be a condition in the CUP, and it would be tested prior to they getting a BTR to operate.
Okay, so you would be able to ensure that these conditions are
Right,
met
we
before
would-
they get a BCR?
Staff would go out there to the site with them, their sound engineer. We would have the sound system on, test the levels, and ensure that going to the adjacent building, that
Okay.
the noise was not audible. It's
All
a
right.
pretty strict standard.
And can you
so-
do me a favor, can you write down the name of that guy? I think it was John that spoke, that
John
offered.
Frank?
James Frank.
James, if he cared enough to speak, I'd like you to maybe use his unit that, as a test. Because, listen, I'm all in favor of, I know their projects, they actually, I know them, they're good operators, and, I think as long as that's done, I don't have a problem with it.
And
That's what we're.
I'm okay with section 6 on page 3, which is commercial uses on the rooftop are prohibited, entertainment is prohibited anywhere on the property and within the building, and then modify that to say except for special events as applied with,
Hey, I'm sorry, Elizabeth, where are you?
on page 3.
Page 3, yeah, section 6, the following shall apply to the entire project?
Mm-hmm.
Okay, where are you now?
On number.
I see trash containers.
Numbers E and F and G.
E, F, and G. Commercial uses are prohibited.
that's
On
the
the
rooftop. Is there a rooftop? element?
Entertainment is prohibited. You're not asking for entertainment, right?
Okay, I'm just, sorry, real quick. The commercial, the rooftop, is there a rooftop?
Yes.
No, I know, but there's the terrace.
It's considered the rooftop.
Yeah, the rooftop of the podium, I'm not sure,
Right.
commercial uses, I'm in a
We're
restaurant.
referring to the rooftop of the
And use of
the
rooftops
tower,
and-
the highest level, which I think is just, there's no venue up at the rooftop of.
No.
Right, so we're referring to clarify that.
Can we add
that-
tower to that one to E? to 6?
Yeah, for the tower,
So-
as well as for the pool deck level.
Okay.
Yeah, so commercial uses on the pool deck level permitted, i.e. the restaurant, but commercial use on the rooftop of the tower would be prohibited.
Right.
So,
Right, but I guess the special event permit would be
With
the
exception-
exception to that.
Exception to, right.
Okay, all right, that's fair.
Was it, just so I understand, we're prohibiting entertainment anywhere on the property?
Correct.
If they get a special
Except with.
except that,
Right.
okay.
Okay, and then, if y'all are all right with that, and then, hotel guests only. And I see invited guests, but I've seen that run into problems before. How do you get around and invited guests? I could have 15. If I'm staying at the hotel and I have 15 friends that live in South Beach or whatever, and they want to come hang out, how do you
I feel like
mitigate
there's
that?
only so much we can control.
Right, within a
they have-
special event, there'll be an occupancy
But
that'll
this,
be limiting.
this one doesn't, this one, would we move the special event to apply to G as well? Do you see what I'm saying?
No, it's the hotel guests. it's the hotel guests, they're invited guests.
Right.
It's like,
Yeah, there's only
they're
so
not gonna be letting somebody bring 20 people, because that would disturb the other hotel guests. And so we
Well-
kinda have to, when you have good operators, you have to kind of,
Rely on them.
trust.
There's a way this 200 feet came about, and it's because of exactly that. So I'm not quite sure. They were bringing a lot of people in. So I don't know how to mitigate that. I really don't. I'm asking for feedback.
What are you saying, what, 200?
When it says hotel, the 200 feet limitation for
Well,
rooftop
the
uses.
reason why this is before you today, if there was no apartment building within 200 feet,
Right.
then this rooftop pool activation would not be before you. It's only because they're less than 200 feet from an
Right.
apartment building. That's why you're here today.
That's why we're trying to make sure that we, control the noise.
So I don't know how you.
She's just concerned about the open-ended phrase and their
But the
guests.
applicants agreed that there's going to be no special events on the pool deck.
Right, on the level 4 pool deck, and just a point on the invitees, they do have room occupancy limits, so as a typical hotel, if you try to come in with 10 of your
Right,
friends and your 2 guests,
All right.
they're not gonna let you use the amenities.
All right, someone want to move,
No, I was
Scott,
just
I'm
gonna
sorry.
say, we talked about speakers, I'm okay with the speakers. Again, it goes down to, goes back to, can noise be heard outside off the property? And that's what we're trying to avoid. You can do all this sound study you want with the engineers, but all it takes is, someone that's operating the equipment to turn the dial up and the noise is loud.
Right.
So it'll be interesting if.
Well, I think
they-
there's a mechanism to lock that.
Well,
we're
we've
proposing a limit.
heard about that a million times with all these
Well,
other
We've
venues,
seen
and they
that
keep coming
before.
back,
But
so.
that's what they're proposing.
Except the ones that are good and don't come back, and then,
Right.
That's
then
fine,
you don't
and
hear from
I
them.
don't expect you will, so, but it's interesting that, we'll see
Right.
whoever comes back here,
Guess we'll see
down the
what
line,
happens.
how we handle it as a board, if we're that concerned about noise.
So since this is an NIE, and with our latest code, this will require like annually coming back to the board on an annual basis, so.
Whatever y'all want to do. I mean, I've already
Wait,
laid
they
out
ha-
what I
we're-
think is,
Say that again, they
It'll be an annual progress report.
automatically?
yep.
All right,
So
Somebody
before
press
you
pressure.
move it, I have one more question. The staff analysis talks about a discrepancy in driveway width from 20 feet versus 12 feet.
Yeah, that was a mistake that we made on our submittal. We've already corrected that, so the
Okay.
driveways are within the setbacks, and I think we've reviewed that as
Okay.
part of
So
the
the
permit
one-way
plans.
drive widths are within the required 12 feet for both entrance and exit.
Yeah, we
Okay,
got that.
thank you.
So it was just a mistake, yeah.
So and just so I understand, sorry, I hate to belabor all this, but there's so much in here. So the Santino pool bar, I think staff was recommending 11 a.m. to 8 p.m. and you want 11 to 9?
We're fine.
No, they agreed.
Eight-
You're
eight-
great,
eight-
and same thing with the other, you're fine
8
with
PM is
okay.
fine.
I mean,
If we allowed music,
And that's the deck also. You've got 11 to 12, but that should be 8 also. And then Brezza Restaurant Level 1, I'm okay with 11. And Bar Muse, I would be okay with 11 also.
so,
11 p.m., 8, 8.
so 11 PM, and then 8 PM for our outdoor. Okay, that's fine.
Okay, wonderful.
all right,
Fantastic.
great, someone move it, let's go.
Changing,
I'll
just to be
move it.
clear,
Let's just recap. 'cause
we're
there's been a
changing
lot.
we're changing the hours for the other venues
All right, and then
To-
we're agreeing to their,
to stop at 11 PM versus 12 AM
and we're agreeing to their proposed modified conditions.
for the sound, right?
You're moving it just.
With the, and I think just to clarify, like with the clarifying point that it shall not be heard beyond the boundaries of the property and on the balconies of the neighboring tower.
Does that include both the lower pool deck as well as the upper pool deck?
Yes.
Yes.
All right, we have a motion, can I get a
And
second?
then there was the change of the
The wording.
canopy
The
for
canopy,
you,
so
for
not,
the
just
solid.
delete the word concrete and leave the word solid.
Let's
the
say
word
you wanted
concrete
a
out.
retractable, let's say you're agreeing to a solid
We
canopy.
can do solid, it's just we were trying to work through a potential setback
That's
issue,
fine.
but if we can work it out, so
Okay.
we'll do solid.
That works.
Yeah,
for me.
yeah.
I mean, look, I live up there, so I'm just like,
I understand.
Can we clarify, I'm not clear on so we're going to allow 4 special event permits per year. No special event permit on actually,
Rooftop.
no special event permit will allow entertainment anywhere on the property.
Except during special events.
Wait, no, I
Well,
think it was
yeah.
the opposite. It was entertainment is prohibited except for a special event.
Okay.
Right.
Okay.
The only
Right.
limit on
And-
special event is the prohibition on the level 4 rooftop, unless we guys want to impose more, but that's.
Is that-
Right, so no special events on level 4, the outdoor area, and then
Ambient, beyond.
So you guys want
Property bounds.
non-entertainment, no entertainment outside associated with a special event? So,
Outside of the special event. This is outside of the
so
special.
there's no special events on the fourth floor?
So the only entertainment that can be approved is indoors with a special event permit.
right.
Even in the ground floor pool deck, no entertainment as part of a special event?
Who made the motion?
Well, I mean, this is kind of like the first we're talking about it, so, I don't know, I mean, I guess that includes like a DJ. I mean,
Yes.
Right, so,
Yeah, Elizabeth moved it, so I just need a second.
well, we need the answer.
She
He
need
needs to know
clarifications.
what, are we limiting it to no entertainment outdoor on the first floor?
There's no entertainment on the property at all,
No, I thought we said indoors.
except during special events.
Indoors.
Right, so during a special event, could we have a special event in the outdoor
As long
ground
as
floor
it's,
pool
as
deck?
long as it ends by 11.
Okay, so we,
Is that
that's
good?
fair, I think that's fair. So,
Okay.
the limits on special events are none on the fourth level roof deck. We're allowed entertainment for a special event only, and if it's outdoor, it must conclude by 11 PM.
Yes.
Fair, we can move.
Fair?
Yeah,
All right,
Good neighbors.
can I get a second?
the board members.
Second.
Go ahead, Shield seconded it, roll call.
Is there anybody opposed to that? All in favor?
Aye.
Aye.
Okay.
Thank you all very much, I know it was tough.
Congratulations.
All right, guys. Okay, next matter, Planning Board File 240715, 1800, 1810, and 1818 Michigan Avenue, single-family home lot split.
So let's see, this is PB 23-0715. This includes an application for the division of land or lot split to divide one existing site, which is comprised of 4 platted lots, into 4 individual buildable parcels. So staff would note that even though there are 4 folio numbers for this property, that there's construction that spans all 4 properties. And that's the reason why the applicant's before you, because they want to separate out these lots and allow the construction of 4 single-family homes. Typically, staff has concerns regarding the maximum lot coverage and unit size on a site. However, in this case, and I believe Mickey's passing around a proposed amendment to our conditions of approval. Typically, we recommend that there be no variances or waivers associated with the property. Because of the historic nature of the site, and they are trying to recall the building that was demolished along the waterfront, and that exceeded the lot coverage limitations of the code. So we do not object to the applicant's proposal to allow the Historic Preservation Board the ability to grant a variance for lot coverage in order to be more consistent with what was originally constructed on the site. Like I say, due to the irregular shape of these sites, we do believe that there could be a warrant for waivers or variances on these properties that are very unique, located within this very small, unique, historic, single-family, primarily single-family district. So we don't object to the applicant's proposal. We don't object to the application to divide the lot into 4, divide the one property into 4 individual sites. And with that, turn over to Emily, who'll probably go through the history of the site and why they're before you here today.
Thank you, Michael. Good afternoon, everyone. Emily Balter, Burkardell, Fernandez, Larkin, and Tappanez, offices at 200 South Biscayne Boulevard. I'm here today with my colleague, Mickey Marrero. I think Michael Larkin has stepped out, and our project architect, Jennifer Macani Gayoso. We're here today to request lot split approval, returning these 4 lots to their original platted lot lines. We understand that there are concerned neighbors here today in person and maybe on Zoom. We've been in contact with these neighbors. Mickey Morero has attended a number of their neighborhood association meetings. We are sympathetic to the issues of this neighborhood, and we're in agreement with working with them to move forward. And in order to do that, this is step one. The property is located at the intersection of the northwest intersection of 18th Street and Michigan Avenue. The current lots are all over 78,000 square feet. They range from 78,000 square feet to the largest one is 12,000 square feet. I guess where I'll start with is lot one. This is a vacant lot that's been vacant since 2004. Lot 2 and 3, which are these two. Lot 2 and 3, we've submitted, they were deemed unsafe and subject to an emergency demolition order approved by the building official. They're currently vacant and in the process of finalizing a demolition permit. What's pending for the demolition permit is a picket fence and shrubs. The picket fence is currently being fabricated and the shrubs are being ordered to be installed. Then we'll close out the demolition permit and finalize a special master case on those two properties, but they are vacant. The lot one, which is the last remaining structure in this assemblage, has been boarded, and we're currently working with historic preservation staff to analyze what of this contributing building has historic value, can be preserved if anything. We have a structural engineer currently preparing a report, and we hope to move forward with a new project there as well. I forgot to mention for lots 2 and 3, we will be going before the Historic Preservation Board next month for after the fact demolition and certificates of appropriateness for the new design. So that's the current state of these sites. As I noted, we will be, the intent of this approval is to return them to their original platted lot lines. These properties were platted, this whole area was platted in 1920, and that's what we'd like to achieve. This ensures.
What are you saying? You said there's opposition. What is the opposition and the concern by the neighbors?
So the neighbors' concerns, and not to misrepresent them, I'm sure they'll speak to you all today, is the state of the properties. So I have a few photos. These sites were, as I noted, 2 of them were deemed unsafe. They were in very poor condition. I'm sure some of you have driven on Dade Boulevard. These are the sites that are across the Publix.
No, but what is the relevance of that to the lot split?
If I can.
I don't know.
We did forward an email that was sent to all the board members regarding the maintenance of the properties.
Yeah.
And so I just want to include, and I talked to Emily about this previously, we're going to include these 2 conditions in the order, which will state that the applicant shall comply with section 58-299 of the city code entitled Responsibility of Owners of Vacant Buildings, Vacant Structures, and Vacant or Unimproved Lots, just making sure they comply with that code requirement, as well as to comply with chapter 58, article 3, division 4, entitled Abandonment and Vacant Property Registry, which requires.
So it's been languishing and nothing, they don't feel
Right.
it's being maintained.
Right.
Got it, okay.
Yeah, so there is a
So they're
desire
not
for us
opposed to the lot split, they're opposed to the way it's been maintained.
Correct.
Okay,
And
got it, that's
we
what I was trying to
are
understand. Okay.
correct. And on behalf of the trustees that are currently managing the properties, that's what we're trying to achieve, and this is the first step. We applied for after the fact demolition and certificates of appropriateness for the new homes, but through that research, and I'll keep going. We came to this very technical aspect of the zoning code that whenever there's a permitted structure and any improvements that cross property lines, you essentially create a building site. So with all the illegal additions of this site, which I can go through some of the history of photos of all the illegal additions and driveways that crossed and fences that crossed and canopies that crossed, this was essentially created into, although it is 4 folio numbers, 4 addresses, they, per the code, created a 1 building site. And we can't move forward with the certificates of appropriateness until we achieve the lot split we're requesting today. The Back to the context of these sites, as I noted, all the sites range, from exceeding 7,500 to 12,000. Per staff's analysis, the lots in this area range from 7,500 to 16,000, so we're within the context of the neighborhood. The minimum lot size for RS4 is 6,000, which we're exceeding. The current homes in this area have a unit size of approximately 1,000 to 4,400 square feet, anywhere from 15% of the lot area to 59% of the lot area. For the two homes that we'll be moving forward with in December, the proposed unit size are 43% and 50%. We're not proposing to exceed unit size, and actually for one of the homes, we're significantly below the maximum permitted. As I noted, why we're here today is because of this technical requirement of the zoning code. I will quickly go through some of the photos here. Our project architect extensively researched each of the 4 lots and kind of diagrammed out for us some of the illegal additions and where things were added to get us to where we are today. So here's a diagram for lot 1, and you can see what were the additions. The additions for lot 2, which is the middle lot. The additions for lot 3, and here you can see the property lines really get funny in the middle of the site, where there's a boat notch that was not permitted in lot 4. The proposed condition that we passed out as part of our certificate of appropriateness, we're proposing to reconstruct, and I say that in quotes, because we really are reimagining these prior contributing buildings, which Jen will show you in a minute. And in order to do that for 1818 Michigan, based on the prior design of the home and what we're proposing, we do need to exceed the lot coverage slightly. And I'll let Jen keep going, but this is what we call the existing. This was what the site looked like before the demolition of lots 2 and 3, and here you can see how the structures and the driveway and everything crossed over the platted lot lines.
Hi, everybody. Jennifer McConney, Studio MCG Architecture, 7500 Northeast 4th Court in Miami. Keep going through, and I'll make it short because I know everybody wants to go home. Okay. This is what the lot looks like today. There's some drone shots after the demolition. Yeah. This is on the top is what the contributing home on 1800, which is the corner house, looked like back, I think, in the 40s or 50s. It was built in the 20s, and it's been, very modified over the past years. The previous owner found some windows and then just blocked up whatever the windows didn't fit anyone else. So all the windows are different sizes than they were originally. It's a mess. This is a home that's on the triangular lot, which is lot 4. This house was demolished several years ago. And then this is the proposed site plan. So let's go. Here's 1818 Michigan was designed actually by Schultz and Weaver, same architect as the Biltmore, the Freedom Tower, the First Roney Palace. Really interesting. It was actually a sales center, believe it or not, for an apartment building in Miami Beach that was never built. So it's really interesting. And we're proposing to reconstruct that residence at a higher height. So right now it's at about 6 NGBD.
I love how beautifully you make that waterway look.
Yeah. Well, those are postcards from the 20s.
Oh, so, really?
Yeah.
Wow.
I like the gondolas personally.
But, but it's a really cool. I mean, to not reconstruct that building, it would be. And we all stared at that for years when we were sitting on the corner of in front of Publix, looking at that corner and wondering what that was. It's gone now, but to build it back, I mean, the seawall needs to be, at 7 NGBD. That seawall is shown there is probably at 2 or 3, so it's going to be significantly higher. These are images, these are older images from the 20s of that building and 1818. And then we're proposing to build reconstruct the building back with steps in the front and a retaining wall, so the building will actually look very similar to what it did previously, because we've just raised the elevation. And we're proposing to put back those decorative walls along the waterway and the trellises, and really to screen, that's a very, well-traveled roadway, Dade Boulevard. So that additional pool house building that we're building, which was not original, but it kind of does help with the screening of that lot from their pool. Nobody wants a pool deck looking at Dade Boulevard.
That's on the 7,000 square lot, right? That's on the one of the
That
smaller
one
ones, right?
is 12,000
So that's the
square
biggest
lot.
one,
Yeah,
okay.
this is the biggest, well,
Okay.
the second biggest lot. The biggest lot is the vacant one on the west side. So we would be reconstructing what existed previously, 1920s, and bring that up. This is what we're proposing. And this is the facade. I won't be much longer. This is the facade, the front facade of 1818, again reconstructed, just at a higher elevation. 1810. The earliest photo we have is on the top right. What we did, and you can see on the bottom left what it looked like a year ago, and it was, I mean, you would never know that that's what was there previously. They had added several additions over time. So what we're proposing is a new building with that kind of three-layered facade that you see in the original photo, and setting the main building back like it sat in the 30s. Now, so this would be the proposed plan. Again, it meets all the setbacks and lot coverage. And this one, we would put a garage in the front instead of having all that surface parking that was there originally, single-family home. And then again, it's a similar massing to what it was in 1930s. And this is a view from an aerial view from Dade Boulevard to what that would look like. And I'll leave it here. So if you have any, again, we would be putting the lots back to where they were
Can we
originally
change the
platted.
boats to the gondolas?
Would love to.
Those are really cool.
Yeah, very
Michael,
cool.
city staff have any issue with the proposed
No,
homes?
we're accepting
All right.
of the
Okay.
changes.
Yeah, with that, we'll conclude our presentation.
Anybody else, are you here for this, sir? Yes. Sorry?
And Mr. Chairman, before the public speaks, do we have any disclosures on this application?
Any disclosures? No? Okay.
Okay.
Through the chair, we'll just reserve time for rebuttal if needed.
Sure.
Okay, my name is Paul Freeman. I live at 1776 Michigan Avenue, across the street from this property. And I'm here hopefully after listening all day to what the chairman said, to balance success with quality of life. So we have no problem with the success. We have problem with quality of life. And the only problem I have with the photos that were done, and I passed the one out, is that what they don't show is the wood slatted, the lack of maintenance on the property, the houses that were there. In fact, the neighborhood was designated historic primarily because of the one house in 1999. The one house that had the gondola is the most historic home that was in the entire neighborhood, and that was demolished for neglect, not for any other reason. I don't have a problem with them rebuilding. I don't have a problem with any of the plans. I don't have a problem with the rebuilding to code at 10 feet or 8 feet, whatever they're gonna do. I think that the house that they're not gonna demolish should be demolished, because I don't know how you build at 10 feet with the house that's there at 6 feet, because that's a problem. But what I do have a problem, and we do development. So I've done a lot of platting in my life. We do it, I'm in for 3 plats right now in different localities, not here. I've never done a plat where we haven't had to bond and guarantee all of the improvements that you're supposed to do. In this case, there's a seawall that that goes across 3 of the lots, that if you divide this and you did a replat without requiring bonding of that seawall, then that's going to be a problem. We could never do that. We also could never get a permit to do any of what they want to do with having a house that looks like that in disrepair. I had a property on Northwest 7th Avenue that had a 40-year certification needed that we were knocking down, was vacant. I had to cut off electric, I had to fence it, I had to do all sorts of things in order, waiting for the demolition order because it was going to be a gas station. And it was a one-story unoccupied building. So our problem is, number one, I think they're going to put the fencing in. We would like to see you put requirements in there. Number one, for bonding the seawall, which is the only real improvement, and number two, for maintaining the property. One of the pictures shows when they had to put the fence, they put the green stuff over it, and the homeless people and the vagrants come in. They did that,
Right,
and the
let me interrupt
picture
you and
that
say,
was there.
I think you addressed that by the conditions you're.
Right, so
referring,
there's a
Well,
section
what-
of the code.
No, one thing, I understand the conditions. The one picture that I had there, which showed the green up, which was homeless people undoing it, that has been like that for a month. So the conditions don't, all they gotta do is send somebody 3 times a week to make sure that what's there isn't there, that there's no vagrants. And I talked to, we talked with Debbie Tackett just before the meeting about getting that wood slatted area knocked down, which I think they will do if the owner will require. I would like you to maybe require that. But from the standpoint of putting the lots back to
Right,
where they were,
I
we
get
don't
it.
have a problem.
Yeah, so, what about the seawall? What's the?
Well, they're going to have to, since it's new construction, each of the properties will have to, when they come in for building permit, will have to construct the seawall to the minimum required, which is like 7 point.
All right, so the city will ensure that before they're allowed, okay.
It'll have to be done as part of their building
The
permit.
seawall right now, my understanding is that there's a code violation issued on the seawall. The problem we had, part of it was sold, but one of the houses was sold, and now there's a dispute over where the leak is in the seawall that causes flooding during the king tides. So that wall, if you require bonding and require the seawall to be done as part of the subdivision improvements, then you don't have 3 owners then going back for 3 separate permits from the Corps of Engineers, from Durham, from whatever,
No,
to
I
then not
understand
do
what you're
it.
saying. I don't
So-
know if we can, Michael?
I think they're talking about it right now.
Yeah, I don't know that we can require that as part of the lot split, but.
It's just, I mean, it would
Yeah, I
be a
think-
standard
so
for
I think-
replan.
No,
It would
your
be a
points are well
standard for
taken.
anywhere we do
It's a matter
business.
of mechanically executing, but let me hear what
I
David
think what
said.
we could do is require that the seawall be reconstructed to comply with the code requirements prior to the issuance of a building permit for any of the.
The
four
entire
homes.
seawall.
Yeah.
I have a lot of information on the seawall, because we got brought in, our firm, at the beginning of 2024, may have been the very end of 2023.
Right.
This thing was a mess, and I understand Paul's concerns and the other neighbors I've spoken to. We have really tried to expedite as much as we can here. Seawall, we immediately recommended they hire a seawall contractor and engineers. They hired Ocean Consulting, they're great. Kirk Lofgren, we've worked with for years. They immediately applied to Durham FDEP, Army Corps of Engineers.
For the whole part, because what
For
he's
for
suggesting
everything
is
they
that.
own.
Right, but one parcel was sold?
So there's a parcel that we don't own, that we never owned. It's just a neighbor adjacent to us. They're based in Ohio. I've heard about them. They don't want to do the level of work that we're doing. What we've proposed to do, what our consultant has supplied for, and this permit is imminent. Durham's already approved it. The state's already approved it. Army Corps, I think, has approved it. It's now at the city. I've spoken to the city engineer as recently as last week to help expedite. They told us from day one it's about a year, the seawall, because of all the different jurisdictions, different agencies. So we're rounding third and hopefully getting that permit soon. My suspicion is either very end of this year or the very beginning of 2025, that
All
seawall
right, so
construction
the
will start.
seawall that's owned by you all, or that's.
It's our responsibility for
Okay.
all the properties that
And-
we own.
And you're going to.
We're
bond
way
and
ahead of
fortify-
the other
okay,
neighbor.
All right,
No,
so the other parcel, I don't know.
I agree with it. It's a year for permitting process, and the Corps of Engineers is not easy.
Right.
We've gotten
Right,
permits
but
from them.
based on what you just
But-
heard-
But the one thing that he said, that they have gotten involved at a certain point, and I love their law firm. They're really good. But one of the misstatements is Michigan Avenue goes and dead ends at the canal. They own the properties to the west of Michigan Avenue.
Okay.
There's one property where Michigan Avenue ends and to the east, there's a property on a canal there. They did own that. That was sold now, and like a year and a half ago or a year ago. And now there's a question of, well, no, the leak is coming from that property. The guy lives in Ohio, but they never did it before they
No, I
they
know, but
sold
now
it
that they
off.
don't own it, I don't know what really we can,
Well, they can't, but we can hopefully make sure that they don't do that to the rest of the properties.
got it.
So,
Okay.
so I apologize.
That's fair.
I was corrected by Emily. They did own it. It was before we got involved, so I wasn't
Right.
even aware they
Right.
owned it. But I know that those neighbors, we tried to reach out. They're based in Ohio. They're trying to just kind of patch it, not really with a permit. So when I spoke to our consultants, I said, hey, some of the neighbors suggested that we patch it. Can you do that? They said what they did with the neighboring property is a violation. We are so close to getting this permit for the really full seawall replacement that if we get hit with a violation by Durham, it's going to delay the issuance of the permit.
Right.
So we were
Okay.
advised by the consultant not to patch,
All
even
right.
though it's cheap and easy, not to do it.
Right, so you're gonna
So
make
we're-
sure that your property is compliant with his concerns?
Absolutely, yeah.
Okay.
The seawall is
All right.
very close.
Can we make that an additional requirement? I mean, it
Yeah,
says
so
he's
you-
doing it
so
anyway.
I think you want to say that the permit for the seawall is issued prior to the issuance of a building permit for any of the homes?
Is that,
Yeah, because the seawall permit's
Okay.
going to be issued very soon, so I'm
Let's
okay with
do
that
that.
condition. No, yeah.
okay.
Yeah. And I believe, is there anybody on Zoom, Michael? Because
There's nobody on Zoom. with their hand
So
raised.
just to be, because he did send you guys an email, we were in touch with a gentleman named John Courtney, who was his neighbor, very nice guy. He's got 2 young kids. He's very concerned about what's going on there. I would be too. He had some conditions. I think Michael formulated those in a way that makes more sense. But these are essentially the vacant property standards that the code requires.
Right.
And we're in the process of complying with that.
Okay.
The fence is being constructed, as Emily said, the shrubs have been ordered, so demo's been done. We can't close that permit out until we get those other things.
Got
done.
it. All right.
That addresses the fence that he was talking about,
The fence
with
and the
covering.
landscaping.
Okay.
Go together, yep.
We would like, yeah, I mean, the only thing that we would like is that they at least try and get that wood slat, which is temporary, it really is, it's eyesore.
Which,
Removed, and it's in disrepair. I mean, you can see from the picture.
Well, I'm assuming
there's
you're gonna have to
boards
do
there
that at
laying
some
up.
point,
well,
right?
as part of our analysis, the structural analysis, and Jen reviewing the historic of that 1800 Michigan, the one structure that's remaining, we haven't had the opportunity to, basically what Mr. Friedman's asking for is removing the parts that are illegal additions that are in disrepair because it's so intertwined with the contributing aspects of the building. We can't just go in there and get piecemeal permits, but we met with Debbie Tackett this morning and she's willing to work with us to, before we go get
All
that
right.
certificate of appropriateness, to figure out which portions of the structure we can either demolish.
And you're saying there's a
or-
lot of homeless that are going and sleeping there? Is that, did I hear you
Part of the
correctly?
concern.
They have electric on in the house, so there's air conditioning. If you're homeless and you want a place that's air conditioned, it's hot in Florida, you go there.
All
The
right, well,
problem is, there's alarms, but.
all
they've
right.
sent people,
You know,
it's a
all I'm
mess.
trying to say is be a good neighbor, and if
Yeah.
if a bunch of, I don't know, what to call it, homeless, whatever, and they're there and they're disrupting, maybe it's your private property that maybe you try to do something about that. All right. Sir, I appreciate you coming. All of your comments are very constructive. Thank you. Any questions from the board or someone want to move it?
So moved with the modification.
Okay, can I get a second?
I'll second it.
All right. Anyone opposed to that? All in favor? Okay, great. Thank you. Thank you all.
And another point, I mean, when we have more time, maybe consider recommending to the commission that before applying for a lot split or something like this, that the property has to be up to date on all, the maintenance and code violations.
We have had cases before, for example, before the DRB or HPB, where the board sees the state of the property and says, we're going to continue your application, require them to clean the property up, and then come back to the board before the approval is issued. They are
You
scheduled
didn't
to
give
go.
us that option. No, just kidding.
But they are scheduled to go before the Historic Preservation Board next month.
All right, next is 17, Planning Board 240723, FAR exception for gender-neutral bathrooms. Very important.
This should be relatively quick. This ordinance would create an FAR exception for gender-neutral bathrooms. Now, these gender-neutral bathrooms would have several benefits, including creating a safe and accessible environment for all people. This includes accommodating people with special needs, families with small children, elderly individuals with a caregiver, as well as transgender and gender nonconforming individuals. Accepting such areas from FAR will allow that square footage to be constructed somewhere else on the site. We're recommending the planning board transmit this to the city commission with a favorable recommendation. This also allows more equitable bathrooms. So you typically would have, say, a common area for hand washing, and you would have like stalls that anybody can use. So you'd have a common area for washing your hands, and then anybody can go and use the restroom. It's not specific, so you're not going to have like a line outside of the women's restroom when the men's restroom is empty. So
I never do the line, I always skip and go right straight for the men's bathroom.
I do too. I do too. I have a question. So how much FAR are we talking here?
it's not much. No one's going to build more square footage than what the code requires for a bathroom.
You could have 20, a whole floor of them if you wanted. I mean, come on.
There'd be no reason for doing that because,
I'm just asking the question. I don't have
It's
I
gonna
don't
be
have
pro-
a problem with it. I'm
it's
just
going to be
asking how many
proportional
we're
to
gonna have.
the size of the.
Is there anyone on Zoom?
There's nobody on Zoom.
All right, nobody in here
All
on
right,
this, okay.
I'll move it.
All right.
I'll second it, and I want to, there were some grumblings when it got brought up, and I just want to point out how important of an issue this is for many people in our community. May not be for all of us, but for many in terms of making our community a more inclusive and welcoming space. So I do commend Commissioner Fernandez for bringing this forward.
And
so
Commissioner
second.
Magazine as well.
Agree. Okay, so we have a motion by Jonathan? Sorry?
I
Elizabeth?
moved it.
Oh, you seconded it? Okay, all in favor?
Aye.
Anyone opposed? Great. Okay, let's see, 18, Planning Board File 240724, Hotel Approval Process, an ordinance.
Just find this application.
Commission approving all new hotels. Giselle, Michael, who's presenting?
Oh, me, I got it. Just had to find the staff report. So again, this is PB 24-0724. This is a new hotel approval process. Currently, any hotel development consisting of ground-up construction or additions to existing structures requires a review and approval of either the Design Review Board or the Historic Preservation Board. Some cases, such application may also come to the Planning Board for review. The attached proposed ordinance would establish a city commission warrant process for future hotel approvals. This would require that any application for a hotel use be reviewed by the city commission prior to the review of any land use board application, which include DRB, HPB, or planning board. Now, there is an exception for hotel developments on oceanfront parcels. They'd be exempt from this process. The ordinance, which begins after the staff report, includes the criteria which would be part of the commission warrant. So one of the things that the commission is reviewing is the impact on how existing housing and existing affordable housing or workforce housing units. Basically, the commission wants to make a stronger effort and a more active effort in reviewing impacts of hotel units on the surrounding neighborhood and wants to take a first step in that review process.
But Michael, I have a question. So if the property that the proposed hotel wants to go on is zoned for hotel, I don't understand that interplay. Like if they're allowed to do it, what is the commission?
Well, so it's almost like right now where, in some cases, an NIE is a conditional use permit. So it's allowed, but it requires, the commissioner in the existing case, the planning board can place conditions.
No,
on
I
approval.
get that,
So
but
this
if
would
the
allow-
concern is replacing residential housing, I don't see how that accomplishes that if it's still a matter of right and all they're doing is conditioning it.
I mean, maybe there's conditions that the commission can place on the
It'll make them
establishment.
not want to do it.
I mean, we already did remove, for example, we removed the FAR bonus for hotels in commercial districts, pretty
All
much
right.
citywide, so.
Okay, so it's maybe creating disincentives to actually do the hotel in lieu of residential.
There are disincentives. This would make the process longer and probably more expensive, and
Okay.
so that's one thing we did note in our staff report. We don't have an objection to it, but it would, make the process longer and probably add another layer and time and more expense.
roadblocks, okay. It's an indirect way of trying to encourage more residential.
And there's also, there's a wide range, so you're looking at, you could have a small hotel operator that's only doing, say, 20 units versus, 150 hotel units. That's a much bigger, a much different impact.
Right.
Right now, there's an exemption for oceanfront properties. I don't know if the planning board wants to consider other exemptions, or if they're okay, if the planning board is collectively okay with this warrant process citywide for hotel units.
And the effective date would be once it's approved, 10 days later.
Well, so this would go into effect with a favorable recommendation by the planning board. This would become effective.
Right.
Zoning
Oh.
in progress. Zoning in progress.
Oh, okay, all right.
Mr.
Anyone
Chairman,
else?
to a point you raised,
Yeah.
this effectively would make hotels not as of right, except on the ocean front. Because if a public hearing before the city commission is required to approve the use, it would not be as of right
It wouldn't
anymore.
be as of, well, it'd be as of right, but it'd be subject
It's
to
almost like a
conditions.
condition-
Right,
yeah,
I get
it's
it.
almost like a
Okay.
conditional
I
use,
get it,
yeah.
it makes sense. Is there anyone on Zoom?
There's no one on Zoom with their hand raised?
Okay, any questions or comments?
Just a quick question, would the commission be able to, just be outright, it's approved or not approved, or could they put conditions on it?
That's what it is, conditions.
It's a condition,
Correct.
okay.
So would it go through the same, it would go through similar, but not the
Yeah,
same criteria?
there would be, it'd be a different
we do.
criteria that's set, it's in the ordinance. And it'd be the same noticing requirements that the planning board and the land use board would be mailing all the affected property owners within a certain radius. And there'd be a hearing at the city commission.
So is,
Go ahead.
okay, the intent, I believe, is conversions of existing residential stock, right? That's
That's
what.
part of the impact. Look at the impacts of that conversion.
Yeah, like an actual building that people are living in
Right.
to prevent that.
Correct.
I'm not gonna propose this, but I'm just concerned about vacant land and then removing that by right ability to, if it's zoned for it today, right? To develop a hotel, if that's what the property owner intends to do. But, other than that, it's just a concern. I wouldn't propose that we make any recommendations unless someone else shares similar.
No, I
feel.
agree.
So in other words, if let's say, item 4 in criteria, whether adequate off-street parking and loading spaces will be provided, maybe an applicant goes in front of the commission and says, I'm only providing 1 loading space. Commission could say, no, you really need 3, and we're not going to approve it unless you offer 3. Okay, so they're taking our work from us, that's okay.
Correct.
I mean,
They don't have
it's
enough work.
Yeah, it's another layer, but it's all to disincentivize hotels.
Correct.
Okay.
If they want to do that, yeah.
That's it, exactly. All right, anyone want to move it?
I'll move it
Okay,
Second.
favorably, I assume?
favorably.
Okay.
Second.
Anyone opposed?
I'm sorry, who was the second on that?
Jonathan.
Anyone opposed? No? All in favor? Okay. All right, last but not least, Planning Board File 240726, Visibility Triangle Requirements, Oceanfront Property.
So included in our staff report is language that the city commission is considering for the specifics of visibility triangles on oceanfront properties. This would entail establishing a triangle dimension, mostly for safety, so that when somebody's accessing the beach walk from, say, private property, there's visibility to anybody walking, running, jogging along the beach walk. So that ordinance is already before the city commission. What this ordinance that the planning board is reviewing is just a reference to that code section. So as that code section is modifying the city code in general, the planning board only has to opine on amendments to the land development regulations. So just to make sure this is not overlooked, we're referencing in the LDRs to the city code section that references the specifics. So, just so, for informational purposes, I did provide a graphic that shows the triangle, and this is towards the end of the board packages. And when this was reviewed by the land use committee, they recommended that we have different triangles depending on the size of the property. So you'd have a larger visibility triangle for a property over 100 feet in width versus one that was less. Now, the diagrams were developed before that proposal, so they both reference a property that's over 100 feet in width. But basically, if the property is less than 100 feet in width, they'd only be required to provide a 6-foot triangle with no landscaping or structures within an area versus over 100 feet, there'd be a 10-foot visibility triangle requirement. This would apply to existing and, prior landscaping or any installed landscaping and future landscaping. So once this becomes effective, the property owners that don't meet this requirement would have to modify their landscaping to comply with this requirement.
Michael, question. Please walk me through why the visibility triangle, the intent, how or why it would be less just based upon the property
Because
lines.
it's taking more, you're taking more of the area of the property away from the property owner, since they're proportionally having to modify more of their property if they have a smaller property versus a larger property.
Okay.
You're taking the property?
Not taking the property, but we're requiring modifications or requiring this visibility.
They can't put shrubbery in.
They
the
can't put
area.
shrubbery if they have shrubs there now, they have to cut it back.
So why
Like,
would
there's
we?
lots of properties that have, like, you've probably seen it where there's clusia or hedges.
We have that.
Right.
Yeah.
So you guys are 6 feet tall. I'm not, like, by a long shot. Why would we not want it to be a little bit more so that you could have more visibility?
It's horizontal, not vertical.
No, horizontal.
Yeah.
So why would we not want, I'm just using y'all, if I laid you flat.
We looked
If I laid
at,
you
Knocked us
flat.
over?
Exactly. If I
we
laid
looked
y'all
at,
flat,
we looked
why-
at 6 foot, 10 foot, and actually 25-foot options.
Okay.
And so the land use committee recommended this varied 6 foot and 10 foot.
What if we did 8 and 12?
But this is not like a traffic runway, it's people walking on.
Right.
foot.
Right.
Like it's, let's contain this on how much safety we need here, right?
Well, I
And
think
at
a
the end
lot
of
on the
day,
beach
there's also-
walk.
there's also what
Melissa,
else
your
to
mic's off.
Oh, sorry, you have the property as well that, that has, to Michael's point, there's a limited amount of greens you want to take away. They need the barriers too and the protection and all that stuff. But I think that, unless we can pinpoint a real problem, why we'd have to take much more. I think that's a pretty good safeguard at 6 feet.
6 feet? I'm just saying that we have problems now, like you were saying with the Calusa. It's, if I laid, no, you're too tall. You, Matthew, if I laid you flat, I mean, what if, if you're at an angle like this and I'm short,
Do you wanna
Melissa,
do you wanna-
you're kind of tall, but,
No,
but if 2 feet's really nothing. It's like, what do you think?
Well, it's 0 feet right now, and there are
Right.
many examples of 0 foot, visibility. So this is certainly an improvement. I think the reason why they moved it down is because there were some concerns from some of the property owners, right?
Is that?
I believe so,
is
just
that
in terms
right?
of the size, right. I mean,
Okay.
Wouldn't
Okay,
it make-
that's the first I've heard of it, so I'm just trying to.
Yeah.
Wouldn't it make-
I err on the side of more safety than less.
Yeah, no, and I get it, if there was some
Yeah.
traffic involved, at this point, I just think though, since you got people walking and yes, potentially bikes too, I get that, but
No, it's a good-
I run the boardwalk on a regular base, and there's areas where we don't have that, and it's, like I
Okay.
said, it's a pretty contained danger, but it's good and preventive.
I like it. I'm just,
It's a good idea, no, for safety. When you walk out, you just want to see if somebody's hanging out there or if someone coming by on a bike really fast.
I'm fine with it.
But I just, one
Always like
thing that
more
I'm
safety.
thinking of now is, wouldn't it make sense, instead of basing the size of the triangle on the lot width, which I understand the reasoning, but what happens if you have a property and the actual gate is maybe set back like 6 feet behind the hedge line, which you do see on some properties.
we have that.
And then it's 6 feet, and then it does a little bit, but not much. Or you could have a gate setback even further, even, let's say, and,
this doesn't modify the location of the gates, because right now the gates have to have visibility through. So Anybody that has a solid gate along the beach walk, that's something that was not approved. The code requires, you know, a transparent visibility through it, through any sort of gate along the beach walk.
Yeah, I'm not saying to move the gate, I'm just saying it just makes sense to, or maybe govern how big the triangle is by how far back the gate is
Well, right
set.
now you
But-
can't-
But this is an improvement anyway, so.
Right, you
I mean,
can't, so I think the gates have to swing out, so basically, they have to swing out, but they can't swing out into the beach walk. So if somebody has an access point directly on the beach walk, their fence has to be set back to allow the gate to outswing and not impact somebody.
Some of them are set back more than just maybe the width of a gate, like 3 feet. Some are set back 8 feet maybe. And, you know, if you walk up and down, you'll see some are like that. Not a lot of them, but you do see some.
Yeah, and this sometimes is because the beach walk varies and it's curved, so in some instances, somebody can't place the gate closer because that is now on city property or state property, so they have to keep the gate at the property line.
I'm just misunderstanding, just help me, so if you have the gate set back there and the beach walk is here, right? And you're saying if the gate is further back?
Yeah, let's say the gate's further back,
Right.
and let's say you're only having a 6-foot triangle.
Right.
Does one leg of the triangle start at the gate, or does it start at?
It's independent because the gate doesn't cause violation with the triangle because the gate is, you're visible through it. It's the landscaping or other structures that are solid. So they're into the location of the gate is independent of the triangle.
Wouldn't you, if you're coming out of the gate, like, does it really matter how set back it is? You're walking down before you.
Yeah, again, I'm not
No, and
questioning
trying to-
this at all.
No, I'm just trying to
It's overall-
understand, so the concern is what, I'm just trying to understand, so if you're,
guess
the gate is set back more, you're walking out, you're gonna still make a pause before you
Of course.
engage into, from.
So if you look at,
yeah,
if you look at the
for you.
diagram, just to point out, so if you look at the diagram on the pages provided, if you look at the bottom of the page, you can see how the property line is the dark line, and then you have the beach walk. And so in one case, you see how there's some the walkway extends out from the property line into the beach walk. So in that case, that property owner cannot place their gate closer than the property line. So in that case, when their gate's at the property line, there's gonna be, room for someone to traverse between the gate and the beach walk. Whereas if it's in the middle of the page, where the property line is at the intersection of the beach walk, they're gonna have to set their gate back because the gate's swinging out. So it's gonna depend on that specific site condition.
No, look, again, I'm not questioning this, it's all good. As long as there's more visibility when you're walking out.
And, you know, this is something that, I'm sure that, once it's started, it's something can be revisited in the future, and maybe it'll be expanded upon if needed.
All right, can we move it, let's move it, as in favor? Or is that what we're doing here?
Yep.
Yeah,
Give
I'll
me a
second
second.
favor? I'll second, all right.
All right. Anyone opposed? All in favor? Okay, passes. All right, guys, happy
Happy
Thanksgiving.
Thanksgiving.
Yeah,
We'll see you, in the new year, January 7th.
January 7th.
Happy Thanksgiving.
It'll be 2025.